Taking your seats, we'll just go over a couple. Perfect. All right, we want to welcome everybody back again. Glad to see some of our seats filled. I thought about having the hotel eliminate the far on each side tables to force you into the middle, but it would have cost me more money. So you guys get to sit on the fringes again, but we're glad to have you here. So just a reminder, at noon today, we will be starting to take votes for the juvenile prosecutor board member for SWAP. There's Ryan's email address. Again, if you need that, so please send your nominations and or volunteer to serve on the SWAP board as a juvenile prosecutor. You do need to have some juvenile experience. Course evaluations, I'm going to repeat this again one more time a little bit later this morning, but please do not wait 2 years to complete your evaluation. It's a pain in the butt for us to open it up and have to redo your CLE. We will close the course evaluation and send in the CLE to the bar by June 15th. And there's our contact information. Okay. I will leave that up there in case you need to write it down while I introduce our two speakers for this morning. We know John, but we don't know David Simpson. And so I asked for, David was kind enough and sent me a bio, so I had to ask John one as well. John's presented for us. So we'll start with John. We know John. John is an assistant solicitor general in the criminal appeals division. After graduating from BYU Law School, he worked for 4 years as a deputy Utah County attorney before joining the Attorney General's office, where he has been for almost 10 years. Can you believe that? Yeah, he's an adjunct professor at the S.J. Quinney Law School, where he teaches appellate practice, and he also teaches evidence and legal writing at Ensign College. David Simpson, we're looking forward to hearing from David. David currently serves as an assistant solicitor general in the criminal appeals division at the Attorney General's office, received his bachelor's from Stanford University and his JD from Stanford Law School. Before moving to Utah, he served as a law clerk to Judge Michael S. Caney, thank you, of the U.S. Court of Appeals for the Seventh Circuit, and litigated criminal appeals for the Illinois Attorney General's office and the Arizona Attorney General's office. He's also an adjunct professor for the Loyola University Chicago School of Law and has taught courses on evidence, criminal law, and criminal procedure for Arizona State University School of Criminology and Criminal Justice. So with that, we will turn the time over to them. Oh, one other thing. If you're looking at the printed agenda, I'm not sure, well, there were reasons, apparently not very good reasons. We were going to go until 1:30 before we broke for lunch, but we're actually going to stop at noon. Those here in the room, we will give you about 15 minutes or so. Go grab your food, come back in, and then John and David will finish up. So that will be a slight change to the printed agenda. With that, I'll start your timer. You guys are good to go. Thanks.
All right, good to see everybody. Good to see anybody. I've done a few trainings during the pandemic, and most of them have been from my basement, staring at my shared PowerPoint on my computer and just speaking into the abyss, especially when I make some, I would say awesome joke, my wife would say lame joke. It's hard to gauge the room and see if anybody's really engaged. So great to see at least some people here, and hopefully we'll have the normal crowd back by next year. I survived the end of the world, right? And all I got was this lousy t-shirt. So let's get started. We'll start with Lopez and Nielsen. I'm sure you saw these cases come across. These are two important cases on when the defense can, and most importantly, when they cannot, subpoena victims to testify at prelims. Question in this case, when can a defendant subpoena a victim to testify at a prelim? The bottom line answer is when the victim's testimony is reasonably likely to affect the probable cause determination, which is, given the burden, the very low burden, and all of the presumptions in the state's favor, it's going to be a very rare occasion indeed. And thank goodness, because that was the whole point of the 1994 amendments that we'll talk about in just a minute. So a high bar. We really liked these cases because the court adopted precisely the rule we asked them to. So sometimes you get what you ask for. The facts aren't super important in these cases. Suffice it to say that both Lopez and Nielsen were charged with sex crimes against children. Lopez against a 12-year-old that he got drunk, and Nielsen, his young daughter. Each of the kids, of course, did their CJC interview, and the prosecutors were going to use those at preliminary hearing. So like you do, the prosecutors asked the court to admit the CJC interviews at prelim under both 1102 as reliable hearsay and all of the procedures in Criminal Procedure Rule 15.5. I'm not going to delve into 15.5 for the sex crimes. Prosecutors in the audience, you're very familiar with it, and it's not super important to the holding here. This is more about prelims at large. But focusing on 1102 here, we have this general rule, right? That reliable hearsay, even if it's written down and attested to, is admissible at preliminary hearing to make this probable cause determination. So the question here is that sub 7, a statement made by a child victim of physical or sexual abuse, which is recorded in accordance with 15.5. So there's an exception under Rule 1102 here, sub 2. They can require live testimony if they establish that it would be so substantially and unfairly disadvantaged by the use of hearsay evidence as to outweigh the interests of the declarant and the efficient administration of justice. So really general language, right? It's not super surprising that we had lower courts, district courts, going both ways on this, magistrates, I guess, technically, right? So defense counsel argued that just about every case meets the exception, right? Saying that they have the right to subpoena and cross-examine the victims at prelim, both under Criminal Procedure Rule 7b and under the compulsory process clause of the state constitution. So we can just take a look at those really quickly. Under Rule 7, the defendant may testify under oath, call witnesses, and present evidence at a prelim, and may also cross-examine adverse witnesses. And there's the money language from the Utah Constitution. They have the right to compulsory process to compel the attendance of witnesses in the accused's own behalf. So this was the basis on which they were arguing, hey, we should be able to call in these victims whenever we feel like it, essentially, because we have these general rights. One more important part of Article 1, Section 12. This was part of some of the victims' rights amendments back in 1995. So at the time there was this case, it was State v. Anderson, and the Utah Supreme Court in that case said, prelims aren't just about probable cause. They're about discovery. They're about the defense being able to build up their case, and they have these broad purposes for preliminary hearing. And they said that defendants had a state constitutional right to cross-examine at preliminary hearings. In response to that decision, victims, advocates, and prosecutors went to the legislature, and we got a bunch of amendments passed to the state constitution, primarily this one, basically saying, look, we don't want to force victims, especially child victims in sex offense cases, to have to go up perhaps weeks after the occurrence and go through the trauma of testifying. They're going to have to do that at trial anyway. Why keep subjecting them to this, to have to keep reliving this abuse, right? So these were passed in 1995. And again, the legislature decided we don't want to put victims through that as a rule, so we have this amendment, which is what gave rise to Rule 1102. One more, there's a whole lot of rules in this case. I promise it'll come together, okay? So back to the cases here, Lopez and Nielsen. Both Lopez and Nielsen each subpoenaed their respective victims to testify at their preliminary hearing. And the state, in each case, moved to quash those subpoenas under Rule 14A, where it says, very general language, the court may quash or modify a subpoena if compliance would be unreasonable. I have a picture of squash because I couldn't find a good picture of quash, but it's close enough, right? So how do these things come out? Again, unsurprisingly, given the general language of all the rules at play here, we had courts going both ways. In Lopez, the defense position was, I don't have to explain why I want to call the victim. I'm, quote, entitled to find out some more of the details as part of the discovery function of prelim. So this is very much like Anderson. This attorney was still living in 1994 and thinking that, this is what prelims are about. The magistrate there denied the victim's motion to quash. There it was the victim rather than the state. And said, well, the victim has a mature demeanor and almost no one's going to be here anyway. I mean, who's had a crowd for their prelims before? Maybe once in your career? Like, they're not super exciting events most of the time, at least well-attended events. So the magistrate was thinking, well, nobody's going to be here, and I understand that they're not going to be able to defeat probable cause in all likelihood, but if the defendants couldn't subpoena the victims, then why do we have this right to process under the state constitution? That would be an illusory right. He said, by the way, we'll stick the defendant in a holding cell while this all goes on. So this shouldn't be traumatic for the victim at all. Not perhaps underestimating the trauma of merely recounting exactly what happened, right? So that's what happened in Lopez Nielsen, the opposite result. The defendant's position there was, look, there's nothing in the rules of the Constitution that lets a victim's avoid process. So I have a right to, quote, test the state's evidence against somebody living back in 1994. There, the magistrate granted the motion to quash and says, look, the Constitution says that the state can use reliable hearsay, period, and the confrontation under State v. Timmerman confrontation right doesn't exist at prelim, so you can't call the victim. So we get this up before the Utah Supreme Court, and we actually had another case up there about a year ago, or year and a half ago, but there were some procedural quirks that the court had to dismiss the case. But these cases finally had the issue teed up, and this time, again, we got the rule that we wanted. This was Justice Lee writing for the unanimous court. And he acknowledges, look, a defendant does have the right to call witnesses, but not just any witness at any time, right? We have to recognize the limited purposes of the preliminary hearing and what's going on here. And thankfully, the court recognized the trauma that this can visit on victims in many cases. Justice Lee acknowledges, look, we can look at the social science literature, and it shows that this can be a very trying experience for victims, especially children. We don't want to magnify their guilt and shame if we can possibly help it, right? We don't want a rule that does that as a matter of course. So here's the money language. Once the state has used a victim's reliable hearsay to make a prima facie showing of probable cause, a subpoena compelling the victim to give additional live testimony will survive a motion to quash only if the defendant demonstrates that the subpoena is necessary to the presentation of specific evidence that is reasonably likely to defeat the showing of probable cause. So that's a really high burden, right? Notice the need for specific evidence. It just doesn't cut it for defense counsel to stand up and say, well, maybe she'll deny it. Maybe she'll deny that it happened, and that would defeat probable cause. Even though it wouldn't, right? Because victims recant and we're still even able to get jury verdicts. So you would really need some compelling evidence as a defense attorney, specific evidence, to be able to haul the victim in there and get them. And in all likelihood, you wouldn't really have to haul them. If they're going to give helpful, favorable testimony, presumably the victim has recanted and really wants to go and testify anyway, right? It can't just change the mix a little bit. The results in these particular cases are kind of an afterthought. Basically, the defendants in neither case proffered what specific evidence that would defeat the showing of probable cause. So the court said, the victim has to testify in neither case. So just to sum up, in practice, this is basically a three-step process, assuming that you have the rare case in which a victim can be compelled to come in. It starts just like any normal prelim. You put on your case, whether it's on paper or maybe you have a witness on WebEx or whatever's going on right now. The magistrate makes the probable cause ruling, binds over presumably, or deny it. If the magistrate denies bind over, we have a different issue, right? But the magistrate makes the probable cause ruling. Then the defendant has to proffer specific evidence that he thinks the victim's testimony will give and defeat probable cause. And then the magistrate decides if the subpoena is reasonable, if that proffer actually suffices. And notice that the court was careful to say that they can still modify subpoenas under Rule 14. The court still can make accommodations, can say things like, okay, the victim's going to be back in a holding cell while I hear this. We're going to clear the courtroom. Whatever it happens to be in a particular case, the magistrate retains discretion to structure even the live testimony in a way that will reduce the trauma to the victim. So good result for us and good thing to be aware of.
Thank you, John. Thank you, everybody. Before I get started, whenever I give a presentation like this, I always like to also acknowledge that if we're talking about appellate cases, that some of those cases may have been your cases at trial or below. And so when we're talking about these, the point of this is not to sort of point fingers or point blame. I think it's some of the outcomes that we may see that are less favorable to the state. It's not really necessarily even the trial prosecutor's fault that we got the outcome that we got. Sometimes it's just an appellate judge being particularly interested in an issue. So I wanted to mention that and say I kind of think of this as similar to what the FAA does in cases involving airline crashes. You don't look at an airline accident and say, well, we need to go punish the pilots and tell them really, really hard not to crash the plane. You look at it from a systems perspective and try to see what we can do better next time. And so just wanted to begin with that note. So with that in mind, let's take a look at Kamoy versus Ridge. The holding, as far as I see it in this case, is that if you plead guilty in the justice court without reserving the right to appeal, you can still appeal anyway, with almost no consequences, so long as you give up before a new judgment is entered. One of my favorite Grandpa Simpson moments here. I was told, by the way, that if I was going to do this with John, I had to insert lots and lots of Simpsons references, so I'm doing my best. Let me know how I've done. All right, so facts of this case. Kamoy was charged with driving with immeasurable content of controlled substance, possession or use of marijuana, and failure to obey a traffic control device. She moved to suppress blood evidence in the justice court. That motion was denied. And so then she pleaded guilty to one count of impaired driving and was sentenced the same day. So you can see she got a favorable outcome on the plea deal. She did not reserve the right to appeal. And the record, for reasons that are not particularly clear in the Supreme Court's opinion, the Supreme Court says the record is unclear about whether she waived her right to appeal. So with that in mind, she appeals to the district court anyway. She moves to suppress the blood evidence a second time. The motion is again denied. And she then realizes, oh, I regret this decision now. I actually want the deal that I had in the justice court. So she withdrew her appeal and asked to have her original plea deal back. So in an example of sort of everything you need to know about law you learned in kindergarten, the prosecution says, well, no takebacks. We gave you this plea deal, and then you appealed anyway and tried to get rid of the plea deal, so we want to reinstate the original charges. And the prosecution has a statutory hook for that. If an appeal to the district court is of a plea entered pursuant to a negotiation with the prosecutor, the defendant did not reserve the right to appeal as part of the plea negotiation, the negotiation is voided by the appeal. All right, so you'd think that might be simple enough. Things get really complicated quickly. I think this case is a good example of a case in which the Supreme Court is probably right as a textual matter in how they interpret this statute, but it leads to a result that is almost certainly not what the legislature intended. So, what the Court of Appeals says, the Supreme Court says is, well, Kamoy's appeal voided the negotiation between the parties in the Justice Court, but not the resulting judgment. So the state would not be bound by the plea agreement in any trial de novo in the district court because the appeal had voided the plea negotiation, but the Justice Court's original judgment would remain in place unless and until the district court entered a new judgment. And one of the things the Supreme Court points out is, well, if merely appealing voided the Justice Court's judgment, then you could completely blow up the original disposition, and you'd never be able to get it back again because that judgment is now gone. So as a result, according to the Supreme Court, when Kamoy withdrew her appeal, it simply reinstated the the Justice Court's original judgment. So basically, she could go to the district court, and as long as she withdrew, she could get back what she had already had in the Justice Court. Now, this may lead you to ask a couple of different questions. So, for instance, how is this any different from a Siri plea or a conditional plea? And the court gives an answer to that is maybe not super satisfying. The court says, well, imagine a defendant who's charged with 3 counts and pleads to 1, like in this case. If a defendant appeals after entering a conditional plea or a seri plea, they can take the suppression issue to the district court. If they win, they win. If they lose, they can either again plead guilty to 1 count or seek trial de novo on that 1 count. If a defendant pleads without entering a conditional plea, as in this case, they can take the suppression issue to the district court. However, the prosecutor is no longer bound by the plea agreement because the negotiation has been voided and can reallege all 3 original counts. The defendant can then either proceed to trial in the district court on all 3 counts or can withdraw their appeal and revert back to the justice court's original judgment. Follow-up questions. Well, that still seems pretty similar to a seri plea. Won't defendants just do this to get a seri plea when the state won't offer one? And the Supreme Court says, don't worry about it. This doesn't seem to have been a problem before, back when we didn't know this was even an option. And presumably, most criminal defendants want the finality of a guilty plea or the opportunity to defend their case in a court of record. My considered legal response to this is, really? I think most criminal defendants want the best outcome they can get in any way that they can get it. So it's not entirely clear to me that this is, just because this hasn't been a problem before, back then when we didn't know about it, that this is not going to be a problem now. And particularly given that the approach the court takes seems to allow a defendant to withdraw their appeal very, very late in the game. So you could really wait for the prosecution or the presumably sentencing district judge to show their hand before you decide to back out again. So other questions then. Well, is there anything I can do to stop my defendants from doing this? And the answer is maybe. So there's some dicta in footnote 5 of the opinion where the court says it's quite possible that the prosecutor may require the defendant to waive her right to trial de novo pursuant to the conditional plea. Because this scenario is not before the court, we're not going to consider it. And then in footnote 8, the court raises the possibility of conditioning a guilty plea on an express waiver of the right to de novo appeal. Like I said, this is dicta, so it's possible that if you do that, you could raise additional issues about waiver of the right to appeal, but at least that option is on the table. And if you pursue this option, make sure to get the appeal waiver clearly stated somewhere in the record so that we're aware of it and the court can take account of it.
I know that can be a hard thing to do when you're in justice court, because justice courts are courts that are not of record, right? But as I've seen a few appeals come up from justice court, I've had a couple of misdemeanor cases that I've participated in either as amicus or taking it over from a municipality. And I've noticed that justice court, at least some justice courts, have a decent paper record that they then send up to the district court, rather. So if you are a justice court prosecutor and you're dealing with this sort of thing, get it in writing. And that will put us in a better position to defend the result on appeal. And I think, you never know what's going to happen on appeal, but I think we would have some pretty solid arguments for being able to waive that. Then we'll see how it plays out. But you'd be no worse off than we are right now, right? So it's probably worth a shot if you run into that situation. And the Jason Schatzes of the world or other defense attorneys who are just going to get a plea deal and then just keep fighting in district court forever. Maybe you can avoid that revolving door a little bit. All right, this is one of the most important cases this year. I'm sure most of you have seen it. Maybe you've already started to deal with the fallout from it. State v. Valdez, this is about compelled decryption of electronic devices. Forcing somebody to unlock their cell phone is the most common example, but of course there are examples of flash drives or hard drives or computers or whatever else. Before we get into the case itself, I want to talk about the issue a little bit, just because it is so new, and I think we're likely to see different results under different facts. So I want to give you kind of the 10,000-foot view of what the issues are in this area, and hopefully equip you to think through the issues when we start getting motions and start dealing with this issue in earnest. And if, of course, if you do have any questions on this, if you get a motion, take to the prosecutor listserv and or email me. I've got a lot of briefing on this. I've written a United States Supreme Court amicus brief on it. I've done CLE presentations on it. I have a lot of research on this thing. So hopefully that will be helpful to you. So looking at all these devices, I imagine everyone here uses at least 2 of these things every day, if not every single one of them every single day, right? And yeah, maybe some days you're using every single one of them. And as you know, criminals are just like you in this respect. They store pictures of their, friends and family, their texts and emails to friends, their downloads, their favorite websites, and of course, their online purchases. And as everybody here knows, a criminal case entirely without some form of digital evidence, somebody's texts, somebody's phone calls, somebody's whatever on their computer, is vanishingly rare these days. It might not be the central evidence in the case. Maybe you don't even need it to convict the person in a given instance, or maybe you have it through, maybe the defendant was texting somebody and you have that person's cell phone so you can get the content that the defendant was sending or whatever else. But there's some kind of digital evidence in just about every case these days. Almost invariably, these devices have some sort of encryption on them. So let's talk a little bit about encryption. Cryptography comes from the Greek words for secret writing, basically. So to encrypt something is to make it secret and unreadable. To decrypt it is to reveal the secret. And if you read some of the literature on this, you see these words plain text and ciphertext. That basically just means the thing you can read after it's been decoded, or the thing you can't read before it's been decoded. Has anybody ever seen an undecoded computer file before? It looks like your toddler got a hold of your word processor, selected wingdings font, and just kind of went like this, right? It's just unreadable. And that's the point. So all encryption is based on an algorithm. An algorithm is just a term that mathematicians use to mean, and computer programmers use to mean, a series of steps to do something. A recipe. And the most simple they call a Caesar cipher, because Julius Caesar had the practice of encoding all of his letters. He would basically just take the alphabet and tweak it a little bit, start the alphabet at D, for example, and then write it as if D were A, and then he could encrypt it, and then somebody could decrypt it if they knew what it was. Modern techniques, though, use really big numbers to lock the data. It's an older movie now that I'm getting older, but if you've ever seen Sneakers, this is the idea, right? We have these massive computer programs that are using very complicated series of mathematical steps to make it essentially impossible to read something without a key. So we have the obligatory Christmas story clip. Let's see if this will work for us.
90 seconds later, I'm in the only room in the house where a boy of 9 could sit in privacy and decode. Aha, B. I went to the next. E. The first word is B. S. It was coming easier now. U.
Oh, come on, Rosie, I gotta go. I'll be right there, Ma. Gee whiz.
G. O. Be sure to. Be sure to what? What was little orphan Annie trying to say? Be sure to what?
Annie has got to go. Will you please come out? Oh, right, Ma. I'll be right out.
I was getting closer now. The tension was terrible. What was it? The fate of the planet may hang in the balance.
No, Annie's gotta go. I'll be right out. Crying out loud.
Gee, almost there. My fingers flew. My mind was a steel trap. Every pore vibrated. It was almost clear. Yes, yes, yes,
Be sure to drink your Ovaltine. Ovaltine? A crummy commercial? Son of a bitch.
yes. I went out to face the world again. Wiser.
All right, so if you have a simple code, it's fairly simple to crack, right? Like a Caesar cipher or the Ovaltine code, We'll take just a few moments, and if you've ever seen any of the old documentaries about code breakers during World War II, you can actually learn how to do this stuff fairly easy. But that's not what we're dealing with. If you have a complex cipher, you have a very complex key. Currently, standard keys are either 128 or 256 characters long. And we'll talk about the implications of that in just a moment. So how do you use cryptography? Everybody here uses cryptography every day without even trying to. Every time you turn off your phone or lock your computer, every time you must enter a password or use your face or put your fingerprint on something, you are encrypting and then decrypting this data. And of course, nobody wants to memorize and input a 128-bit or 256 character password every time. So manufacturers give you a meta key, right? They have you pick a swipe pattern or use your face or biometric data, whatever it happens to be. This is kind of the meta key that then tells your computer, phone, whatever, to then decrypt everything so that you can look at it and so that you can use it. And then we also have these additional protections. So if you have this meta key, this 4-digit password or swipe code or whatever else, you could actually guess that after a fairly short amount of time. That would be more akin to trying to crack the code for drinking more Ovaltine or whatever, or Julius Caesar's letters. So what manufacturers like Apple and Google do is limit the number of times. And I'm sure anybody has dealt with this. If your toddler has gotten a hold of the iPad and it says, and they try too many times to unlock it, what happens? You can't unlock this thing for a month, or maybe it erases all the data. Like it's a huge freaking pain. But that's to try to prevent people from brute forcing their way into your data, basically. So it can lock the device, erase the data, extend the time between tries to a time that's far too long. So how do you break the lock on these things? Breaking a simple cipher takes experts just a few minutes through like what I call these brute force methods. If you try to break a complex cipher through brute force, it's nearly impossible. So brute force is just like keep trying codes until something works, right? The possible combinations for a 120-bit key are 2 to the 128th power. I'm not even going to try to say that number. Possible combinations for a 256-bit key are not just double that, but they're exponentially more, right? So to give some perspective on that, the possible keys to break one of these ciphers would outnumber the grains of sand in the sea and the stars in the sky combined. You see the numbers for the estimated grains of sand in the sea and stars in the sky. These are just such unimaginably massive numbers. The mathematics overwhelmingly favors encryption because it's so easy just to change one thing and make it that much harder to break into, or make the password just a little bit longer. All of a sudden, the number of possible combinations, like who here is forced to change their password every couple of months on their email? And then you try to reuse a password that you forgot you used like 2 times ago. It's like, no, you can't use the same password until you've had 20 passwords in between them. It's a huge pain. But the reason they do that and say you have to use a character, you have to use an uppercase, you have to use a symbol or whatever else, is that it makes it, just that one little tweak will make it exponentially more difficult to break that lock. Now, in some cases, I know that it's possible to bypass the lock. You have companies like Cellbrite that say that they can bypass all encryption. And I know, has anybody ever used Dixie State to break open a cell phone or something? I see a couple of hands going up. I know they have a program down there that is it free to law enforcement? I believe it is. Is that true? Yeah, so they can help you out. There are some drawbacks to it. From what I understand, it will actually destroy the device if you send it. And I don't know if there's a long waiting period or whatever else. There's going to be kind of a cost benefit there. But I know that the Cellbrite machines can also be expensive. Last time I checked, they ranged from $9,000 at the base model up to $16,000 for everything with the bells and whistles and the little windshield wipers on the headlights and stuff, right? So I know that it can be expensive, maybe prohibitively expensive sometimes, but even if, Cellbrite is the one that broke the code on the iPhone over the sniper shootings in California some years ago. But as I understand it, it didn't take Apple long to just change their encryption, and then Cellbrite has to start again and try to break it. So even though you can sometimes break in there, it's not always guaranteed that the encryption isn't going to race ahead. Okay, so let's talk about the Fourth and Fifth Amendment history just a little bit. I won't dwell on this too long, but I think it's helpful to you as you think through these issues. So as far as locks in the Fourth Amendment go, Fourth Amendment is the primary protector, I think it's fair to say, of the right to privacy to the extent that one exists. And the Fourth Amendment has a preference for warrant searches. And if the government has a warrant, it's been the case since at least 1603, so for about 400 years now, it's been the case that if you have a warrant, you can break down the door, you can cut open the safe, you can get into that however you want. If somebody's not cooperative, if you say, I have a warrant to search your house, like, well, you can't come in. It's like, well, you can move them out of the way and kick their door down if you need to, if it comes to that. So that's just kind of Hornbook Fourth Amendment law has been that way for a very long time. The problem is that we also have a Fifth Amendment issue here, and that's where it gets a little dicey. So the Fifth Amendment right against self-incrimination, the prototypical case is what grew out of the Star Chamber, out of the Spanish Inquisition, forcing somebody to confess, right? This was within the historical memory of the founders. The Star Chamber was finally abolished with the Glorious Revolution in 1688. That's less than 100 years before the American Revolution, right? So there were people still alive who remembered these practices. And in response to that, we have the Fifth Amendment saying, well, we're not going to torture confessions out of people. We're not going to build our cases based solely on confessions. So the prototypical case is you can't beat a confession out of somebody. But we also have what the U.S. Supreme Court has come up with called the active production doctrine. And the basic idea behind this is forcing somebody to do something can have the same incriminatory effect as forcing somebody to say something. So to be a protected act of production, the action has to be compelled, it has to be testimonial, and this is where most of the fights are. And testimonial in this respect isn't exactly the same as testimonial in the Sixth Amendment, Crawford kind of respect. This is more like, are you being forced to say something out of the contents of your mind, which is a distinction that doesn't make a whole lot of sense once you get down an analytical chain on this, but that's where we're at right now because most of these cases were decided in the 70s and 80s, and the Supreme Court just hasn't addressed it very much. And then, of course, it has to be incriminating. And incriminating in this respect doesn't just mean, here's the thing that proves my guilt. I have a confession on my computer, and then you open it up and like, surprise, I'm guilty. But it can be something like laying foundation for evidence that might later come in. Now, we know that not all acts are protected under the Fifth Amendment, right? There's a whole list of things in Rule 16. Has anybody ever used Rule 16 to get a defendant to grow their hair out or get a haircut or say a line or something like that? Every now and then, provide a handwriting example. There are U.S. Supreme Court cases, a line of them saying, look, you can force somebody to do something sometimes, and that doesn't violate the Fifth Amendment. Things like giving over a blood sample, a handwriting sample, a voice exemplar, so you can force somebody to stand in a lineup and say the line that the robber said or whatever, or to try on a particular piece of clothing. The idea behind these rulings is these are not testimonial because the acts themselves don't communicate anything. They're not telling you anything. They are just demonstrating something. They're not disclosing their knowledge or admitting guilt, even though it might have the effect of making them look super guilty, which is, of course, the point. And, of course, they are in most instances, right? So the unsettled law in this area, it hasn't been applied to electronic devices at the U.S. Supreme Court level, but we do have some of these older subpoena cases. So if you get one of these motions, odds are they're going to rely on these subpoena cases stretching back to the 1970s and going through the mid-80s or so. Just a quick summary of these cases so you have an idea what the arguments are likely to be. United States versus Fisher is the first one. The defendant was being investigated for tax fraud by the IRS, and the defendants got some records from their accountants and gave them to their attorney, because presumably their attorney said, well, we got to look into this whole tax fraud thing. Why don't you give me your tax records so we can look this up? And they hand over their tax records to their attorney. Then the IRS sent a summons to the attorney and said, okay, hand over those records that your client just gave you from their accountant. So in Fisher, the government was looking to force Fisher to sign some consent forms to get these documents. And the court said, well, that doesn't violate the Fifth Amendment privilege because it doesn't compel oral testimony or require the taxpayer to affirm the truth of the records. He doesn't have to say, yes, these records are true. This is what my financial situation actually was. These are actually the claims that I made. And of course, the contents weren't compelled. The government did not force them to keep these tax records. They were not forced from their minds. And to the extent the forms reveal anything like, hey, these are his tax records, the court has this little toss-off line. They say, well, this was a foregone conclusion, so it didn't really add anything to the government's case. And this is the rule that a lot of prosecutors are pushing to basically say, look, if you know that it's somebody's cell phone, it's in their pocket, you can go to Verizon or Cricket or whatever provider and prove, yeah, this number belongs to this person. Then having them unlock the phone, does that add to your case at all? I mean, the contents of the phone certainly do, but the act of unlocking it, it's like, well, of course we know it's their phone. We know 6 ways to Sunday this is their phone. So keep that in your back pocket for a minute, this idea of it's a foregone conclusion because it doesn't add much to the state's case. A couple more cases. U.S. v. Doe, we call this Doe 1 because there's another Doe case we'll talk about in one moment. But Doe had a sole proprietorship, and a grand jury was investigating fraud in his getting some government contracts, and they wanted those sole proprietorship business records. And he said, no, if I turn over these records, that would violate my privilege against self-incrimination. And the court says, well, the privilege doesn't protect the content of the business records because they were not compelled to be produced. But the act of turning them over may be testimonial if it provides foundation for evidence. So if you run your own business, you create those records, the simple act of turning them over basically is laying foundation. Is kind of like the 900 series rules, right? How else are you going to prove that these things are what you say they are? Well, we know we have the foundation for them because he gave them to us and he is the business owner. And the court said, actually, that has some testimonial value under the Fifth Amendment. But they said they didn't really reach that issue. They said the government we'll send it back down, and on remand, the government can try to show that that was a foregone conclusion anyway. Maybe there are other ways besides his particular testimony, his say-so, that can provide the foundation for these records. And finally, there's a third case that I thought I had on here, but we'll just talk about it really briefly. It's Doe versus United States. It happened just a few years after United States v. Doe. He was the target of a grand jury investigation into some tax fraud allegations. He had bank accounts in the Cayman Islands that the feds needed his authorization to access, right? So they're saying, well, sign these consent forms so we can get all of your Cayman Islands bank information. And of course, he was super cooperative and wanted to help out in any way he could. So he said, of course I'll do that. No, he said that I'm not even going to acknowledge that those accounts exist, because if I acknowledge those accounts exist, I would potentially be incriminating myself. So go pound sand, government. So the government went to the court and said, well, order him to sign these consent forms so we can get these accounts and investigate this tax fraud. The trial court denied that, so the government tried again, but this time they submitted a form saying, I hereby give permission to the government to access these accounts that may or may not exist in the Cayman Islands under my name. And the U.S. Supreme Court said, well, that doesn't implicate the Fifth Amendment because by signing that, he's not even acknowledging it. He's saying such counts as may exist. So the government kind of got out of this one in a clever way by writing the subpoena in such a way that it wasn't providing incriminatory information, even foundation for those documents. So that's basically it. We have these old subpoena cases, and we have this idea of the foregone conclusion. So just to drill down on foregone conclusion a little bit more, again, if the doing of the act does not give the government any additional information, the result is a foregone conclusion, but the government has to show knowledge of the information demanded. So let's say we know it's his cell phone. The suspect's possession of the information, We know it's his cell phone and that it's encrypted. We know that he knows how to decrypt it because it's his cell phone. So of course he knows how to unlock it, right? And it's on that authenticity. We can show through Verizon's records or whatever that this is his cell phone. The contention in these cases comes down to knowledge of the information demanded. Does the government have to prove that they know that there is a password, or that they know what the password is, or the contents of the computer or the cell phone? Do they articulate exactly what those contents are, right? And this is where a lot of the fighting goes on. We talked about Doe 2. One other quick one, US v. Hubble. Hubble was part of the whole Whitewater scandal. And while they were looking for evidence in that investigation, the independent prosecutor immunized Hubble and then looked through a bunch of his documents and found out he was committing tax fraud. All these cases are about tax fraud. And then they tried to prosecute him for the tax fraud, and they said, no, you immunized him, so you can't use information derived directly or indirectly under the federal immunity statute from the compelled document production. And then the court also said in Hubble, well, Fisher doesn't apply because the government couldn't confirm the existence and authenticity of documents without his testimony. So these are all of the cases you're going to deal with in this area. Let's look at the arguments on both sides, and then we'll get to Valdez, and we'll move on here. I'm going to channel my inner defense attorney for just a minute. These are the arguments that we're seeing. Has anybody ever watched, if you want a really fun YouTube rabbit hole to go down one of these days, if you're bored, look up the Texas Law Hawk on YouTube. He has a very entertaining series of commercials, and this is him up there in the top right corner. Talons of Justice is his tagline. It's pretty good. From the defense point of view, they basically say, look, electronic devices are so different from what existed before that we need new rules. And there's a little bit of appeal to that. There's especially appeal to that in a certain segment of the judiciary and of the population, right? It's understandable. Everybody's life is on their cell phone, right? If you lost your cell phone or your computer, it wouldn't just be like in days of yore where, oh gosh, I don't have that paper I was working on for my biology class. It's more like, oh, there goes all my access to my bank accounts. There goes my life. There goes all my pictures. There goes all my messages to my spouse. We have so much information on these devices. And that's qualitatively different, says this point of view, from just having a lockbox in your house where if you were to print out all that information, where would you keep it in an analog era, right? In a file cabinet somewhere, in a safe, in a box in a storage compartment, or in a storage unit or whatever else. And goes this view, to the extent there are old rules, they show you can't force something out of somebody's mind. There's a very famous dissent that Justice Stevens did in one of the Doe cases where he says, look, the government can force somebody to hand over a key to a safe, but they can't force somebody to tell the government can't force them to tell them the combination to a wall safe. And this analogy has really taken over this field of law where you have courts saying, well, anytime you're forcing somebody to tell you what the password is, that's like forcing the combination to a safe from their mind, therefore it violates the Fifth Amendment. I think that's overly simplistic. We'll talk about it in a minute, but you see that a lot in this area, and I'm sure you've probably already seen it already, some of you. And from this point of view, the Fourth Amendment isn't the only safeguard for privacy. The Fifth Amendment is about keeping one's thoughts private. So the court should adopt a rule that reflects that. Entering a password says a lot more than I know what the password is. It actually lays the foundation for everything on the device and effectively forces those things from the accused. And a lot of the same information, they say, this isn't a bad thing because a lot of this information can be obtained from third parties, right? Like you can send a subpoena to Facebook or to Google or to a cloud service or whatever else and maybe get the same information. There are problems with that, of course, because let's say you have a drug case and they're setting up the drug deals via text, as they often do. A third-party provider, you're not going to be able to go to Verizon and say, give me those texts. Those texts are just on the phone. They're usually not on a server somewhere at Verizon, though I may be wrong. Has somebody had a different experience than that? Been able to get like third-party information when somebody wouldn't unlock their cell phone? Yeah, so not all the data is going to be available. From the prosecution side, as I see it, electronic devices are really just fancy boxes. And the primary guardian of privacy is the Fourth Amendment. So if you have a warrant, just like in olden days, just going back to the 1600s, you should be able to break the door down, right? But the problem with electronic devices is encryption can be so strong that you effectively can never break the door down. So how is that fair? By letting somebody, when you have proven probable cause to an impartial magistrate, why should somebody be able to use the Fifth Amendment as a sword, essentially, against the Fourth Amendment? That's how I see it. And entering a password, because really it's not about what's on the phone, because the government didn't force you to make that stuff. The only thing they're forcing out of you is like, put in the password or give us the password. And entering a password really is not going to add anything to your case. I think the Fisher foregone conclusion exception should apply, because it's not like the fact that they know the password to their own cell phone is really going to crack the case open for you, right? I mean, it might crack open the case for you, but not that fact. What you care about is the stuff on the phone. That's what's going to crack the case open. And I think that if to the extent courts might or legislatures might be concerned about the testimonial value of the entry itself, then you can deal with that legislatively by saying, well, we'll just exclude the entry. You won't be able to stand up before the jury and say, ladies and gentlemen, convict this man because he knew the password to his cell phone. As if you would do that in most cases anyway. There's some courts that distinguish between biometrics and passwords. If the unlocking is putting a fingerprint on it or just holding it in front of their face, the result is likely to be different, because that's much more like forcing somebody to get a haircut or wear clothing or provide a handwriting sample, right? Like, you're not forcing anything out of their minds. You're just using their external physical body to gain access. But at bottom, I really don't think that distinction should matter, because again, these are just fancy boxes, and this is just a fancy key to a lock, whatever the key happens to be. I don't know that they should really be treated all that differently. And again, third-party subpoenas aren't going to produce a lot of this evidence. Now, the U.S. Supreme Court has before it right now a case called Andrews v. New Jersey on this issue. They will decide whether they want to hear it in a couple of weeks. It's going to be on for what we call conference. So they're going to sit down and decide, are we going to grant review in this case on May 13th? So it's coming up pretty quickly. And if that one doesn't go, then who knows? Maybe Valdez will make its way up to the U.S. Supreme Court, and we'll have a case that way. Both sides have a tendency to be a tad apocalyptic on this. Just a reminder, as if we needed more
Disaster
reminders
of biblical
apocalypses.
proportion. What do you mean, biblical?
What he means is Old Testament, Mr.
Yes.
Mayor. Real wrath of God type stuff.
Exactly.
Fire and brimstone coming down from the skies. Rivers and seas boiling.
40 years of darkness, earthquakes, volcanoes.
The dead rising from the grave.
Human sacrifice, dogs and cats living together, mass hysteria.
Enough, I get the point.
So for defense counsel on this, they basically say it'd be the end of privacy as we know it, as if that were ended already. I think a lot of us realize. But it would be at the end of privacy as we know it. There would be no place government could not go if the Supreme Court says that the Fifth Amendment doesn't apply. On the prosecution side, you can imagine similar reactions to a contrary ruling, which would be, we're never going to be able to investigate anything again. People are going to get away with murder. People are going to get away with drug dealing. And I think the hardest cases really are child pornography. Because if you can't force child pornographers to open up their computers, then those prosecutions are going to get a lot harder, right? So I think the truth is probably somewhere in between. We'll see how inclined the court is to deal with this. But for now, we have to deal with Valdez, and we'll go look at that really quickly now. A few questions in this case. They're not all unhelpful to us. First question is, can the state force a defendant to reveal his phone password to police? And the answer to that currently is no. We are seeking cert on this. I filed my cert petition about 3 weeks ago. And I think if the Utah Supreme Court were to deny it, then we would just appeal to the U.S. Supreme Court. We would have less chance of getting review in the U.S. Supreme Court, but I think we'd have a pretty good pitch. So I think the Utah Supreme Court is very likely to take this up and maybe give us some more clarity on this question. A couple of subsidiary questions that you can actually use this case if you have something involving the investigation exception. Objection, hearsay. Your Honor, I'm not admitting this for the truth of the matter. I'm using this to show why the cop did what he did. There's some helpful guidance on that issue here. And there's also a cautionary tale about should prosecutors ask witnesses to opine on the truthfulness of other witnesses. That answer is, of course, a big heck no. All right, this is our charming Mr. Valdez. He was upset that his ex-girlfriend refused to get back with him, so what other options did he have than to lie to get her to meet with him, kidnap her at gun and knife point, and tell her he was going to kill her? While he was driving around threatening her, saying things like, "I hope you said goodbye to your kids today, because this is the last time you'll see them," a dog who had gotten off its leash ran in front of the car, of all things. And even though he's on his way up the canyon to brutally murder his girlfriend, presumably, he stops to let the dog pass by. Because what is this, a Steven Spielberg movie? You just can't kill the dog? Anyway, as soon as he slows down for the dog, the victim figures, well, if I'm going to escape, it's now, right? So she fights like crazy, and fortunately, she's able to get out of that car and make it to a neighbor's house, and they later call the police. There are lots of issues in this brief, but we'll narrow it down for today's purposes. This is a case about, like a lot of cases, about dueling narratives, right? The victim says defendant is an abusive, controlling boyfriend. Defendant says she's the crazy ex-girlfriend, and she's the one who wants to get back with him, and she's making this drama all up, yada, yada. Because the defendant robbed the victim of her cell phone and got rid of it, the state had to rely on her memory and testimony of what her communication had been with Valdez leading up to the kidnapping. And the state really wanted to get into his cell phone. He didn't testify, but his ex-wife did give some favorable testimony for some reason, including that she saw the victim texting Valdez, because Valdez's ex-wife actually worked in the same company with his then recently ex-girlfriend, with the victim in this case. And she was saying, well, the day that they met, I saw her basically sexting with Valdez. She was sending these very sexually suggestive texts to him. So there was a dispute about what the communication was between these people. Here's how it played out at trial. So the state got a warrant to search the phone, and he refused. And then the officer said, well, we might have to break it open then. He said, well, destroy the phone. I don't care. I'm not giving you my passcode. So the officer testified at trial that he asked the defendant for his phone's, in this case, he had a swipe code, so, connect the dots in some creative way. And the officer said, well, he wouldn't, I asked for his swipe code. He said he wouldn't give it to me. And the officer said, well, I'm going to try to force it. And the defendant said, well, fine, just destroy it. So the prosecutor relied on this testimony in closing to rebut the defense argument that, hey, you heard ex-wife testify that the victim was sending these sexually suggestive texts to the defendant. And the prosecutor basically said, boy, we would really love to see those texts, but guess who wouldn't open their cell phone, right? Understandable why it went down the way that it did. The defendant said, no, hey, that violates the Fifth Amendment. You can't talk about that. The trial court said, oh, yes, the prosecutor can. This gets up to the Court of Appeals, Judge Harris writing. He goes over the active production test that we talked about a little bit earlier, compelled, and said, well, the state conceded that this was compelled. Now, what is being compelled, of course, is the password. The state had a warrant. That is a form of governmental force to get somebody to do something, right? So we didn't contest that the action itself was compelled, or at least sought to be compelled. Incriminating, the court said, well, the code itself is not incriminating, the little connect the dots swipe code. But it could lead to incriminating evidence. So relying on Hubble, that Whitewater case that we talked about, this would provide foundation for what's on the cell phone, therefore it's incriminating. And testimonial, the court says, yes, it discloses evidence, information from the defendant's mind, again, going to that analogy that Justice Stevens made decades ago, to provide this foundation for other evidence. And then looking at the foregone conclusion test, the court basically said, look, the U.S. Supreme Court mentioned this once back in the 70s. They've never really applied it, so we're not going to extend this into the digital world, and we're doubtful that the U.S. Supreme Court would. So basically, for policy reasons, the court says, this seems to be a really narrow thing, and we're not going to apply it outside of the subpoena context. This was my case, and something that got my dander up a little bit is that the court didn't even mention that the state had a warrant and that they knew that it was his phone, which I think is a pretty big deal, right? It's one thing if the cops are just trying to force you to open your phone, but if they've gone through the whole process to get a warrant, compliance with the Fourth Amendment should mean something. It didn't mean anything, at least materially, to the Court of Appeals yet, but we'll see hopefully what the Utah Supreme Court says about it. All right. The kinds of claims you might get in these cases, just a quick overview and some helpful cases in the future. If you have a biometrics case, so if somebody, like my work iPhone has the face thing, right? If I just look at it, the little lock on the top opens and I can access everything on the phone. If you have a case with a fingerprint, or I don't know any phones that open up to voice or face print or whatever it happens to be, there are a number of cases, this is just one of them, where they basically say, look, facial recognition and fingerprint is just like the blood handwriting voice sample. It's unprotected, though there is one case going the other way. But I think this is the strongest argument in this area for it doesn't violate the Fifth Amendment to use biometrics to unlock these things. If you have a password, so that includes putting in the numbers or connecting the dots, there are a couple of different ways to approach this. The way that the record was slightly unclear, but the way that the officer appeared to approach it in Valdez was to say, hey, give me your password. Now, I argue that that was unlikely because it's one thing to say, my password is 1234. It's another to say, start at the top left dot and then proceed to the middle dot and then go up to the top right dot. It's just not really practical to have somebody explain their swipe code to you. So I think it's more likely that the officer was asking him just to grab it and go like this and open it up. But regardless, the court's ruling in Valdez was grounded on they wanted him to turn over his password to the police. And if police ask for it so they can do it, you have some courts that say this is protected because it's just like the wall safe combination like we just talked about. Some say, well, we can apply the foregone conclusion rule, and there's a whole bunch of cases there. And then others decline to apply a foregone conclusion, essentially for the similar reasons to why the Utah Court of Appeals did. So if you have one of these, currently in Utah, you can't ask them for it. Well, you can ask them for it, but they don't have to give it to you. Another possible way, of course, is to have them do it. It's like, look, I'm not going to be the intermediary here. Here's your cell phone, you unlock it. Now, I realize that there are dangers with that, especially if it's like a computer. Let's say a very sophisticated defendant has a bunch of child porn on their computer, and if they unlock their computer, what's the first thing they're going to do? They're going to hit some kill switch, right, and wipe the whole computer, and you won't even be able to try to get it open at Dixie State or from Cellbrite or whatever other hacking technology you can get your hands on. So I realize that there can be dangers to this, but at least under the current state of the law, if you're advising your officers, you probably want to say, rather than have them give the officer the password, say, look, we have a warrant, you have to unlock your computer for us, or you have to unlock your cell phone for us. That will give us different arguments that we can make and differentiate the case from Valdez as it currently stands. So just a couple of take-homes on compelled decryption. The kind of encryption matters, if it's in biometrics versus a passcode or something like that. Get a warrant for any devices you want to search, break in if you can. Ask the suspect to decrypt it or ask for an order requiring that. We tossed around the idea of immunizing the act, just saying, okay, we'll give you immunity for the entry of your cell phone, the entry of the password to your cell phone, but I looked at the immunity statute, there it is. It also excludes testimony, evidence, or information compelled, as well as information directly or indirectly derived from this testimony, evidence, or information. It's similar to the federal statute, so I don't know that immunity will get you there currently. But if you have any other ideas, by all means, let us know. And again, send me an email if you get one of these, and I'll send you some helpful briefing on it. A couple of quick issues on this case, and then we'll take a break. First, let's talk about the credibility testimony. You have two different rules with credibility testimony. If you have a lay witness, you can't have them say, I believe so-and-so, essentially. And if you have an expert witness, they can't say something like, well, they can't act like a human lie detector. They can't say, look, I've been to all these trainings and I know how to tell when people are lying, and they raised their left eyebrow and spoke in a high voice when they were talking, so I knew they were lying, kind of thing. The expert witness rules prohibit that. In this case, the prosecutor actually, basically what the officer did is say, look, I've been trained, when I was interviewing the victim, I had her tell her account backwards. And I've been to all these trainings, and they say if somebody can tell their story in reverse, they're most likely telling the truth. And then the prosecutor actually asked them for their opinion, and the detective said, I believe victim was telling me the truth. So you just can't do this. Never ask either an expert witness or a lay witness to opine on somebody else's truthfulness. There's an exception for that, right? On a particular occasion. You can get them to say, in my experience, it's my opinion that they're an honest person, or they have a reputation in the community for being honest or something like that, but never get a witness to say, yeah, I believe this person was telling me the truth on this occasion. It's just out of bounds. Finally, a caution on the police investigation exception to hearsay. Exactly where the line is on this thing is not clear in Utah, right? Like, when is something, you can argue that it's not hearsay if you want the officer just to say, yeah, dispatch told me to look for a red Buick driven by a Hispanic male or whatever it is. You can get past a hearsay objection pretty easily on that because you'll say, I'm not using it for the truth of the matter asserted. I'm using it to say, why were you looking for a Hispanic male driving a red Buick? It explains why the officer was doing what they're doing. But in this case, they had the officer say back everything that the victim told him about the entire encounter with Valdez. And then the prosecutor said, well, I'm just using it to show why the officer did what he did. Be really careful with that. If you push it too much, then we can't have nice things. And the court is going to push back and say, in fact, they already do say here, look, it's too much just to let everything in under the police investigation exception to hearsay. If you're going to use it sparingly, and we'll be able to have a nice rule that we like. But if you play with fire, then we're going to lose our nice things, and maybe the court will make it much more difficult to use that investigation exception. All right, we'll take a break. Bob, how many minutes? 15 minutes? Did we lose Bob? 15 minutes.
For those of you that signed up to be here in person but are not here and would like to join us for lunch, we would encourage you to do so. Those of you that did not sign up to be here in person but would like to join us for lunch, please feel free to join us at noon. We will begin the regional legislative updates. Many of you are not familiar with what that is, but UPC staff, we travel around the state and train your law enforcement officers on the new legislation, basically what you're getting today. Marlise and Tyson are going to be doing the bulk of the training of those updates this year and are going to cover a few more bills than what we were able to cover yesterday. So when we send out the announcement, I would encourage you to look at that, and if you've got the time, come and sit in on that. The last thing Marilyn wanted me to announce is that our Utah Prosecutor Assistance Association conference is June. It's almost next month, but calendar-wise, 2 months from now in June. It will be live. It's going to be held at the Provo Marriott. It was canceled last year, so we know that the assistants are really excited to get back together, and so we would encourage you to support your support staff in attending that conference. And with that, we'll turn it back over to our two gentlemen here. There you go.
All right, so this group of cases, I think, is a good example of the aviation analogy I was using earlier. These are cases where we won, we prevailed on appeal, but I think that they were near misses. They're cases where we dodged a bullet, and I think each of them has something to say about the new direction that the Court of Appeals is going when it comes to charging different counts, multiple counts in the same prosecution. And so I'll give you a little bit of background and then walk you through Case, Wytock, and Goller and kind of give you a sense of where I think we are now and where we might end up. So the reason we're worried about this at all is that a decision that came down previously in a case called State versus Aliris. So Aliris was decided in 2019, cert was denied. What happened in that case, Aliris was charged with 6 counts of sexual abuse of a child, 2 counts for 2 different instances against his daughter, and then 4 counts for 4 different instances against his daughter's friend. During closing argument, and my sense is this is actually fairly consistent with the way practice had been in Utah, the prosecutor described a whole bunch of touchings, a whole bunch of prohibited acts that could have been criminal, and generally told the jury that it could pick whichever ones it wanted to for a conviction. This is the reaction that the jurors had to being told that. They then sent a note expressing their confusion to the court, and the court told them to refer to their jury instructions. And so the jurors responded to that confusion by essentially convicting on just 2 counts out of the 6 counts charged, 1 for each victim, and then acquitting on the other 4 counts. So on appeal, Aliris argued that his counsel was ineffective for allowing all of this to happen. And Judge Hagan, writing for a unanimous majority, agreed and reversed the convictions, holding that it was objectively unreasonable for trial counsel to propose instructions that did not require the jury to be unanimous as to the specific acts supporting each count of conviction. And I flagged the fact that this is Judge Hagan here for 2 reasons. One, Judge Hagan, I think, is generally fairly pro-prosecution in her outlook. But 2, Judge Hagan, I think, comes from a somewhat different background. Before she was appointed to the bench, she was the appellate chief at the U.S. Attorney's Office. And so she's familiar with federal practice, which is going to differ pretty significantly from Utah practice in ways that we'll get into. So continuing on, once the state failed to elect which act supported each charge, the jury should have been instructed to agree on a specific criminal act for each charge in order to convict. Without such an instruction, the jurors could have completely disagreed on which act occurred or which acts were illegal. So you could have 3 jurors believing that touching of the buttocks formed count 1, 3 jurors believing touching the breast could form the basis for count 1, 3 jurors believing another form of prohibited touching. You can add all the numbers up. You can see how you'd have potential disagreement on which act was actually committed and informed each count. So, moving into the 3 examples from this past year, first is State versus Case. So the defendant in this case had 37 different images of child pornography on his computer, and the prosecution, presumably and I think quite reasonably as a matter of restraint, only charged him with 7 counts of possession, but presented all 37 images to the jury, right? So I think from the understandable mindset from a prosecutor in this point, you'd say, well, look, I could have charged you with all 37 of these. I'm being the nice guy here. I'm going to only charge you with 7 instead of all 37, but I still want to be able to present all 37 images to bolster my case. During the closing argument, the prosecutor then told the jury it could pick which 7 images that it wanted the jurors to convict on. The Court of Appeals holds that this is mistaken. Once the state fails to elect on which act of possessing or viewing child pornography supported each charge in the amended information, the jury should have been instructed that it needed to unanimously agree on which specific criminal act or image satisfied each charge to convict. So in other words, instructing the jury this way was error, but it's harmless under the facts of this case because there's no dispute that all of the images were pornographic. The only dispute is whether the defendant case intentionally possessed all of these images. And so they all rose or fell as one, and so there's no substantial risk of a non-unanimous verdict based on the facts here. Second non-unanimous jury verdict case, State versus Wytalk. Wytalk is charged with 1 count of rape and 1 count of witness tampering. But at trial, the state presents evidence that's arguably sufficient to support 2 different counts of witness tampering. So 1 count for threatening the victim directly, and another for telling the victim's stepfather to pressure her to recant. I apologize for the typo there. The Court of Appeals, again, holds that this was error. So Wytalk was charged with only 1 count of a crime, but the state put on evidence of 2 potential occasions on which he might have committed the crime, once against the daughter and once against his stepfather, and made no effort, whether in the information, in the jury instructions, or in closing argument, to distinguish between the 2 occasions or to indicate to the jury which factual occasion was the one being charged. However, again, we dodged a bullet here. The Court of Appeals affirms because the defendant didn't object, and the issue is only raised through ineffective assistance of counsel. And so although there was an improper risk of a non-unanimous verdict, a reasonable defense attorney could decline to object because alerting the state to the issue might have caused the prosecution to charge 2 counts of witness tampering instead of 1, right? You can imagine there would be good reasons why a defense counsel wouldn't say, hey, judge, the state is only charging my client with 1 count, but it looks like they presented evidence that supports 2 separate counts. Can you make sure to point that out to them? So again, we prevail on appeal because of the standard of review, because this issue isn't preserved. So how can we prevent these sorts of issues from coming up again in the future? One of the themes of this presentation is going to be that wherever you can, give the Muji instruction. So maybe the Mujis will be able to help us in this. Okay, the Mujis are absolutely no help in with this problem. The Muji committee, I won't read this verbatim, but the Muji committee has a note to its criminal instructions on unanimity that basically says, the Utah Supreme Court has suggested sometimes you might need special unanimity instructions. We think it's really complicated and we don't fully understand what the Utah Supreme Court means. We don't know what the distinctions are that they're trying to draw. So we'll just note here that sometimes you're going to need special unanimity instructions, but we're not going to opine on what those should be. You should look at the case law. All right. I have a query here. Is it really all that unclear? I'm not sure that it is. I'll give you my opinion on how I think you'd sort this out, and then we'll turn to the last of the 3 cases I wanted to discuss for a potential sample for how you could present your own unanimity instruction in the absence of guidance from the Mujis. So for the difference between unanimity of elements and unanimity of theories, this is the distinction the Utah Supreme Court has drawn. Take a look at State versus Hummel. So a unanimity of theories would be something like whether the jury has to agree that the robbery occurred by entering the front door of a house or by entering the window of a house. And what our Supreme Court has said is jurors don't have to be unanimous about that. They can disagree about the theory of the way in which the crime occurred. But jurors do have to be unanimous about the elements of the crime. So, for instance, if there's evidence presented as to a robbery in Salt Lake City on Wednesday and a robbery in Provo on Friday, the jurors do have to be unanimous on which one of those two acts occurred. And I think the distinction there is whether they would have been chargeable as separate crimes or merely as alternative ways of committing the same crime. So under the hypothetical here for unanimity of theories, those are both just alternative ways of committing the same act of robbery. Under the unanimity of the elements, you could charge each of those two robberies, the one in Salt Lake City and the one in Provo, as separate crimes. And the concern is that when you have one charge that encompasses multiple criminal acts, which themselves each would be independently sufficient to sustain a conviction, then you might have a unanimity problem. In other states, there's a much more developed case law on this issue, and they often refer to it as duplicity. So if you're presented with an issue like this and want to get some guidance from other jurisdictions, punch in duplicity to Westlaw or Lexis, and you'll be able to get some guidance from other states. I mentioned earlier that this is also why I flagged the fact that Judge Hagan was interested in this issue. I think this is an issue where federal charging and federal practice is different, and so the federal courts may be sort of more attuned to this than the Utah courts have historically been. But I think now that the Utah courts are aware of it, I think we're going to start seeing these sorts of issues more and more. All right, so how can you deal with this problem practically? Well, one way to deal with it is by giving a unanimity instruction, a special unanimity instruction in cases that might present a duplicity problem. And so for an example of that, you can look at State versus Gallagher. So Gallagher is charged with 4 counts of first-degree aggravated sexual abuse of a child, and at trial, the state presents evidence of approximately 8 prohibited separate acts of touching. During closing argument, the prosecutor suggests that the jury can pick or choose which of the 4 out of the 8 possible acts they want to convict Gallagher on without necessarily having to agree from juror to juror about the 4 counts. So as I think the last couple of cases discussed, this is mistaken, and this is courting reversal under cases like Aliris. So the Court of Appeals holds that this statement is error when the prosecutor's statement is error when the state charges a defendant with multiple counts of a particular crime arising from a number of distinct acts. The jury must be unanimous as to which act or incident constitutes the charged crime. And it quotes State versus Case for that proposition. Thus, to ensure unanimity in such multiple act cases, the jury instructions must either link the alleged criminal act to the charge, and I'll return to that subject, what that looks like later, or inform the jury that it must unanimously agree that the same alleged criminal act has been proven beyond a reasonable doubt. So, all right, so we have error. We say that what the prosecutor said here was not correct. However, again, we've dodged a bullet. The error was cured, according to the Court of Appeals, because the jury ultimately received proper instruction on the constitutional unanimity requirement via the trial court's aptly timed sua sponte curative instruction. So the district judge here hears what the prosecutor is saying and steps in on its own motion and says, no, that's not right. What the prosecutor said is mistaken. I'm going to give you a special unanimity instruction. So this is what that instruction looks like. The court describes it in a couple of different ways. It gives a longer block quote in paragraph 11 of the opinion, and then a shortened, trimmed down block quote in paragraph 34. The shortened version of it is the jury must make a determination as to each count and be able to find unanimity, a specific instance that meets the criteria for the offense as to that count. There must be identified instances on which the jurors unanimously agree for each offense charged. That's a little clunky to me. I wouldn't give that instruction verbatim because I think it's a little goofy. You can see take a look at the longer one as well when you're not just sitting here listening to me drone on. But I think if you are faced with a potential duplicity problem where you're charging multiple potential acts, then I think you should try deliberately, if you can, to model a unanimity instruction off of Gallagher, because Gallagher has been approved by the Court of Appeals as sufficiently correctly stating the law to cure any error. So using some language of this version of Gallagher's language will help alleviate the unanimous verdict problem going forward. If you can, please also put in the record that you are basing it off of Gallagher. So if the Court of Appeals gets angry with us about the instruction, we can say, well, we got it directly from you, Dad. You're the one who told us that we're supposed to do it this way. So that's sort of an immediate suggestion for how to deal with this issue. There are a couple of other things to kind of look at going forward and to think about in calculating how you want to charge your various offenses, how you want to proceed, and maybe what your tolerance is for risk on reversal on appeal. So another option, other than giving the unanimity instruction, would be to distinguish individually between the counts. So whether in the information, in the jury instructions, or in the closing argument. So for example, you'd say count 1, witness tampering, to wit, threatening of the victim. Count 2, witness tampering, pressuring the stepfather. Or in a sexual assault case, oftentimes you would have sort of episodic memory, so you might see count 1, touching of buttocks at birthday party. Count 2, touching of breast after dinner. Whatever it is that matches up to the facts of the case. That method of charging, I think, is quite common in other jurisdictions, and if you do that, it can also alleviate these unanimity concerns. For those of you who prosecute child pornography, I know as a sort of advocacy point, when I was practicing in Arizona, people who were prosecuting child pornography would often like to charge whichever images had the nastiest, grossest name for the electronic image. So you can say count 1 and then have some horrifically disgusting sexual description to tag to each one, and that allows you to sort of present that as an advocacy point. One other sort of question moving forward, right? So say you do have a case where there are 37 images of child pornography and only 7 are charged. What does that mean for Rule 404B, right? If the state is presenting 37 images, but it's only charging 7, does that mean the other 30 images are other acts evidence under 404B? We don't, I think, have a clear answer to this now. I think that they could arguably be intrinsic evidence, but we don't have a particularly well-developed doctrine about that under Utah law as it stands right now. They could arguably be 404B evidence, so if you're saying that we're going to charge these 7 images and we want to present 37 to show absence of mistake, this is not just someone who accidentally downloaded 1 or 2 images of child pornography, this is someone who was intentionally seeking this out. I think there are theories and ways that you can get this admitted, but it is something to think about going forward. The Gallagher approach, I think, has the benefit of kind of avoiding the need to individually designate which charge it corresponds to which act. You can just give a blanket unanimity instruction. But if you only do that and don't designate between each charged act, and you have other acts that you're presenting but not charging, then you may be triggering a 404B problem. So just something to think about going forward about how you want to present your case. If you wanted to be extra careful, arguably the way that would sort of cross every T and dot every I would be to designate each act that's charged and then file a motion in limine saying, I'm going to also introduce these other images or these other acts of touching to show grooming or to show intent or to show lack of mistake or whatever your either intrinsic or proper 404B purpose would be.
2 aphorisms come to mind on that line of cases. One is, I think a lot of prosecutors feel like no good deed goes unpunished. Because it's like, well, I cut the guy a break. I didn't charge him with 100 things. I just gave him 7, right? But it is still true that juries can pick and choose, as it were, which ones they believe and which ones they don't. But they have to pick and choose as a group. I think that's really the take home from those cases. So I think you would craft jury instructions that let them know that if you want to take that approach. And that arguably avoids the 404B thing. It's like, we have 4 charges. You can choose which ones you believe, so long as you pick them and believe them beyond a reasonable doubt as a group, and you're not having a smattering of different acts for each different count. So I think the old practice, as it were, is still somewhat available, but you have to be really careful about it because the court is concerned about this, and understandably so. I don't think it's a phantom concern at all, or an unreasonable one. For defense counsel, I think the aphorism is be careful what you wish for. Again, if they're going to start complaining that we didn't charge enough, okay, let's amend.
The one other point that I would add is, I think every example that I've given here is something that is either arising on an error that's not preserved, so either plain error or ineffective assistance of counsel. If this is a preserved error, if a defense attorney objects on a duplicity basis, it arguably goes to unanimity. And so theoretically, it at least arguably could be structural error because it goes to whether the verdict itself was unanimous. And pointed out there are some possibilities in which it could be harmless, but particularly if this is an issue that a defense attorney is raising, I know some jurisdictions count this as structural error, and so you'd want to think really, really hard about how you'd respond to that in a truly preserved duplicity claim.
All right, on to State v. Beal, a quick case on using prior inconsistent statements to impeach an uncooperative witness, so especially for you domestic violence prosecutors and gang prosecutors. Question, can a party call a witness it believes will be uncooperative and impeach them with their prior inconsistent statements? The answer seemed pretty obvious to us, and fortunately it was also obvious to the Utah Supreme Court. Of course, that's how this works, right? All right. Sorry. Okay. So here's Mr. Coac Beal on the left. In the middle there is Uziel de la Torre, and on the right is Juan Castorita. I'm pretty sure that's him. Anyway, they're all fellow gang members, and just a little disclaimer for all of the precise thinkers out there. These are only allegations. This was an interlocutory appeal. Mr. Beal has not been as yet convicted. Hasn't even been a trial yet. Not that there have been many trials lately, right? So Mr. Castorita is a big bad gang member, and he had a big bad gang dog. That's right. Big old bad French bulldog, little Frenchie. After his little doggy went missing, he went mad. He got mad and he wanted it back. Understandable for all those dog owners out there. So Mr. De La Torre, his friend, going along with the gang code of standing up for your homies, got mad right along with him. Took to social media warning that whoever stole the dog was, quote, gonna get it. So Castorita eventually came to suspect that a guy named Luis Cruz had taken his doggy and started messaging him with polite messages to please give his dog back. So the conversation went something like this. Dearest sir, it has come to my attention that you have come into possession of my dear Frenchie. I know not how this happened, but I urge you to please do the honorable thing and return him to me so that I may once again enjoy his sweet company. Sincerely, Juan Castorita, and so forth. Didn't actually go like this, right? I actually had to use Urban Dictionary to translate all of these texts back and forth, which I thought was really fun to have like 7 footnotes to Urban Dictionary to explain what a phrase like this bitch finna gonna get lit up on me means to the Utah Supreme Court. But essentially they just argued back and forth. Give me my dog. No, I don't have it. Hey, what about this picture of you with my dog? Oh, that's not me. Yes, it is. I know it's you. Oh, anyway, goes back and forth like this with all sorts of colorful language and threats. So, but what happened next was no laughing matter. So Castorita told De La Torre to go drive by Cruz's house to confirm that his little dog was there and then to shoot it up. De La Torre took alongside Beal and 2 others, one of whom was Beal's cousin, so 4 of them in the car. Beal sat in the back seat behind the driver, who was De La Torre here. They circled the block a few times, and a couple of the neighbors' houses had Ring doorbells or some kind of surveillance so that they could record what was going on here. And so this car circled the block a few times, kept slowing down and passing by before the shooting. And according to these neighbors' surveillance cameras, the driver's side rear window was the only one down when the shooting happened. That happens to be where Mr. Beal was shooting, of course. According to the passengers, De La Torre handed the gun to Beal and said, shoot it up. He did, which ended up killing Cruz's aunt in front of her 13-year-old daughter as they were watching TV together. So really tragic, really sad. So here are the first stories. De La Torre tells the cops, hey, I heard the shots come from behind me, but he's being pretty tight-lipped. He's not saying, shots were fired. He's using the passive voice here, not being super specific about how the bullets ended up there, but he does say, I heard something behind me. The passenger's first story is, yeah, De La Torre handed the gun to Beale and then told him to shoot. So of course he heard the shots come from behind him. That's what he expected. That's what he wanted. Then the passengers, one of whom again is Beale's cousin, decide to change their story. And this is all before prelim, by the way. I think it's before prelim. Actually, it might have been right after prelim. So the passenger's second story, passenger one says, well, I lied. I was really afraid of De La Torre, and he threatened me and said, you better say Beale was the shooter. But that doesn't make a lot of sense because his first story implicated De La Torre anyway, and this didn't, even saying Beale is the shooter, it's like, well, De La Torre said that, you said that De La Torre was involved too, so it doesn't help a lot to just blame Beale. And the passenger two, the cousin, the officer wrote out a witness statement based on what the second passenger had told him, but then he refused to sign it. And then he said, he just wrote on there, I won't sign it basically, and Beale wasn't involved, when he clearly was. Anyway, they've changed their story. They're now no longer cooperative. So, a couple of rules. Defense counsel finds out that the passengers changed their stories and moved in limine to prevent the state from calling them and impeaching them with their prior statements based on some federal cases. So let's look at the Utah rules of evidence and the corresponding federal rules of evidence. Rule 607 in each is identical. It basically just says anybody can impeach, right? And the reason we have this rule is, does anybody know why we have this rule? What the rule was at common law? At common law, yeah, of course, everybody loves the common law, right? At common law, we had what was called the vouching rule. The idea was if you called somebody, you were implicitly or maybe even explicitly telling the court and the jury, look, this person is truthful. And you weren't able to impeach your own witness because then you would be at cross purposes with yourself, right? Like, well, you called them and you were implicitly saying this person is truthful. So you shouldn't be able to, be unfair to go around and then impeach them. Now, there are obvious reasons for this. The most obvious to me is that who picks their witnesses, right? Outside of expert witnesses, you go to war with the army you have, as it were. You just have to deal with what your witnesses are in a given case, especially in gang cases. So Rule 607 got rid of that old voucher rule and just said anybody can impeach at any time, and for good reason. Then we have 801 D1A for prior and consistent statements. So in Utah, the rule is much more lenient than the federal rule. In the federal system, if you want a prior inconsistent statement to come in for impeachment and as substantive evidence, the prior inconsistent statement has to have been given under penalty of perjury at a trial, hearing, or other proceeding. Now, this is a little bit easier for the feds because they don't proceed by information, right? They go by grand jury, which means they can get somebody's testimony very early on in a case, get it on the record, and later have that in their back pocket if somebody goes south on them. Grand juries in the state are very, very rare. Most prosecutors will go through their entire careers and never do a grand jury hearing, I think it's fair to say. And because of the way that prelims are after the Utah Supreme Court's ruling in Goins a few years ago, prosecutors have basically a disincentive to do live hearings, right? Because what good does it do you? Why do a live preliminary hearing when there's not even the prospect of you using that testimony later to if somebody becomes uncooperative or unavailable? So in Utah, the prior inconsistent statement doesn't have to be under oath, and it comes in as substantive evidence, right? It's not just to say, jury, you can just use this to show that this person is telling the truth or not. You can say, that statement is substantively true. That is what happened. So there's the difference, the similarities and the differences between the state and the federal rule. The basis for the defense objection here takes a little bit of explanation. So under the federal system, we have what is called the subterfuge exception. So the subterfuge exception is basically, look, there are plenty of federal prosecutors who have lots of prior inconsistent statements they would just love to get into evidence, right? But they weren't given under oath. If they were prosecuting in the state system, that wouldn't be a problem. But in the federal system, that's a problem. So what some prosecutors were doing, at least as the federal courts saw it, was when they would offer this testimony and defense counsel would say, objection, that doesn't meet the requirements of 801 D1A for prior inconsistent statements, the prosecutor would say, well, I'm not trying to get it in for the substance under Rule 801D1A. What I'm trying to do is just get it in for mere impeachment under Rule 607. And the danger of that from the federal point of view is, look, we really don't trust juries to make that distinction, right? If a jury hears a statement, they're, under these circumstances, under these conditions, they're likely to consider the truth of the statement and not just its impeachment value. So in the federal system, trying to use 607 as an end run around the requirements of 801D1A is what the court calls a subterfuge. It's like, so there's this exception to Rule 607. Anybody can impeach at any time in the federal system, except with prior inconsistent statements that don't meet the requirements of 801D1A. So there's a substantive problem they're trying to prevent. Does anybody see why this isn't a problem in Utah? Because why smuggle something in the back door that you can get in through the front? If it doesn't have to be under oath under 801D1A under our version, there's no reason for a subterfuge under Rule 607 because it just comes in for its substance anyway. So this is how we pitched our argument. The district court disagreed with us. I like this particular district court judge. I think he's a good judge, but he got this one wrong, so we took an interlock. He agreed with defense counsel and said, well, the federal and state Rule 607 are the same. That's true. And it is also true that when we have identical state and federal rules, our courts tend to look to federal courts for guidance because, hey, they're interpreting the same rule. We have the same rule. It makes sense. But he also happened to rely on Mangrum and Benson's treatise, which for whatever reason said, yeah, the subterfuge exception applies in Utah. They didn't cite a single case for it because there was no single case for it. And it disregarded this difference between the federal and state prior and consistent statement rules. So said Judge Blanche in this case, the state can't call the witnesses and impeach them if they testify inconsistently. You can imagine that if this ruling spread, it would decimate gang prosecutions, right? And likely domestic violence prosecutions. If you could never impeach a witness that you had called, if you knew beforehand that they were going to be uncooperative and give unfavorable testimony to you, gosh, that would really make life hard for a lot of victims and make your jobs a lot harder. So we took an interlocutory appeal and the Utah Supreme Court reversed. Here's Pierce writing. The court basically says, look, the plain language of Rule 607 says any party can impeach any witness. And we go by the plain language of rules. We don't go by these judge-made exceptions. If the Supreme Court wants to deal with the rules, then it will go through the Rules Committee. That's what the process is for. Otherwise, we're going to go with the rule as written. And by the way, we have this difference between 801D1A in Utah and the federal system. So there's no need for a subterfuge exception, again, when you can get it in through the front door. No need to sneak it in through the back.
All right, State versus Kitches, an interesting case that has some maybe helpful things to say about the voyeurism statute and how it interacts with some of the revenge porn statute. So, basic facts of this case. This is a really creepy but unfortunately familiar fact pattern of a guy who he and his wife separated, and then he decided to be a really creepy jerk about it. So Kitches and his ex-wife got divorced. When Kitches found out she'd started seeing someone else, like I said, he decided to just become a real creepy jerk. He was charged with voyeurism, voyeurism distribution, stalking, and criminal trespass. And if you look at the case, it's a fairly long opinion, and Kitches did lots of really weird, creepy things, including intercepting his wife's text messages, his ex-wife's text messages. But for now, we'll focus on some of these secret videos that he recorded. So he recorded videos of himself and his ex-wife in sexual situations before the marriage broke down. And then would later use these as part of the pattern of stalking, threatening to reveal them to other people, sending them to her to bother her. So there are a couple of holdings here that may be useful. One is that voyeurism can be proved by circumstantial evidence. So Kitches argued there was insufficient evidence that he took one of these two videos, But the video was taken inside their master bedroom. It depicted Kitches and his ex-wife. Ex-wife testified that she wasn't the one who took it, and the video was found in his computer. Obviously, you don't need direct evidence that he's the one who took the video. It's a completely fair inference that he's the one who did it.
They look at the credits?
Right, yeah, exactly. Produced by, so that's a mostly common sense, but it might be useful if you're responding to a motion for a directed verdict to say, no, look, you can rely on circumstantial evidence. It also makes clear that voyeurism doesn't require proof of the exact date that the recording occurred. And that makes sense. By definition, voyeurism occurs when somebody doesn't know they're being watched. And so if the victim doesn't know when that they are in fact being recorded, it's going to be very difficult for them to say, in a lot of cases, precisely when they were recorded. So date isn't an element of the offense, and you typically don't need to prove the date. The other interesting thing about this case is how it interacts with voyeurism distribution. So generally speaking, voyeurism against an adult is a Class A misdemeanor. There are elevated punishments if it's against a child. But distribution or sale of any images obtained by voyeurism is a third-degree felony if committed against an adult. And again, there's elevated penalties if it's against a child. So the question presented in Kitches is, what does distribution mean? Is it enough that you distribute it only to the victim? If you distribute it only to someone who is already depicted in the image? Or does the image have to be distributed to a third party? So this was presented here because Kitches sent one of these images only to his ex-wife as part of this pattern of stalking and harassment, but did not send it to other people. So the court's answer to this question is that the distribution to the victim is enough. The distribution to the victim is enough. Nothing in the statute requires distribution to a third party. And the court draws a helpful comparison to the revenge porn statute, which does require distribution to a third party. So as a general matter, revenge porn, according to the Court of Appeals, is intended to prevent a situation in which the victim is willingly recorded, but then the defendant later distributes the images without their consent. So someone sends an explicit image to a romantic partner, later they break up and that romantic partner starts circulating them. Because the focus of the revenge porn statute is on the non-consensual distribution of the image, not its non-consensual creation, it necessarily requires a distribution to a third party, right? Because the image itself was created consensually, and so if you're going to commit a crime under the revenge porn statute, you have to send that image to someone else. With voyeurism, on the other hand, the creation of the image itself is non-consensual. The victim does not know that they're being recorded. So even the distribution to the victim who's depicted in the image itself could cause harm. And in this case is a great example of that. As a matter of fact, Kitch's intent was almost certainly to cause the victim harm by sending her this secretly recorded image. So if you're presented with a case involving one of these sorts of domestic violence, revenge porn sorts of scenarios, I think this interpretation of voyeurism distribution can be a helpful tool in your toolkit, because even if the image isn't sent to someone else, it can still be charged if it is circulated back to the victim as part of a pattern of harassment.
Yeah, it also helped there that part of him sending it to her was the threat of, I'm going to send this out, look what I have. Right, makes perfect sense. State v. Gallegos, this is an important 404B case about prior possession of contraband, and another one I'm seeking cert on. This is another one of my cases. A couple of questions. First, can you use prior weapons possession to show knowledge, intent, motive, etc., 404B stuff, in a constructive possession case? The answer is not for now, and that's why we're seeking cert. Question number 2, this part is actually helpful, I think, to gang prosecutors and those, especially in the DA's office, who deal with crimes at the prison. That I guess you could also have that in purgatory and stuff. But do gang and sentencing information necessarily violate Rule 403? No, but be careful with it. Okay, here's Mr. Gallegos, aka Tresic. He has a whole album on MySpace. I looked him up, and yes, MySpace still exists. And yes, you can still stream his music, so thank you, Google. Oh, this is an old picture. There we go. That's what he looks like today. Slightly different, right? And here's his cellie, Mr. David Fresquez. One day they were just chilling in cell 213 down at USP when guards came in to toss the cells on that block. So everybody out, go stand in the shower, let's go through your stuff. Under a desk in a common area of the cell, they found a pair of Adidas shoes, one of which had a shank inside. You had to like lift up the inside sole, and there it was, this 9-inch shank. They asked who it belonged to, but neither of them said anything at the time. They just kind of, I don't know. Oh, so later on, Gallegos, and Fresquez had a chance to chat. Gallegos goes over to the searching guard and says, yeah, it was mine. And then the investigating guard sits him down, starts the tape recorder, gives him Miranda, and it's the shortest police interview I've ever listened to. It lasted like 1 minute and 36 seconds. Went something like this. Okay, it's 9:15 on April 13th, and I'm Officer so-and-so here with Darren Gallegos. We're out of Utah State Prison. Here's your Miranda rights. Do you want to talk to me? Yeah, I'll talk to you. Okay, so what happened? Yeah, it was mine. What was mine? The shank. Oh, okay, yeah, the shank was mine. Why did you have it? We're in prison? Sometimes you guys find my shank, sometimes you don't. It's just kind of hit and miss, but yeah, that's why I had it. Okay, anything else you want to say? No? All right. Conclusion of interview, 9:15 a.m. And it was very straightforward, or at least it seemed that way at the time. And then he goes to an administrative hearing because you don't just suffer potential criminal consequences. It could be, well, you don't get your commissary, you can't have, Skittles and ramen and whatever other little treats you would make on your Bunsen burner in your cell during your downtime. So he says, at that hearing, yeah, it was mine. And then they talk to Fresquez and says, yeah, it was Gallegos's. Seems pretty open and shut, right? Then all of a sudden, all that changed after Mr. Gallegos was charged criminally. In a series of prison phone calls, he explained to his friends that he had a, quote, strategy to defeat this new charge in which his homie would take the rap for the shank. So now he said, well, I only claimed it was mine because I just thought that I would take the administrative hit for it, and I could take that, but Fresquez, he's a lifer. I don't know if anybody knows who David Fresquez is. I'm sure somebody in this audience does, but he brutally murdered 3 people in Midvale several years ago and was spared the death penalty, but he's there forever. So charging him wouldn't really add anything to his sentence, and administratively, I guess they could take away some of his privileges, take him out of Gen Pop, again, take away his stove or his TV or something. But Gallegos basically said, look, I decided to take the fall for him because I just thought there would be administrative sanctions. But actually, now that you mentioned me being criminally charged, it actually wasn't me, it was his shank. Even though his phone calls are making it clear that he has a plan to deal with this. So his story was, he thought it was just going to be a fine, and he said, I don't care about fines because I've got like 50 grand in restitution on my books, and I never even use my books because if somebody put money on those books, where would it go? To restitution. So why put money in my books? I just use his books. Anyway, they had a fairly plausible story, right? It's not unheard of for people in prison to lie about things, especially people who are fellow gang members. And so the state needed to show that this was actually his shank, or at least that they jointly possessed it, right? So let's think about constructive possession. It's just the idea that you can possess something when you're not holding it. That's all it really is. It's a common sense thing. From time immemorial, we've recognized this, right? Like, unless you're think way back to property law in law school, if you're taking livery of a seas or something, like you buy some land and somebody takes the land and puts the dirt in your hand or something like that. Yeah. Most things you possess aren't in your possession all the time. And constructive possession is just the common sense thing, like, well, it doesn't have to be in your hand for you to possess it. There are other ways to show that. And this goes back in Utah law as far as possession crimes go. We had People v. Gillis, people possessing their neighbor's sheep that were among their flock, even though they weren't physically holding the sheep at the time. There's the State v. Morris case. This is also the inverse of what Marianne O'Brien in Utah County years ago, when I used to work with her, called the not my pants defense, the idea that you aren't possessing something even though you are holding it. Common possession crimes, this usually is most common in drug cases, of course, but you also have weapons, stolen property, burglary tools, child porn, right? You're always looking for circumstantial evidence to prove that somebody owned something or could exercise dominion or control, all that kind of stuff. So to show constructive possession, you need to show what the cases call a sufficient nexus between the accused and the item. And going back to the late 90s, we've had this list of considerations, the kind of things that are sufficient to show constructive possession that include, among other things, prior use or possession. So we have this line of sufficiency cases. There are several of them you'll see referenced here in the presentation today, but this has been an established thing for a very long time that prosecutors have used to show, oh, how do we know it was your meth? Well, partly because you're a meth user. So it's a lot more likely that you'd be using meth here. And that's been an acceptable use of other acts evidence, even if it wasn't directly addressed. So here's 404B. You could all sing along with me. It's a very familiar rule that we talk about every blessed year because so much litigation spawns from it. But we have a fairly long history in Utah, going back to the early 80s, of prior possession being used to show current possession. A lot of these are drug cases, of course, because that's the most common possession crime, but they're not exclusively drug cases. I have them listed there, though I did find that 7 federal circuits say that prior weapons possession is relevant to show current weapons possession. The Court of Appeals, as we'll see, was not persuaded by that, but I think we have a pretty good pitch in the Utah Supreme Court. So in this case, the court let in several pieces of 404B evidence. So it both let in that Gallegos possessed a shank before. It also let in that Fresquez had possessed a shank before. It let in evidence on gang affiliation and code. You know, these people are in the same prison gang. People in the same prison gang are expected both to be armed as a sign of loyalty to the gang and to each other. They're also expected to cover for each other, you know, try to show the motives for why their stories would change and all that, as well as some evidence on their relative sentences that they were serving and their parole dates, because this was relevant to show, again, why they changed their stories. If Gallegos' parole hearing was coming up, and if he were convicted criminally, that would obviously not bode very well for his release, right? And where on the other hand, Fresquez couldn't care less about more charges. What are you going to do? Keep my corpse in prison for another couple of years or whatever else, right? Like there's nothing to threaten with him that way. So the state needed all this evidence to really tell the story of why what happened. So the bad news first, the court reverses on Gallegos' prior shank possession with Judge Harris writing. And yes, I know Judge Harris and I look kind of similar. I get that all the time. But the way that the Court of Appeals saw it in this case, they said, look, these prior possession cases are pretty narrow and they mostly deal with drug use and with sufficiency of the evidence. The Supreme Court has never addressed, they believe, what they call the propensity implication of this kind of evidence. When I argued this case, I got fairly philosophical in my oral argument. I got explicitly philosophical. And because I knew from prior experience, other acts, if you will, that Judge Harris and I have a philosophical disagreement on the nature of 404B evidence. And I tried to spell it out as clearly as I could to say, it's possible to say that somebody did something without making a comment on who they are. And what 404B really gets at is you can't say one of two things. You can't say, this person is a bad person, therefore they did this thing. And you also can't take the extra step of saying, this person did this other thing, therefore they are a bad person, therefore they did the thing that was charged in this case. 404B says, as long as you're not doing that, if you're just saying, look, they had this same motive on another occasion, they had that same motive on this occasion. They had knowledge of this thing on that occasion, they had knowledge of this thing on that occasion. Because it's often, 404B is often caricatured as they did it before, they did it again. It's like, well, on its face, that's actually not really 404B. That doesn't really violate 404B because you're not saying anything about their character. Because 404A is all about Are you saying that they're a bad person, therefore they did this bad thing, usually? But from the Court of Appeals view, it's impossible to separate out those motive, intent, whatever, in a prior possession case from the propensity. You know, they possessed it then, they therefore possessed it now. But the court was not persuaded by my philosophical view of this, and we'll see what the Utah Supreme Court hopefully has to say about it. But as the law stands now, there's only one use for this kind of evidence, and that's propensity. And propensity is a forbidden purpose, therefore it does not come in under Rule 404B. The court also does an alternative 403 analysis and says, well, even if you have a little bit of non-propensity purpose sprinkled in there somewhere, it still shouldn't come in under Rule 403. So because of the danger of unfair prejudice, because of what it sees as this invariable propensity inference. So that's, as it stands right now, we'll see what happens in the future, but we'll do our best. One thing that really kind of got me about this case is there was a short dissent from Judge Pullman where she said that she would have reached a different result on the 404B evidence for reasons that aren't super important for this presentation. But neither side discussed the fact that Fresquez, well, the trial court also admitted evidence that Fresquez had a shank before. How can you say this made any difference if both people who were the potential possessors of the shank had had a shank before? I don't know. It was a little beyond me, but here we are. We'll see what happens. Now for some slightly good news. Oh, we have... No, I do not want to switch to Microsoft Edge. Go away. I'm really sure. There we go. But there is some good news in this case for gang cases. So if you are a gang prosecutor or you have cases involving gang evidence, then there's some good stuff here. Here's Rule 403. All of this evidence was challenged under Rule 403. And the defense often in these cases basically makes the same argument that Jim Carrey makes here in Liar, Liar under 403. Amounts to something like this.
Your Honor, I object!
And why is that, Mr. Reed?
Because it's devastating to my case!
Overruled.
Good call!
Just because something is prejudicial to your case doesn't mean it's unfairly prejudicial, because that's the wording of Rule 403, right? It has to be unfair. And in a lot of these cases, it's not going to be unfair. In fact, it's going to be crucial to understand why in the world things happened the way that they did, especially for things that happen at jails or prisons, because the rules are different inside there, right? Like society, to the extent that it functions in there, functions differently than it functions on the outside. So on the gang evidence, the court said, yeah, this had a really high probative value because it explained why Gallegos had a motive to possess the shank despite the potential consequences of it. And it also explained why he might have initially claimed to have the shank out of a sense of loyalty to the gang and fellow gang members. And also they challenged the tattoo evidence, but again, tattoos show your commitment to the gang, right? I don't have a tattoo myself, but as I understand it, they can be quite painful. In fact, they have pain charts for how painful tattoos can be. They're much more painful on the head and the neck and other sensitive areas, the hands, things like that. I think prosecutors, maybe even in the right case, might want to use this kind of thing just to say, hey, if they're willing to have a tattoo put somewhere where the sun don't shine, that really shows they're committed to this thing, because that hurts. But I digress, as I often do. So the gang information was necessary and crucial and admissible despite a 403 objection. Here also we had some sentencing information. There were two different kinds. One was what sentences were they then serving, which gave a context to their motives for the stories they were telling. And then there was also evidence that I don't think the prosecutor meant to get it in there. It was in one of the prison phone calls that if you've ever had to go through all of those for a case, I know it can get mind-numbing just listening to all of, they're flirting with their girlfriend or they're joking with their friend, or in my favorite case when I was a trial prosecutor, them planning a bank robbery and then confessing to the bank robbery they had just committed over the jail phone calls, and they got arrested while they were confessing to have just robbed a bank in Spanish Fork. It was gold. We catch the dumb ones, right? But the court said, yeah, it's fine to discuss the sentences that they were still serving because that showed their motives, but this evidence of what he could serve potentially for being convicted in this case, that's out of bounds. So be careful when you're going through all those jail phone calls, that massive amount of discovery stuff you get from the cops. And it's just not relevant, right? The kind of sentence they will be serving on this, for this case. There we go.
We have about 5 or 6 minutes before the break, so I think I can get through this quickly. 2 additional observations. The not my pants defense is universal in every jurisdiction that I've ever practiced in. Second, we were told not to get too deep into appellate nerdery, and you prompted me to give an answer about enfeoffment of season. So my apologies to everyone in the audience. We're both appellate attorneys at heart, and occasionally we show our nerdy colors that way. All right, State versus Bridgewater's, the basic holding of this case is that a protective order must be served under the requirements of Rule 4 of the Rules of Civil Procedure, not Rule 5. So give you some background here. Bridgewater's was personally served with an ex parte protective order. He didn't show up at the hearing, and the district court entered a permanent protective order. For some reason, the sheriff didn't serve it, and so eventually the petitioner's counsel, the person he had been harassing, attempted to serve Bridgewater's with the permanent protective order by mailing it to Bridgewater's last known address. So a little background on types of service for if you're like me and let all of this stuff drain out of your head after first year civil procedure. So Rule 4 service is the type of service required in a civil lawsuit to initiate a civil case. So that's what we would call service of process in the civil context. So it generally requires personal service, leaving it with a person living at the subject's abode, direct service upon an agent, or signed receipt of mailing. So this is the kind of super service you'd need to start a case. Rule 5 service is the type of service you would have for documents once the case has already begun. So this allows for more types of service, including regular mail and email. So the issue here is the service that the petitioner's counsel did in Bridgewater would satisfy Rule 5 by just mailing it, but it would not satisfy Rule 4. So the Court of Appeals begins with the Cohabitant Abuse Act and says that after issuing a protective order, a court shall deliver the order to the county sheriff for service of process. And so according to the Court of Appeals, when it says not just service, but service of process, that indicates that it's invoking Rule 4 and those elevated service requirements rather than the lesser requirements of Rule 5. However, in this case, Bridgewater's conviction is still fine because by statute, the ex parte order remained in place until the permanent order was served. So even though the permanent order isn't valid because it hasn't been served properly yet, the ex parte order remained valid because that remained valid until the service was completed of the permanent order. The one sort of other note of caution on this in dicta, you'll notice that the statute here, the Cohabitant Abuse Act says service of process will be accomplished by the county sheriff. The court suggests in dicta that this might mean that service is improper if it's accomplished by someone other than the sheriff. So if you got, say, a process server or someone else to go and deliver the documents personally, that might otherwise satisfy service of process, but it might not under this statute because the statute specifically mentions the sheriff. If you want to kind of cross all your T's and dot all your I's, then you'd want to get the sheriff to serve it to fulfill every checkbox in the statute.
All right, I think just a couple minutes left, so we'll go ahead and take a break. Maybe alternatively, we could have service accomplished by publishing it in some newspaper of general circulation, like the mugshots things that they're going to look for their friends in or something.
They got rid of those requirements.
I know, darn it. All right, take a break, come back at 11 o'clock.
is Tyson and Marlise and I have been talking about the need to talk a little bit more about bail reform than what we got done yesterday. And so this morning, Tyson has been working with Representative Pitcher, talking with some of the other presenters, people that are in the know on bail reform. And we are going to try to put together a WebEx, Zoom, Teams meeting, whatever, virtual meeting sometime in the next month during the lunch hour and take 30, 40 minutes, whatever it is, that they need to, to really flesh that out. So I just wanted to put that out for you all to be aware that this is probably something that we are going to try and do at least quarterly, is a topic that we don't necessarily have time to cover at one of our conferences. So that will probably be our maiden voyage. So I just wanted to let you know to be on the lookout for that. So with that, we'll turn it back over to John David.
All right, an important case, State v. Strickland, on sufficiency and recantations. Question, if a victim recants, does that render the evidence insufficient to convict the defendant? The answer is no, thankfully. All right, so stop me if you've heard this one. Strickland got drunk one night, and then he was around a young girl, in this case his stepdaughter, but it could be his girlfriend's daughter or his niece or whatever, and sadness ensues. The victim gave 3 accounts with basically 2 different versions. So you can see one of these things is not like the other. To the police at the scene, she said, yeah, Strickland came into my room in the middle of the night and he touched me. CJC said the same thing. He came into my room in the middle of the night and touched me. Then trial comes along and she says nothing happened. The recantation was pretty bad. Some seemed fairly plausible, but this one was just really bad. She had a really hard time explaining why she would falsely accuse Strickland in the first place. And her behavior at the scene corroborated her first story. She was upset and crying and all of that. The jury believed the first version and convicted Mr. Strickland. Then he raised a sufficiency claim saying, well, the victim recanted at trial, so therefore, by definition, the evidence was insufficient under these 2 old Utah Supreme Court cases from the late 80s. So under Webb, there you had a defendant accused of abusing his 18-month-old daughter, and he was watching the daughter while the mother was at work. And while the mother was giving the daughter a bath after she got home from work, the daughter said, "Ow, bum, daddy," and the mom saw some redness and swelling around her anal area. A doctor later looked at it and said, yeah, there's an anal tear there, but there was another expert who said, I didn't see anything. So anyway, you had these conflicting accounts. The appellate court said that's not insufficient. He was convicted of sexually abusing his daughter. And the Supreme Court said that's just not enough. It basically came down to ow, bum, daddy. For an 18-month-old, who knows what that means? That could mean a host of different things, right? The child is not sufficiently articulate to say exactly what happened. So they said that was insufficient there. Then you had Ramsey. Ramsey is just a terrible case. He was accused of forcing his young children to have sex with each other. The son told a social worker about it, and the social worker testified about what he had told her. But when the son testified at trial, he denied ever even making the statement. He didn't just say, yeah, I told her that, but I lied. He said, no, I never even said that. And then when it got to trial, he said nothing happened. So all you had there was a hearsay statement, essentially. And the court said that's not enough alone to sustain a conviction. So he was saying this case is like Webb and Ramsey. Judge Ruby Mills was on this one, and she disagreed. She denied that motion for a directed verdict and said, well, this is different than Ramsey because the victim doesn't deny making the statement. She just now says, she tries to explain very unconvincingly, I might add, why she lied. And we also have this corroboration at the time. When she told the officer what happened, she was visibly upset, she was crying. And by the way, we also had this statement, defendant, when police show up and they're talking to the kid, they overheard the defendant say on the phone, he called somebody and said, I acted inappropriately, I can't stay here, can you please come pick me up? So there was more corroboration here than in those other cases, essentially. She denied it. Strickland appealed. This goes up to the Utah Supreme Court, and the court affirmed on a 3-2. So this was a very close case. We prevailed, but only just. Justice Pierce writing. He distinguishes Webb and Ramsey and says, look, all this Webb and Ramsey stuff came from a Sixth Circuit case where the Sixth Circuit said it's doubtful that in any but the most unusual case, a prior inconsistent statement alone will suffice to convict. But when the Utah Supreme Court cited it back in '89, they said, the law is that a single uncorroborated hearsay statement is not substantial evidence and not sufficient to support a verdict. I love Justice Pierce's understatement here. Needless to say, we overstated the case, quote, a bit. So he's basically saying the foundation for the Webb-Ramsey rule is not super strong, and by the way, these are not super similar anyway. He notes that some states follow the Webb-Ramsey rule that you can't rely on hearsay, essentially, or an out-of-court statement to convict, but there is another approach, and that is that there's no need for corroboration if the declarant is available to testify and be cross-examined. And this makes sense, right? You're not just admitting a statement and who knows where the declarant is. This isn't the trial of Sir Walter Raleigh. If the person is sitting right there who made the accusation, then of course you can explore all of the circumstances under which that statement was made, and that renders it more reliable. So good enough, essentially, the court says. And by the way, there was plenty of corroboration here. You had the victim's demeanor, you had her consistent initial stories, her motive to change her stories to protect Mr. Strickland, and of course the defendant's statements on the phone. The dissent, this was Durant and Himonis dissented in this one, and they preferred a rule that says, under these circumstances, the appellate court should reevaluate the evidence for itself. I think Strickland was a very good case for us because it reaffirms the principle that the jury gets to decide this stuff, right? We have some lines of cases where the appellate court says, well, we know better. Even though we weren't there, we didn't hear these people testify, we didn't see them testify, still it seems to us that this just shouldn't have gone to the jury. The court, at least narrowly, at least for now, says that the jury is still the fact finder, and I think correctly so.
Okay, so let's talk a little bit about the doctrine of chances. For those of you who are not familiar, the doctrine of chances is all about probabilities. And so I wanted to kind of translate this into something we all could understand. So for you trial attorneys, the doctrine of chances is about probabilities. This is what that looks like. For the appellate attorneys who are watching from home, this is what the doctrine of chances would look like to you, the 12-sided die and the cones of Dunshire. All right, so doctrine of chances is essentially an exception under 404B that allows the prosecution to introduce evidence of previous incidents to demonstrate the statistical improbability that the criminal act occurred solely by chance. So there's a paragraph here from the Seventh Circuit that kind of summarizes this well. You know, if you win the lottery once, we all congratulate you. If you win it twice, we investigate you. If your wife drowns in the bathtub and you get her life insurance, that's a tragedy. But if your second and then your third wife also drown in the bathtub, then we start to think that that's maybe not a coincidence anymore. And so everybody sort of agrees on these classic examples of the doctrine of chances, that there are certain circumstances, right? If you have three spouses who just happen to have drowned in the bathtub, that we say that's really, really unlikely, and that those three instances should be admitted under the doctrine of chances. The difficulty is in drawing the line about when something goes too far under the doctrine of chances. The Court of Appeals has been really, really active in this area recently, particularly Judge Harris. Judge Harris, in particular, is very concerned that the state is admitting evidence under the doctrine of chances that's really just inadmissible character evidence. And I know John talked earlier about Judge Harris and his views on 404B. So he's written a number of separate opinions, and these separate opinions are starting to get the attention of the Utah Supreme Court. The Utah Supreme Court currently has a case in front of it right now in Richens that was argued 2 weeks ago. Sometimes you can get kind of a good sense of where the court's going to go from oral argument. This is not one of those cases. I think the court is really kind of struggling with some of these doctrine of chances issues. I am in no position to tell you how that's likely to turn out. There are also rule changes that are pending. John has been involved in some of those as well, so he may ask you to add a little bit at the end as far as where the rules may be going on this. But this is a really unsettled area of law as far as how you draw these boundaries for the doctrine of chances. And if you're curious, you can go back and actually listen to or watch the oral argument in Richens, and you can see, I think, the court's asking tough questions of both sides. So what I want to talk about is State versus Argueta, which is a case from last year about the doctrine of chances, which really doesn't technically hold much of anything about the doctrine of chances, but gives us a whole bunch of dicta, some of which is helpful, some of which is not particularly helpful, some of which is arguably contradictory, and may be supplanted if the Utah Supreme Court gives us additional guidance soon, but I wanted to make you all aware of it. So basic facts of this case, the victim felt someone stroke her vagina and her buttocks in the middle of the night. She thought it was her boyfriend, but later her boyfriend came home and found Argueta inside the apartment and pinned him down until the police arrived. At trial, Argueta claimed that he was just entered the apartment to return some keys that had been left in the front door, like you do. Of course, you go into someone's house in the middle of the night that you don't know to return their keys. To rebut this defense, the state presented two pieces of evidence under the doctrine of chances. One was evidence that Argueta had been convicted of trespassing at another woman's house nearby. And the second was that Argueta had been previously seen by the same victim in this case peeping into her apartment window. So Argueta challenged both incidents on appeal, but he didn't properly preserve his challenge to the peeping incident. So the Supreme Court only addresses the trespassing incident. And so the question is the fact that he has trespassed on another woman's property nearby admissible under the doctrine of chances to rebut the suggestion that he was only there to return some keys? So the court, in terms of its holding, ultimately rejects Argueta's appeal on harmlessness grounds. And so it says, all right, we don't need to decide whether this was admissible under the doctrine of chances because we think the evidence was otherwise overwhelming. However, it flagged the doctrine of chances as something deserving careful consideration and gave us a whole bunch of dicta about the issue, some of which is taken from some of Judge Harris's separate opinions. So, giving you an overview of this dicta. First, it says courts must use care and precision to distinguish between the doctrine of chances and mere character inferences. A party arguing the doctrine of chances must articulate the rare misfortune that they believe triggers the doctrine. Without a clear articulation of what event is being evaluated, it is difficult to make sure that the prior act is admissible under the doctrine for permissible inferences. So in the bathtub example, the rare misfortune is it would be an extraordinarily rare misfortune to have 2 or 3 spouses all drown in the bathtub. Courts should then weigh 4 factors in light of that rare misfortune: materiality, similarity, independence, and frequency. Similarity and frequency also work together. So the less similar the acts, the more probable it is that they could occur in the general population. And the less frequently they occur in the general population, the more it is objectively improbable that so many incidents would occur randomly. So again, in the bathtub example, those examples would all be highly similar, spousal drownings in a bathtub. They would also not occur particularly frequently in the regular population, and so you would think that that would be pretty damning evidence. The court is actually, I think, inconsistent on how similar the acts need to be. At one point, it says it merely needs to suggest a decreased likelihood of coincidence. So they need to be similar enough that it suggests this is not an accident. Later, the court seems to say it must be sufficient to dispel any realistic possibility of independent invention, which seems to me to be a much, much higher standard. The court doesn't really try to rationalize those two or tie them two together. So again, this is all dicta anyway, but I really genuinely don't know how similar the acts must be under this discussion. The court also seems to suggest that the proponent of the doctrine of chances must provide empirical evidence of frequency. So, quoting one of Judge Harris's concurrences, it says that the assessment of frequency cannot be based solely on intuition. To evaluate the frequency of a rare misfortune, a court must ascertain some benchmark for the typical person's experience with these sorts of circumstances. I put query here whether this is actually going to help defendants, and Justice Pierce actually raised this exact question at oral argument recently. So in the case that's currently before the Utah Supreme Court, it's someone who was supposedly accused of exposing himself and had been previously convicted of similar incidents of exposing himself. And I'm sure we could go through and pull case data for the population of Utah, what percentage of people have been accused of exposing themselves to children, and find that percentage, and then figure out how many of those people have been accused more than once. And I guarantee you that is going to be an astronomically low number, right? And we could present that issue to the jury. We could say, ladies and gentlemen of the jury, our data show that there are only 0.0001% of people would face this again. That doesn't seem like it's going to be something that the defense bar is actually going to want. And just as Pierce pointed this out, I think the defense attorney's response was, well, maybe you'd show it to the judge, but you wouldn't show it to the jury. We don't have an answer on this yet, but at least there is some suggestion of the need for statistical evidence. And so that may require you, if you really want to admit this, say evidence of a prior crime, to do some research and some digging around in court records to see what the percentages are. The court also says that it won't even bother to evaluate any of these factors unless the state first articulates the rare misfortune that they're talking about. So unless they've articulated the rare misfortune with care and precision, we're not going to even look at the issue and analyze it. So how do you take this moving forward? I've been trying to kind of give as concrete advice as I can. Takeaway number one is think really carefully about whether you want to use the doctrine of chances at all. And that's going to depend on the strength of your case. It's going to depend on the strength of the doctrine of chances inference. But the courts are looking at these issues very, very closely. The law is very much unsettled in this area. It's difficult to give clear guidance, and so just be aware of the risks, and that if you're pushing the envelope on this, you're risking the potential for reversal, particularly in the Court of Appeals if you get somebody like Judge Harris on the panel. Takeaway number two, if you do use the doctrine, make sure to clearly articulate the rare misfortune that's going on, the rare misfortune that you would happen to be accused of exposing yourself 3 or 4 separate times, the rare misfortune that your spouse would just happen to accidentally drown in the bathtub. You want to articulate that as carefully as possible. Point number 3, and this is just true as a matter of common sense with Rule 404B in general, but you want to try to hook it into the text of Rule 404B. So you want to talk about how I'm not saying that this defendant's a bad person, I'm not saying he's a bad guy, he has a bad character, I'm doing this to show absence of mistake or lack of accident under Rule 404B, whatever the inference might be. And then the last point, watch for State versus Richens and for future rules development. I think we will see, I hope, some additional clarity on this point going forward, but either from the Supreme Court or from the Rules Committee or both. But at this point, it's really tough to give you guys clear guidance other than just to be very, very careful and to evaluate whether this sort of evidence is actually critical to your case or not before you decide to introduce it. Do you want to talk about any of the rules stuff at all?
Yeah, sure. So I'm on the Evidence Rules Committee, and it was about a year ago that the Utah Supreme Court said, hey, give us a rule of 404B, take 404B and throw the doctrine of chances in there. So we did that about a year ago. It was fairly bare bones. We basically said, okay, here's the doctrine of chances. Here are the 4 foundational requirements. This is now a thing under Rule 404B. And we sent that up to the court. The court didn't like it, and they said, try again. So we're currently trying again. We just settled on another proposal that we're now going to send up to the court. But we have been debating this for the past year or so, and there's no real end in sight. So I agree with Dave. If you can possibly help it, avoid the doctrine of chances, mostly as a risk aversion strategy, right? Because if you really need it, then by all means use the tools that you have at your disposal, and we're not going to fault you for it. But if you're going to be a little risk averse, just recognize that if you use this thing, our courts are, I won't say all over the place, but it's very unsettled. And until the dust settles on this, until we have a better idea of what exactly it means, and part of that's going to be accomplished hopefully through our rule committee work, part of it is going to be accomplished through cases, but we aren't there yet. And I think this is emblematic of how this thing all came about anyway. This whole rule started being a thing in Utah from State v. Verde, and the court brought it up on its own. Neither of the parties argued it and didn't rely on it, but the court saw it as hey, here's a good way to frame all of our prior cases in this area, like the serial rapist cases like Nelson Wagoner and others, where you're using this inference that, gosh, how many times this happened by accident? I would have added, if that were my case, I would have added one more clip. The old movie Fried Green Tomatoes, there's a part where Kathy Bates is in a parking lot and somebody takes her parking space and she's feeling fairly liberated and keeps crashing into repeatedly this parked car, and she gets home later that night and her husband is sitting watching TV and he says, "How in the hell do you accidentally rear end somebody 27 times?" And that's the basic idea, right? The idea is, of course, you don't accidentally rear end somebody 27 times. You were doing it on purpose. That's what we're trying to show here. So it makes sense as a theoretical matter, but it's been very hard to implement in practice, and it's still in play. So just FYI, we are working on those things, but they're not worked out yet. State v. Marquina, a case about sleeping jurors. We've had a few of these in the last few years. It's an ages-old question. How do you deal with lollygaggers, right? There are possible options analogizing to some ancient wisdom. Let's see if I can get this working.
What will we do with the drunken sailor? What will we do with the drunken sailor? What will we do with the drunken sailor early in the morning? Way hey, and up she rises, way hey, and up she rises, way hey, and up she rises early in the morning. Shave his belly with a rusty razor, shave his belly with a rusty razor, shave his belly with a rusty razor.
It's fun for a minute, but then it gets really grating. So there's I don't know if anybody, please no. I'll just skip the slide. I don't know if anybody got caught up in the sea shanty thing on TikTok or on the internet, but put in the Wellerman into YouTube, and you can go down a very fun YouTube rabbit hole, and it's actually a very catchy song. Dave and I started sending sea shanties back and forth to each other for a while because that's the kind of people that we are. But there's a lot of different options if you know the old song. It's like, well, you can do one of all of these things, and it's very much like, what do you do with a sleeping juror? Do you try to wake him up? Do you let him sleep? Do you tell the judge? There's all sorts of choose your own adventure kind of paths you could take here. So let's look at those questions. Here is our cast of characters. On the far left is a guy named Michael Flores. He was being evicted from his Magna apartment. So what options did he have? I could move in with mom again. I could find a friend. I could crash on their couch. I could couch surf for a while. No, he decided to go rob his friend's landlord, who he had heard, quote, carried a lot of loose cash. So he brought along some friends to do that. Ricardo Smith there, second from the left. Leanne Velasquez there on the right. And on the far right, Mr. Marquina there. The victim had just gotten home with his wife after an evening at the symphony, actually. Flores chickened out, so Marquina went up to the house alone. And when the victim opened the door, Marquina just shot him 5 times in the face and the neck. Fortunately, he was in the hospital for a while, but the victim did survive. So there is that here. On day 2 of trial, defense counsel was cross-examining an officer, and the prosecutor asked to approach and said, Your Honor, I'm sorry to interrupt here, but it looks like one of the jurors is nodding off. I was thinking maybe we could either stretch or take a recess or something. It's like, okay, maybe we've been going on too long here. We've all been that way in trial. I know I've been at risk of nodding off during some cross-examinations or closings because, my gosh, can you not just finish already? And the court said, yeah, that's a good idea. Let's take a recess. Let's wake everybody up, get the blood flowing. Then the next day, it happened again. After a lunch break, the court said, okay, it's time to release the alternate jurors. What do you want to do, counsel? The prosecutor said, I think it's safer just to replace the sleepy juror. She seemed to have been nodding off a little bit. Let's just err on the side of caution here. And the court said, well, yeah, I actually noticed one sleeping too. Defense counsel said, oh, no, wait, I didn't notice anybody sleeping. And hey, don't you know about Judge, it's not Kimball, I forget who the federal judge is, but there's a federal judge here in Utah who's famous for looking like he's sleeping on the bench. He just kind of folds his arms and bows his head. And it looks like he's sleeping, but he's really just intently listening to all the testimony. And if you try to get something past him, he'll jump down your throat. And so defense counsel used that example of, hey, Judge so-and-so does this, and he's not really sleeping, he's just really focusing. And the court said, okay, well, I won't do anything then. And the prosecutor said, well, why don't we ask him? Again, to err on the side of caution, the prosecutor was being great in this case. They're doing all the right things, saying, hey, let's err on the side of caution. Let's talk to the juror. Let's find out if they missed anything or how long they were out. And the court's like, nah, this is fine, right? Everything's burning down. We're fine. So a quick visual of the Court of Appeals holdings. Oh, my clicks didn't work. The court basically said, this isn't preserved, so we have to look at it through plain error. And this isn't ineffective assistance because defense counsel could reasonably decide, district courts have a lot of discretion in this area to deal with sleeping jurors, so we can't say it was obviously an abuse of discretion. So this goes up to the Supreme Court, Judge Peterson writing. The court had some misgivings about how the trial court dealt with the prosecutor's concerns, and understandably so, right? Where you have a party saying, Judge, we got this sleeping juror, let's use the alternate instead, or let's at least talk to them, and the judge is saying, no, I'm not going to do any of that. The Supreme Court basically said, judges don't act like that. If somebody raises a concern about a sleeping juror, get to the bottom of it. Talk to the juror outside the presence of the other ones and just say, okay, were you actually sleeping, first of all? And if you were, how long did you nod off for? Did you notice? Whose testimony was it during? All those things. Get to the details of it so you can figure out, so the judge has information to act on and not just, I understand not wanting to interfere with the jury's processes and things like that, but a juror sleeping, that just kind of crosses the line, right? So if you do run into this situation, if you have a sleeping juror and the court doesn't appear inclined to do anything, pull out Marquina and say, Judge, we got to talk about this just a little bit. And they say that should have been, the question here, because it was unpreserved, is whether Marquina's proposed approach, which on appeal, of course, he took a different position than he took at trial, which was, and you can see why some defense counsel would do this. It's like, it can do nothing but help my case if the juror is sleeping, because maybe they missed some good evidence. I don't have that great of a case. So maybe I would prefer that all the jurors were sleeping here. But the court said you should address those concerns as they come up. Here's the law as it existed at the time of trial. You have these cases going back to the late 20s, for that matter. Jurors have been falling asleep for a very long time. So maybe it should be comforting that every generation of lawyers is to some degree similarly boring. And if you look at these cases, it's basically discretion all the way down. Courts have always had discretion in dealing with sleeping jurors, and this makes sense because they are there. They are the ones sitting there in the presence of the jury. They can see whether somebody's just nodding off or if they're actually snoring there in the jury box. And they are equipped to deal with the problem when it arises. So the court basically says, look, we can't say it was an abuse of discretion, but we do want to caution everybody. This was an obvious error, but let's caution trial judges to be careful when this kind of thing happens if you run into this situation. But again, it doesn't mean the trial court dealt with this in the best way. And the way that the court basically says to deal with these things is act in proportion to the report. If a party says a juror looks tired, the response will probably be different than, hey, juror 5 was sawing logs back there, drool was coming out, they're staring at the ceiling, they're not responding to other jurors poking them with pencils or whatever else is going on. And before the trial court rules, it should, quote, glean any facts relevant to make an informed decision. On the ineffective assistance, they had an alternative ineffective assistance claim here. The issue, of course, on an IAC claim is, could counsel have reasonably decided not to object or to dig deeper? The answer is yes. Counsel could have thought it was good that a juror missed some testimony or disliked the alternative one. And my gift didn't work there. If it played, it would say, this guy is cool. So defense counsel could be okay with that.
Okay, this next one is going to be fairly quick. I think I mentioned before that one of the general themes of our materials is often just when you can give the Muji instruction. So we'll talk very quickly about State versus Newton. So the takeaway here is that in rape cases, make sure to give the Muji rape instruction. So I'll give you some factual background. So the victim reported that Newton had choked her and raped her in his car. She presented with multiple genital injuries and with redness on her neck that was consistent with strangulation. Newton's defense was she's lying about all of it and that she actually enthusiastically consented. And the kind of comically enthusiastic consent defense seems to be a common one in rape cases, the ridiculously implausible consent defense. All right, so the concern with State versus Newton is that rape in Utah actually has kind of a hidden element. So, and specifically that hidden element is the mens rea regarding lack of consent. So Utah defines rape as a person commits rape when the actor has sexual intercourse with another person without the victim's consent. Now there is no express mens rea in there, and on its face it appears to provide just two elements, which is intercourse and lack of consent. Our Supreme Court has recently clarified, however, that there are actually hidden mens rea elements in the rape statute. So Utah also requires a mens rea for every non-strict liability crime. And so rape requires proof not only that a defendant knowingly, intentionally, or recklessly had sexual intercourse, so there's a mens rea with regard to the intercourse element, but also that the defendant had knowledge or recklessness regarding lack of consent. And so that's in State versus Barella. Be aware that both Barella itself and some Court of Appeals opinions in particular seem to kind of mash these two separate mens rea elements together. So you'll sometimes see in some opinions saying, well, consent is very contextual and we must look at all the facts around what happened to determine whether the victim consented or not. And the answer to that is, of course, no, you don't. All you need to do to know whether the victim consented or not is ask the victim, and that's sufficient as a matter of Utah law to determine whether they've consented or not. Now, you might bolster that with surrounding circumstances to show that they're not lying about it. To the extent, though, that you really need to look at the surrounding circumstances, it's not to show necessarily whether the victim in fact consented or not, but it's to show recklessness or knowledge regarding the victim's lack of consent. So the defendant in a rape case must be at the very least reckless with regard to whether the victim consented or not. Okay, so in State versus Newton, the claim was that his counsel was ineffective for not objecting to an instruction that failed to state the correct mens rea regarding consent. And the court holds that the instruction was arguably ambiguous about mens rea, but Newton suffered no prejudice. Under Newton's theory of events, the victim clearly consented. It consented enthusiastically. And under the victim's version of events, the victim clearly did not. So there's no reasonable basis for the jury to believe that Newton might have been reasonably mistaken about consent. Either she did not consent and she very clearly communicated that in a way such that he had knowledge or recklessness, or she very clearly consented and he would have had no basis of knowing that she did not consent. So it's harmless under these facts. The court does say, though, going forward, however, district courts should ensure that jury instructions for rape clearly require a finding that a defendant had a requisite mens rea as to the victim's non-consent. They can accomplish that task by simply using the Muji. And so when in doubt, give the Muji instruction, and that's going to be the safest course. Separate and apart from that, we also get a bonus holding in Newton that may be helpful. The bonus holding is that the prosecution doesn't violate Brady by failing to investigate something that it could have investigated but didn't. So under the facts of this case, the victim lost her cell phone during the incident. Police later found it and returned it to her without searching it. Later examination found out that the victim had entered Newton's cell phone number into her contact list in her cell phone. Newton argues that the state violated Brady by not investigating the phone and then revealing the fact that Newton's contact information was inside the phone. Query, by the way, whether this is exculpatory at all. I have a lot of people's phone numbers in my cell phone. I don't consent to have sex with most of them. or with all but one of them. To be clear, honey, if you're watching. So query whether this is exculpatory in the first place, right? But regardless, Brady only applies to evidence that is known to the prosecution, not evidence that could have been known or could have been discovered with additional investigation. So if you're faced with a Brady claim based on something that you didn't even know about, but they're just saying that you should have done a better job investigating it, State versus Newton has some helpful language about that.
Thanks for that clarification, Dave, because my number is in your cell phone. All right, Pleasant Grove v. Terry. This is an important case on legally impossible verdicts. So, question, is legally impossible verdict valid? The U.S. Supreme Court is okay with it. Utah Supreme Court, how about no? Not so much. Here is, I think, Mr. Terry. He went to go pick up his son and his daughter from school, and his son came out first and sat in the car. While he was waiting for his daughter, his ex walks up and they start fighting over whose turn it is to pick up the kids. So they yell back and forth about it, and at one point the ex went to the passenger side, and here the stories diverge. She said that she went to calm her son down, and Terry punched her in the mouth. He said he just went to put his arms around his son, and she started hitting him. So she started shouting, "He hit me," and Terry saw a man running towards him, so he took off. The man was his ex's boyfriend. The man jumped partially into the passenger side window and hung on for blocks. Terry went to a police station where the man, the ex's boyfriend, was hanging halfway out the passenger window. So, exciting day at Mill Creek Elementary or whatever it was. That was my elementary school. I don't know where I don't remember. Oh, happened in Pleasant Grove, clearly. All right, so the jury on this one says he's charged with domestic violence assault and commission of domestic violence in the presence of a child. The verdict, they acquit him of the assault and they convict him of the DV in the presence of a child. So everybody was confused. The judge thought, well, wait a minute, doesn't reasonable doubt on the assault mean that the thing that's based on the assault also has reasonable doubt? Terry filed a motion to arrest judgment, which the trial court denied after finding no Utah authority to support it. And again, the U.S. Supreme Court had said this is perfectly fine. Maybe not perfectly fine, but at least acceptable. So let's look at some factually inconsistent verdicts. The Supreme Court reversed with Justice Simonis writing. And here's the law pre-Terry on inconsistent verdicts. You have two different kinds. You had factually inconsistent verdicts, and you had legally impossible verdicts. So the law, both at the federal and the state level here, tolerates factually inconsistent verdicts. State v. Stewart is one example of that. If there's evidence supporting the verdict, then the court affirms. Here, some co-defendants were acquitted and others were convicted. The law tolerates that. If the jury picks some facts to believe and not others as to one defendant and not another defendant, that's okay. This is for cases basically in which the jury convicts on some but acquits on others that are factually related but not legally dependent on each other. So let's say you have one of these sex assault cases where the person is charged with different acts that occur over the course of 4 or 5 hours. So they've got a rape count, a sodomy count, a indecent liberties count, just sexual sex abuse. Just go down the list of, okay, they touched this part here and that there with this other part, and you're lining up all your counts that way. The jury can convict on some of those and acquit on others. They don't have to believe that every single one of those things happened. And that's not legally impossible, that's just factually inconsistent. Even though you would expect, well, if the jury believed this person did not consent to X, they likely didn't consent to Y as well. So it may confuse us and puzzle us a little bit, but under the law, there's no problem in affirming those cases. Now, it's different with legally impossible verdicts. This is where one of the counts is legally dependent on the other one. So obviously, you can't be convicted of domestic violence in the presence of the child if there was no domestic violence. Then all you're convicted of is in the presence of a child, which is not a crime. Doing nothing in the presence of a child. As if those of us with children can ever do nothing. That would be so sweet, wouldn't it? It's impossible to do nothing in the presence of a child, especially when they're quiet. I have a 3-year-old right now. Anyway, so SCOTUS and the majority of courts have said these are actually okay. Even if they're legally impossible, the jury is the one who gets to sort this out. They can decide to exercise mercy. They can do what they will for reasons of their own, and for good reason under Rule 606, we don't go into the reasons why the jury did what the jury did. But the Utah Supreme Court disagrees with this reasoning and says we're not going to have legally impossible verdicts be valid in Utah anymore. So they part ways with the Supreme Court because they basically say, look, legally impossible verdicts from their view undermine confidence in the trial outcome, and it shows that the jury acted outside the law, though I would say, well, they do that all the time by nullifying, right? And that's always been the case since we've had juries. Such a constitutional insult, the court calls it, cannot stand. They have some very strong language for this. And if the court were allowed them to stand, as the majority saw it, this would seriously undermine confidence in the criminal justice system and raise the possibility of wrongful convictions. So the court said we cannot stand idly by while legally impossible verdicts call into question our justice system. So how can you figure out whether this kind of thing is going to happen in your case? You need to first figure out whether your offenses have a predicate-compound relationship. So a compound offense is something that's composed of one or more offenses, right? So robbery is essentially theft plus assault, though robbery is not dependent on another, but it has kind of subcrimes inside of it. I think one of the easiest ones, like ag sex assault, you have a sex crime coupled with the threat of violence or use of a dangerous weapon, for example. And then you have to say, well, do they have a predicate or a lesser included relationship? So is one of them composed of some but not all of the elements of a more serious crime that is necessarily committed in doing the greater crime? Again, I think ag sex abuse is an easy one there. It's basically like the mirror of the rule that you can't be convicted of an offense and a lesser included offense. You can't be acquitted of the lesser offense and convicted of the greater or the compound offense. So the way you deal with this is if you have that situation, if you run into the Terry situation and you have a DV count as well as a DV in the presence of count, just instruct the jury, just like we do all the time on greaters and lessers, right? Like you cannot convict on a greater and a lesser offense. Here, you cannot acquit on this included offense and convict of the other one. And I think by telling juries that, not only are we likely to avoid the Terry problem, but you'll get them thinking good and hard about what they want to do. If they do want to exercise leniency for reasons of their own, then they should know what the consequences of that are going to be, that they can't do a split verdict in this way and have the split verdict stand. So be on the watch for that sort of thing.
All right. State versus Malloy is kind of a weird case. It gives us an answer to the question of whether opening a car door is a search. That also may have been a question that nobody really asked. So, facts of State versus Malloy. The police receive a report that someone fell asleep at the wheel, hit a light pole, backed into a parking stall, and then fell asleep again. I was talking to Jeff Gray in our office, who's our search and seizure guy who handled this case, and he was saying, oh, I just argued a case about someone who backed into a light pole and then passed out in their car. I said, oh, was that Malloy? No, different one. So yeah, for those of you, this is a common fact pattern, right? So an officer finds Malloy slumped forward, unconscious in the driver's seat of the truck. The officer immediately opens the door and sees evidence of drug paraphernalia at Malloy's feet. All right, so Malloy moves to suppress the evidence that's found, arguing that opening the door was a search because it was a physical trespass onto his property, and that the search was unreasonable. So we have a search, and it's an unreasonable search under the Fourth Amendment. So here's sort of how the Utah Supreme Court gets to its reasoning. So in Pennsylvania versus Mims, the United States Supreme Court held that once a motor vehicle has been lawfully detained for a traffic violation, the police officers may order the driver to get out of the vehicle without violating the Fourth Amendment's prescription of unreasonable searches and seizures. State versus Jones later picks this up and says, well, there's no functional difference between ordering someone to open a car door so they can get out and just opening the door yourself, right? It's the same thing. It's the same intrusion onto the the private space of the interior of the car. The only difference is that in one, the owner of the car is opening the door, and in the other, the police officer is opening the door. All right, so that's back in 2000. Since then, in State versus Jones in 2012, the U.S. Supreme Court held, well, there's not just one theory of search under the Fourth Amendment. There are actually two. There's not just protection of a reasonable zone of privacy, there's also a theory of physical trespass. And so here, the officer, the reasoning goes in Malloy, the officer physically trespassed onto the car by opening the door himself, and so that must be a search. So then the Utah Supreme Court says, all right, well, we've decided that opening the car door was a search. We're going to decline to address whether the search is reasonable, though, because an officer could have opened the door anyway under our prior precedent, and so the officer, by opening the door here, would have acted in good faith under Davis, and so there's no need for suppression. So, end of the holding here, opening a door of a car is a search under the Jones physical trespass theory of the Fourth Amendment. All right, there's an epilogue to this case, which is, this is not the question that anybody has ever actually asked here. So, the state has filed a petition for rehearing, and the last I heard from Jeff Gray about a week or two ago is that the Utah Supreme Court has ordered a response to be filed to it, which is not particularly common, so they may actually be taking this seriously. But we pointed out, well, look, the court's just answered a question that nobody's really asked. So look back at Pennsylvania versus Mims again. Once a motor vehicle has been lawfully detained for a traffic violation, police officers may order the driver out of the vehicle without violating the Fourth Amendment prescription of unreasonable searches and seizures. So we, as the state, would agree that opening a car door is a search. It's always been a search. It's been a search since Mims. It's just not an unreasonable search in the context of a traffic stop. And so if that's true, if opening a car door is a search in this context, but it is not an unreasonable search, then arguably James is still good law. And if it's reasonable to order someone to open a door, how is it any less reasonable to just open the door yourself? So that is still pending. Takeaway for all of you guys, opening a car door is a search, and we think it's always been a search, and we would like the Supreme Court to actually answer the questions that we've asked. But is that too glib, or?
I will rarely say that something is too glib. My career has been made on glib statements, so I'm probably the wrong audience for that. All right, Lehigh City v. Rickabaugh, First Amendment case about the Electronic Communications Harassment Statute, City Council meetings, and Kevin Bacon. And yes, I promise these all relate. Question number one, is the Electronic Communications Harassment Statute vague? Answer, nope. Is it overbroad? Also nope. So, yay. All right, here's Geneva Rock's digging operation out at Point of the Mountain. I'm sure everybody in this room has driven by it 100 times as you've rounded the corner out of or into Utah and Salt Lake counties there. Now, they've been out there forever, right? Certainly when I was a kid, I remember when I-15 still had just one or two lanes going north and south each way as we headed down to BYU games back in the late 80s. But turns out that a lot of people live out there now. There's a lot of people, especially if you've been to Traverse Mountain lately. Lehigh has exploded all the way to the border up there practically with Salt Lake County, out to the west to the Okers. It's all filling in, right? We're all seeing this. And so the old law school idea of coming to the nuisance comes to mind, but a whole bunch of people move in next to Geneva Rock and all of a sudden get upset that Geneva Rock is doing what Geneva Rock has been doing for decades. So people have very strong feelings about this and what goes on out there. So Geneva Rock decided they wanted to expand their mining operations a little bit over there, and a lot of people living in Traverse Mountain there in North Lehigh and in Draper to the north didn't like it, and there are a whole bunch of city council meetings about this. And if you've been to local government council meetings, you know that these things can get just a little testy.
Right, we'll start the meeting, and I want to repeat what I said at the beginning of the last meeting, that this meeting has not been called according to the law. The law has been broken.
It has been properly
Will you
called.
please let the Chairman
Weaver, please.
speaks.
If you disrupt this meeting, I will have to remove you from it.
You can't.
It's only the chairman who can remove people from a meeting. You have no authority here, Jackie Weaver. No authority at all.
She's just kicked him out.
I
No, she's kicked him out. Don't. She's kicked him out. Don't.
This is a meeting called by two councillors.
Illegally?
You may now elect a chairman.
No, they can't because the vice chair's here. I take charge. Read the standing orders. Read them and understand them.
Anyway, it gets kind of testy. I had another clip of a guy who goes to a California City Council meeting, and he goes on everything from alien mind control to secret government meth-producing operations in the hills of California. It looks like it's not going to play for me, but if you Google like funny City Council meeting, it's good stuff. Anyway, these things can get a little weird, right, sometimes, a little testy. And this one was no exception, though it was certainly more dignified than the examples that I had there. These are actually two different meetings, same councils. On the left is Robert Ludlow. He lived in Traverse Mountain, and he wanted to play nice with Geneva. What he wanted, and what a lot of residents of Traverse Mountain is like, look, Traverse Mountain lacks two pieces of infrastructure that are really crucial for us. We don't have an elementary school, and we don't have a church building. So that means we have to drive all the way across the freeway. And if you've tried to, they've got it flowing pretty well now, but especially during construction, if you tried to get from Traverse Mountain to like Thanksgiving Point or any other point down in Lehigh, it was a mess, right? And if you had to do that every Sunday for church and every morning to take your kids to school, I sympathize somewhat with Mr. Ludlow's desire to get things moving along and play nice with Geneva. And he thought, well, maybe we could work out this swap. They can expand their mining operation over on this corner, and they'll give us some land so we can build a church and a school right here, so it can be one-stop shopping here for residents of Traverse Mountain. On the right there is Mr. Jason Rickabaugh at another, I think this was a city planning meeting, and then it was city council on the left. He was a resident of Riverton, but for some reason had very strong feelings about expanded mining and spoke out against it, as did most other residents. Mr. Ludlow was decidedly in the minority of people who were voicing concern. Then things got really testy after the meeting. Mr. Rickabaugh went home, cracked open a few cold ones, cracked his fingers, and started typing away. And between midnight and about 1 a.m., he sent Mr. Ludlow a bunch of Facebook messages saying things like this. I'll let you just take a look at them. Some of them are almost incomprehensible. Some of them are just kind of funny. But a number of them did appear to be fairly threatening. And they were sprinkled with generous Kevin Bacon references. Anybody know why he would reference Kevin Bacon? Footloose was filmed in Lehigh. Yes, thank you. And Lehigh residents take great pride in that to this day. But he would say things like, oh, are you too cowardly to cross Kevin Bacon's railroad tracks to take your kids to school? He thought that was a good insult. I think his insult game needs a little work. But at any rate, he was charged with violating Utah Code 769201, which is our electronic communications harassment statute. It requires somebody to have intent to intimidate, abuse, threaten, harass, frighten, or disrupt the communications of another, and then making repeated contact, making threats, basically doing constitutionally unprotected things like making a true threat or saying something that is likely to provoke a violent or disorderly response. I've left out some variants not at issue here, but he argued that all of these provisions were vague and or overbroad, both as applied and on their face. So, well, I won't get too far into detail because it's not super helpful, but I think the global tests will be helpful to you if you get one of these. I just got another one related to another statute, but this particular attorney seems to have made a cottage industry out of challenging things under the First Amendment. Everything, according to her, that I've seen is overbroad and vague, both as applied and on its face, even though as applied overbreadth is a contradiction in terms, I think. Okay, so overbreadth. It's an exception to the general rule of standing. Most of the time, if you're going to challenge something as unconstitutional, you have to be the one that's injured, right? We see this in Fourth Amendment cases all the time. If a privacy interest in something, you don't have standing to challenge even the most egregious privacy violations of somebody else. So you have to be the one that's injured. Now, the court created this exception for overbreadth because they thought, well, in the area of free speech, we want to have enough breathing room that people aren't self-censoring too much. We're not chilling protected speech. So we're going to let people, even if you can look at the statute and say, well, what you did was clearly covered here, we're going to let them raise the free speech interests of other people not before the court because we want those rights protected sooner rather than later. We don't want somebody to have to violate the law in order to challenge it. So that's the basic idea behind overbreadth. This sweeps in too much constitutionally protected activity. But if you get one of these, you can just shoot me an email. I've got tons of briefing on overbreadth and vagueness. And what they often miss is, even if they can come up with a couple of examples, it's like, well, here's one example of a person who might self-censor. Could you get me a little bit of water? Sorry. I'm not getting emotional. I just probably ate that granola bar too fast. Sorry. But again, it can't just be a little bit of protected speech. It has to sweep in a substantial amount, is the language from the cases. So as the court correctly said, this is Judge Pullman writing, they say, no, this was not overbroad, and we only need to look at one subsection to uphold the statute, because if his conviction was valid under one subsection, then who cares if another subsection was overbroad, right? Thank you, Dave. Sorry about that. So one of the subsections they were saying was overbroad was this insults, taunts, challenges the recipient in a manner likely to provoke a violent or disorderly response. Clearly, this is just aimed at what we often call fighting words, right? Under Chaplinsky v. New Hampshire in that line of cases. And defendant argued, well, hey, somebody could be convicted merely by saying something subjectively offensive, but that's not true. If you look at the statute, it says somebody has to act with the intent that. So you're not just focusing on a sensitive listener who will think, oh, you just threatened me, you know, which these days, I suppose, is an increasingly valid concern. But you focus on the intent of the speaker. So the court says no overbreadth problem there. He also said, well, this specific intent requirement not only doesn't cure the overbreadth problem, it causes an overbreadth problem, because look at all these examples of things that would fall under that. He said, a boss could threaten a worker to do a task or they will get fired. Or a political canvasser trying to get out the vote will intentionally annoy people. Or retailers sending spam emails. But I thought the hardest question really was the boss threatening a coworker, and the distinction that I made was there's a difference between a threat of violence. I mean, your boss isn't going to threaten to beat you up if you don't finish your TPS reports, right? The most they can do is fire you. So if they're threatening to do something they're legally entitled to do, I don't think that would fall under being a true threat anyway. But the court said, well, we're not just going to consider that. And even if one or two of those might arguably be swept in, you haven't shown a substantial amount of protected activity that's swept in. So that's just not overbroad. And again, the intent helps prevent overbreadth, not causes it. So overbreadth is mostly it's mostly been applied in the First Amendment context. Arguably, the court has used it from time to time in the abortion cases, so I'm not going to say it's always exclusively a First Amendment issue, but that's 99% of the time where you see it. Vagueness, by contrast, even though whenever somebody makes an overbreadth argument, they also make a vagueness argument, they travel together that way. Vagueness is about notice under the Fifth Amendment. The question is, would somebody reading the statute know what it is they do to violate it? And another aspect of that is, would a cop looking at that statute know what it is, know what a violation is if they see one in the wild? And if neither of those things can be said, then you have a vagueness problem. So it's about notice, right? Notice to the person of ordinary intelligence of what conduct the statute prohibits, and then notice to police and prosecutors sufficient to prevent arbitrary and discriminatory enforcement. So the classic case of vagueness is you had this, I think it was City of Chicago v. Morales, That was a loitering statute, wasn't it? Like, there are other cases too, but basically the idea there was you had a statute that said you can't annoy passersby. It's like, well, what does annoy mean? What's annoying to one person? That's not an objective standard by which somebody could tell if they were being annoying to others, or a prosecutor could say, that's, as a matter of law, you are annoying. Though I think there are certainly cases we could ask for judicial notice of that, right? Yeah. Of course, it says, look, this isn't vague. The mental state, again, helps to narrow the statute's application. And his threats were clearly prescribed under the fighting words exception. So kind of a fun little case, but good if you deal with, I think, this particular attorney who goes up and down the Wasatch Front saying everything is overbroad and vague. Oh, we got 30 seconds to a break, so let's take our, I guess it's break for lunch. Let's get some lunch here. Actually, no?
Don't let him go just yet.
Okay. Don't go just yet.
Okay, so here are the nominations for the SWAT board for the juvenile prosecutor position. I will read off their names, and then I will go through their qualifications, and then I will put up a slide that has my name and phone number and Marilyn's name and phone number so that you can text your vote. And we'll leave that up for about 20 minutes while you all eat. Okay, so in no particular order, this was just the order it was sent to me. Nominee 1, Paul Wake, works for the Utah County Attorney's Office. Paul has been a juvenile prosecutor for over 2 decades and has been on the Juvenile Rules Committee, SWAT Black, and other committees, and would be happy to serve on the SWAT board. As he says, my approach as a juvenile prosecutor is to help kids by holding them accountable and helping their families work on their moral development. I'm convinced that HB 239 has been a good way to accomplish that. The less adversarial team approach we're more accustomed to in Utah County has done a decent job of accomplishing that goal, but we juvenile prosecutors can always improve. If elected to the board, I would certainly be very open to input from juvenile prosecutors across the state interested in improving communications within this community and inclined to see if we could return to the biennial juvenile justice conferences of yore. Next, Ryan Perkins from Davis County. Ryan has been a juvenile prosecutor for more than 20 years. He has been very active in working with legislation over the years relative to juveniles and juvenile justice. He is passionate about serving the community and the youth of Davis County and the state of Utah. I think he would be a valuable voice for juvenile justice on the SWAT board. Eric Butler in the Uinta County Attorney's Office. Eric is the sole prosecutor on the juvenile delinquency cases for Uinta County. Mr. Butler has been an attorney for approximately 14 years, and prior to that, he served the country as a United States Marine. Currently, Mr. Butler handles all juvenile delinquency proceedings through every single stage, including the investigation and filing of petitions through to resolution. Prior to his time at the County Attorney's Office, Mr. Butler was an Assistant Attorney General in the Child Protection Division, where he represented the Division of Child and Family Services in child welfare cases. Mr. Butler also has in-depth experience working with Native American tribes and families, as the Uinta Basin is also home to the Ute Indian tribe. Next, Angela Adams from Washington County. I have been prosecuting delinquency cases in juvenile court in Washington County exclusively since 2003. I have identified issues in the Juvenile Court Act in the past and have been active in bringing them to the attention of the appropriate legislators, and am interested in the policy-making process. I have prosecuted all of the special victim offenses in juvenile court in Washington County for many years, so have a specific interest in advocating for victims. And last is Adriana Davis with Salt Lake County DA. I have been a prosecutor for over 12 years, beginning with the Salt Lake City Prosecutor's Office and then transitioning to the Salt Lake County Attorney's Office, where I was assigned to the juvenile team for my first 3 years. After 2 other assignments, I returned to the juvenile team and am currently the supervising attorney overseeing the downtown juvenile team. I participate in the Juvenile Drug Treatment Court, which can be particularly rewarding. 2 years ago, I was able to attend juvenile-specific training at the NAC, where I made valuable contacts with fellow prosecutors and experts in the field. This has been a tremendous resource as we navigate all the changes in criminal justice. My passion lies in juvenile justice and prosecution. I believe I would be a valuable asset and voice of the SWAT board. So like I said, I will bring up a slide with all of their names, where they're from, and then, as I said, either mine or Marilyn's cell phone. Please only vote once. Okay. So there's 2 serving tables for those of you that are here. You guys at home can go grab some lunch. There's 2 serving tables, so this half of the room, if you go out these doors and get the food on that side, this half of the room, go out those doors there, and we'll give you about 20-ish minutes. Let's see, Vince, we're on, right? Vince, we're good to go. Okay. So for those of you in the room, if you haven't voted, here's your last chance to capture our cell phone numbers. Those of you at home, same thing. And here's my final comment. Let's see. Here, you don't want to see it that way. Course evaluations. Last, I'll harp on course evaluations. Let's see. If you complete it before June 15th, that's good. If you wait for 2 years, that's bad. So there we go. Please don't put off your course evaluations. Okay. No, June 15th is good. I guess I should have said anything after June 15th is bad. Thank you for that clarification. Anything after June 15th, bad. All right. Thanks, guys.
Oh,
yeah, nothing.
I'll leave my coffee behind. One of the very few bright spots of the pandemic is being able to drink coffee while I'm arguing in the Court of Appeals. And you may be wondering to yourself, well, doesn't that mean you risk spilling coffee on yourself while you're arguing in front of the Court of Appeals? And I can say from experience, yes, it does. All right, so one of the things we have not talked about so far in this entire presentation, despite how long we've dragged you through all of this, is the U.S. Supreme Court. This has been kind of a quiet year for criminal cases coming from the U.S. Supreme Court. You have your standard federal criminal cases. You have the ceremonial slapping down of the Ninth Circuit with a ruler that begins every Supreme Court term for the last 20 years or so, but relatively few cases that are relevant to our work as state prosecutors. Here's one, and it's almost kind of more of a curiosity than it is something that'll affect you every day, but interesting nonetheless. So this is Torres versus Madrid. It's a 1983 case, and the question presented is, if police shoot a suspect, but the person gets away, is that person seized for purposes of the Fourth Amendment? And somewhat surprisingly, if I just asked you that question in the abstract, the answer is actually yes, according to the Supreme Court. There's a voting breakdown here. You have Roberts in the majority, joined by Breyer, Sotomayor, Kagan, and Kavanaugh. You have a dissent from Justice Gorsuch, joined by Thomas and Alito, and Justice Barrett did not participate. I won't talk about the dissent at all, except to say that after reading Justice Gorsuch's dissent, I was really kind of surprised at the kind of nasty and personal tone of it. Maybe you disagree with me, but I kind of came away from it thinking that dissent was a little more vinegar than it was honey. But all right, turning to the case itself. So this is, as I said, a 1983 suit out of Albuquerque, New Mexico. The facts are heavily disputed because this comes to the court before an actual trial, but viewed in the light most favorable to Torres, who is the plaintiff here. She thought that the police were carjackers and tried to speed away from them. The police then shot her several times, but she managed to escape and get away. She drove to another town about 75 miles away, checked into the hospital there for her bullet wounds. She was promptly airlifted right back to Albuquerque. Police found her in the hospital, and she was arrested the next day. All right, so in order to settle this case, the court has to look at originalist history. And so again, we have the breakdown here for the appellate attorneys and the trial attorneys, the originalist history for all of you trial attorneys out there, and then for the handful of appellate attorneys, this is how we look at originalist history. I will keep it very light. There's pages and pages and pages of old-timey cases. I'll just give you my favorite. At common law, basically, the majority says merely touching someone was enough to arrest them, even if you didn't actually succeed in taking them into custody. And they cite a bunch of examples, but my favorite is the Countess of Rutland's case, where the sergeants of the mace, quote, showed her their mace and touching her body with it, said to her, "We arrest you, madam." Because I don't do trials, I just do appeals, I assume that's how most arrests go, right?
Yeah.
Okay, that's how it works. Good. So according to the majority, the application of physical force to the body of the person with the intent to restrain is a seizure, even if the force does not actually succeed in subduing the person. There are a couple of critical limitations to this that are kind of bound up in that rule that I just gave you. One is it requires an intent to restrain, so accidental force or force applied for other reasons doesn't qualify, so police are not going to seize somebody if they accidentally run into them with their car in a traffic accident. Intent is also purely objective. It does not depend on the officer's subjective motivations or on the suspect's subjective beliefs. So that's consistent with sort of the post-Brigham City approach to most of the Fourth Amendment, that we are not concerned about looking inside people's actual heads. We just look at it objectively. And the seizure lasts only as long as the force lasts. So the Fourth Amendment does not recognize any continuing arrest during the period of fugitivity. So as I understand it, in this case, Torres would have been arrested or seized when she was shot, but the whole arrest or seizure was not continuing on after that. In terms of looking forward, the court declines to address non-physical touchings or things like pepper spray, flashbang grenades, lasers. The dissent takes them to task for not talking about flashbangs and lasers, and they say flashbangs and lasers are a question for another day. As I said as well, this is a 1983 case, so it's kind of worth thinking about how this rule might interact with the exclusionary rule. You would think this would be particularly relevant to circumstances where you're dealing with an unlawful use of force or an alleged excessive use of force. And that in a case like that, it's very much in the interest of civil plaintiffs to be able to say, well, this is a seizure under which the Fourth Amendment qualifies. For the criminal context, it would take some sort of more unusual circumstances, because you would need to be able to tie the unreasonable seizure to some sort of evidence, right? You'd need to have some sort of causal link there. Torres doesn't really discuss this because it's only a suit for damages, but you might imagine in a case like this an argument being made by Torres, for instance, that, well, I was only in this hospital and I was only arrested as a result of having been shot in this unreasonable arrest, and so maybe my later arrest at the hospital should be suppressed because it's a fruit of that initial unlawful arrest. You might see questions along that. We might respond to that by arguing the attenuation doctrine, a new kind of weird corner of Fourth Amendment law, not necessarily particularly relevant to what you might be doing day to day, but if you do come up with a situation where you have an officer who tries to arrest somebody, applies force, and then that person is only apprehended later, Torres versus Madrid might become relevant.
Okay, State v. Williams, quick case about whether a 911 call is testimonial. Actually, a couple of questions here. So first, is a 911 call testimonial where the subject in a violent crime is at large and the victims are seeking medical help right after the attack? No, it's not. Question 2, does this phone call qualify as an excited utterance? Yes, it does. Pretty sure this is Mr. Williams from his Facebook page there. One night while high on meth, he saw his father's motorhome parked at a business in Midvale. It was actually a po' boy's carpet. You get the idea. He tore the door off of that. I don't know why he was mad at his dad, but he decided he would tear the door off the camper and assault his dad and his brother and beat him up, and then he ran away. So his dad called 911. Here are some excerpts from that. If you listen to it, it has a very distressed tone and labored breathing. He says things like, "We just got assaulted." There's a heavy sprinkling of profanity from evident pain. As he's breathing in and out, he's swearing under his breath and sometimes not so under his breath as he's waiting for the operator to get down, dispatcher to get down some of the details. He says, "I got injuries. He kicked the shit out of both of us, and he's in effing danger." So this is the phone call going on right after the son left, Mr. Williams. So by the time of trial, neither dad nor brother was cooperating. So the state relied mostly on, first of all, the 911 call, and then a few pictures of dad and brother's injuries. So the two issues here is, was the 911 call testimonial, and if not, did it qualify as an excited utterance as an exception to hearsay? So little quick recap on Crawford. There's the Sixth Amendment. We know it well. And there's Crawford. Basically, you have to, if something is testimonial, then the witness has to be both unavailable and the defendant must have had a prior opportunity to cross-examine. Davis was a later case in the Crawford line that said, basically, whether something is testimonial turns on the primary purpose of the statement. Even if somebody is speaking to police officers, for example, even though that's quintessentially the testimonial circumstance, it depends on what they're trying to get out of the interaction. If they're sitting down and saying, okay, yesterday somebody came to my house and tore the door off and did this and that and the other, that's testimonial. But if it's out, I'm sitting in Davis, it was bleeding to death in a parking lot after being shot. Here it's, calling up 911 and swearing up and down that you're injured and that your son did it and that he's a danger and needs to be taken into custody. Is there an ongoing emergency or not? And we also had Hammond v. Indiana, that same term, said if the emergency is over, then it's testimonial. So the big question in a lot of these cases is there still some emergency? Is there somebody at large? Are they still armed and dangerous, as it were? Or is this kind of the standard police interview? Here you can kind of hit the easy button. This is almost identical to Davis, albeit the call happened right after rather than during the actual assault. But it's the same purpose, right? The victim is complaining of pain, saying he's a danger, all that kind of stuff. So not testimonial. So did it qualify as an excited utterance? Something is an excited utterance under 8032 if it is a statement relating to a startling event or condition. I'd say that qualifies, right? Ripping somebody's camper door off and going in and beating them up. While made while the declarant was under the stress or the excitement that it caused. It really helps here that we had labored breathing and profanity and everything else. Shows that his adrenaline is still pumping, right? That's the very definition of being under stress. And under West Valley City v. Hutto there, you need a startling event statement made under that stress, and it has to relate to the condition. It can't be like, you're under the stress from your son breaking in, but you offer your opinion on, Dogecoin or something like that. It has to relate to the startling event or condition. Again, you can hit the easy button. Having someone rip your door off and beat the crap out of you is a stressful thing. I think we could take judicial notice of that, right? And it's clear from the call that he was still under the stress and pain of the event. But one caveat on this, you may still have to redact the call because sometimes, and I'm sure you've seen this in police interviews before, it's evident that the person calms down, right? Maybe you have a really long interview, and for the first little bit, it's very chaotic. Maybe you have maybe you have a dash cam, or maybe you have a body cam or something like that. And for the first little bit, the person is saying what just barely happened, and they're clearly still stressed. But by the time hour 2 rolls around, their breathing has returned to normal. They're no longer wincing in pain, that sort of thing. That's when it's going to start crossing the line into testimonial territory. So be aware that just because you have a 911 call that starts out as an excited utterance, it doesn't mean that it stays an excited utterance for the entire time. So just be on the watch for that.
Okay, so talk a little bit about expungement. So State versus Malo is a case in which the Malo was charged with sex crimes against a minor. The crimes are pretty darn disturbing, but the charges end up getting dropped when the victim gets sick and isn't able to testify. So later Malo tries to expunge this from his record, and the state opposes it. And usually we say that bad facts make bad law, but sometimes I think good facts make good law, and I think we got some good law here in part because the facts of this case are so disturbing. So a couple of holdings here. One is that district courts can consider the bindover and any evidence presented at the preliminary hearing when deciding whether to grant expungement. So I said in Malo in this case was accused of doing some super skeezy stuff, and there's evidence presented of that at the preliminary hearing. The district court can take all of that evidence into consideration in deciding whether it's going to grant expungement. It's also okay for prosecutors to argue that expungement is contrary to the interest of the public, even if the prosecutor doesn't intend to refile charges. And that's because there can be multiple reasons why a prosecutor might not want to refile charges that are separate and apart from belief about whether the crime occurred. And so again, you have a case like this where you have a particularly skeevy set of crimes and some initial evidence that looks strong, but because the victim is not able to cooperate, they're not able to continue through with the prosecution. So in a circumstance like that, a prosecutor can continue to oppose expungement even if the prosecution has no intent of refiling the charges again.
And that's great, especially when you have a higher turnover in a jurisdiction, because you'd want that there so that when he does this again, and the odds are he's going to do this again, probably, if I don't know all the circumstances, but when in the event that this happens in the future, you'll have something that you can go look for some 404B evidence on, right? You don't know if by then the victim will have recovered and will be more cooperative and all that sort of thing. So keeping that kind of track record can be very helpful. Yeah, and in 404C, of course, that kind of evidence. So I think, like Dave said, it was a good result for us, and not just because of the case and for expungements itself, but for what it represents for future cases and being able to track that down. When you lose institutional memory, maybe the prosecutor leaves or retires or whatever else, and nobody remembers that, hey, didn't this guy do this before? State v. Butters, this is a case about the residual hearsay exception. Two questions here. First, if the evidence is admissible under a specific hearsay exception, if certain requirements are met, is it admissible under the residual exception if you don't meet the more specific requirements? The answer is no. And question two, does mistakenly including secrecy language in a subpoena render the evidence received under it excludable? So we'll talk about that a little bit. Here are David Butters and Mark LeCount. So Butters came up with a technology that he thought was, quote, better than Netflix. It was basically Redbox, but with USBs instead of DVDs. And I guess that would have seemed really cutting edge back when you had to go to the grocery store and actually get the DVD from Redbox rather than everything just streaming digitally. But anyway, he was really excited about this technology, passionate about this project. They solicited a bunch of money from investors to develop this and bring it to market. But stop me if you've heard this one, they didn't tell them about their past business failures and used the money, I know, shocking, to do things other than what they said they were going to do with it, to pay off other business debts and so forth, right? I can't believe it happened, but the one time that it happened, we caught them. Super shocking. So to show the fraud, as the state always does in these kinds of cases, they had to follow the money, right? So to follow the money, you have to get a bunch of bank accounts. So the state subpoenaed a bunch of bank records. For some of them, they were able to get custodial certificates under the 900 series of rules, right? Like I always did this if I possibly could as a trial attorney. If I could avoid having a witness come in, better for us, better for them, at least for foundation stuff. So I would usually find some cooperative person in an organization, in a bank, in a phone company, in a whatever else, that I could get all that information, get it to defense counsel and show, okay, look, this is a self-authenticating record now. We have the foundation. Let's just move on with life and agree that these are the phone records or these are the bank records or whatever else. So in this case, the state was able to get those from some of the banks, but not all of them for whatever reason. And when it came to trial, they offered all of them into evidence, and the trial court admitted some of the ones that met the 900 series for foundation without a witness present. The court let in under that, and that was fine. But then the state said, look, we tried to get certificates for these other ones, but we couldn't get them. So please admit them under the residual exception, because it's close enough, right? Like they clearly look like bank records. It says Key Bank or Wells Fargo at the top or whatever, and this is the person's name, and it has believable transactions. It's got to be close enough, Judge. And the judge said, you know what, you're right. I'll let that in under the residual exception. Few rules at issue, here we go. 8036 says, is the business records exception kept in the regular course of business? It was a regular practice, all that stuff that's pretty well known to you, I imagine, at this point. And then 90211 says you can lay foundation without a witness present if you have a signed custodial certificate that's signed in a manner that, if falsely made, would subject the signer to criminal penalty. So similar to basically an 1102, but for foundation, right? And also, obviously, we're dealing also with the residual rule. So Rule 807 is just in case we've forgotten something or overlooked something that's a lot like this other stuff, but not quite this other stuff, then you might be able to get it in so long as you can show that it's trustworthy, essentially. It's circumstantial guarantees of trustworthiness, because the whole idea behind hearsay exceptions is, well, the idea behind the hearsay rule is we want people to be there for cross-examination and not to just convict somebody based on, or make a legal decision based on the word on the street, right? Or based on something that somebody heard and might have overheard wrongly and all that kind of stuff. But we also have exceptions to hearsay because sometimes the circumstances under which those statements are made show that it's super reliable, like a statement against interest. Why would somebody say something that got themselves in trouble unless it were true or whatever else? So 807 is just the catch-all for, it doesn't quite fit anything else, but it's enough like those other things that we really should let it in and let the jury decide. Now some case law. So Rule 807, this is from Clopton back in 2015. 807 is applicable when a hearsay statement is not specifically covered by a hearsay exception in Rule 803 or 804. And it's intended, said the court in Nelson, for those rare cases where, although an out-of-court statement does not fit into a recognized exception, it's justified by the inherent reliability of the statement and the need for its admission. So bottom line, you shouldn't use this very often, and you can't use it when the evidence that you're trying to get in is covered specifically by another hearsay exception. So applying that here, the bank records without complete custodial certificates or foundational testimony were not admissible. So the state never said it couldn't have laid the right foundation. It's like, well, so you're having trouble getting a custodial certificate. Send a subpoena. Like, I know it's a pain for you, it's a pain for them, but maybe if they get a subpoena, they'll say, oh, you know what, I would prefer to sign a paper rather than having to head down to Provo or head up to Weber or whatever else and give live testimony in court. Just to sit down outside the jury, well, sit down outside the courtroom for 2 hours, be called in, give 5 minutes of testimony, and then go home. So that might actually promote cooperation, right? But it's not enough to get it in under the hearsay exception because it's covered. But again, don't use the residual hearsay rule that much, and if you do, you better have a good reason for it. One more quick issue on this: the state subpoenaed the bank records that included a secrecy warning, but did not get a secrecy order from the court. So there's the code section covering when you get a secrecy order, when one is appropriate. But is it true that you always need a secrecy order in these kinds of cases, or is that mostly the prosecutor's call? Do people get secrecy orders as a matter of course on this? Do you seek those very often? I'm seeing some shaking of heads, so maybe this was just an exceptional case, or it was prosecuted exceptionally, in an exceptional way. The court said, well, that was inappropriate to include the secrecy order in this particular case, but just a violation of the state statute isn't grounds to suppress it. And by the way, even without the secrecy language, he wouldn't have been able to quash the subpoena, so no prejudice there. So no big deal.
Okay, next case I'm going to begin with a little quiz. When you look at this stock photo, what do you see? If you answered a normal family, then congratulations, you are correct. If you answered a threatening Mexican drug cartel, congratulations, you are a racist. And you also might be Nicholas Seach. So the facts of this case are just absolutely bizarre. So a Latino family went to a public park, the mother and daughter went for a run, and the father and son stayed behind, and the father went for a ride on his bicycle. Seach apparently felt threatened by this and thought the family were Mexican cartel members. He accosted the family, spat on their car, said he was going to kill them, threatened them with a knife and a pellet gun, and shot up their truck. So really terrorized these poor people. At trial, he claimed that he thought his life was in danger and he acted in self-defense. He said that seeing the father riding on the bike made him uncomfortable, so he confronted him. And after some back and forth, he went to his car, retrieved a pellet gun, and shot at the family to scare them away. When he was asked why he was so afraid, Seach explained that it was based on the fact that there was an older Hispanic on a pedal bike, which he found suspicious, and that on his perception that father might be a construction worker and thus carry tools in the truck that he used that he might be able to use as weapons. So he's like really checking every racist stereotype box in front of the jury too. All right, so the jury instructions in this case end up being a little convoluted. The jurors are told a bunch of correct things. They're told the definitions of intentional, knowing, and recklessness. They're told that a defendant cannot be found guilty unless they have the required mental state. They are told that the state bears the burden of proof to prove the mental state. They're told that every crime that is not strict liability has a mental state. They said if no mental state, they were told if no mental state is specified, then recklessness is sufficient. And then the court said it would instruct the jury later about the required mental state in this case. However, the aggravated assault instructions themselves did not actually specify a required mental state. So you can kind of get there through all of the instructions that the jury was given, but it doesn't actually tell them what the mental state is for the charged crime, and even though the court said that it was going to provide that mental state later on. Seach argues on appeal that his counsel was ineffective for failing to object. The Court of Appeals was kind of wishy-washy on whether these instructions were actually incorrect. They basically admitted that, yeah, if you went to law school and maybe if you were a particularly smart person who chose not to go to law school, also probably a good sign that you're a smart person if you chose not to go to law school, you might be able to piece it together and figure out the correct mental state. But the court also wrote that the instructions were infirm, not completely accurate, or at least potentially problematic. Whether that's error or whether that's not error, I don't know. I think you could read it either way. Regardless, the holding is that there's no prejudice because Seach argued self-defense, which didn't depend on a mental state. So there's no question that in his case that his argument was that he had acted intentionally. He just said he had acted intentionally to scare them off because he was acting in self-defense. The final note, though, the court adds in a footnote that all of this confusion could have been avoided if the prosecutor had just provided the Muji instruction. So kind of again in the general theme of things, wherever possible, provide the Muji instruction and that'll give you a safe harbor.
All right, State v. Stephan. This case has a few issues, but hopefully a friendly reminder that will serve as about discovery issues and agreements with defense counsel. So a few of them here, 4 questions. Question 1, does Rule 412 require courts to admit dissimilar instances of abuse involving the victim and another perpetrator? No, it does not. Question 2, should prosecutors be really, really careful with discovery responses? Answer, yes. Question 3, should prosecutors be really, really careful with adhering to stipulations? Answer 3, double yes. And question 4, does the work product doctrine apply in criminal cases? Answer to that is yes, it does, as do its exceptions. So let's dive right in. Here's Jordan Stephan. He abused his girlfriend's 11-year-old daughter. Leading up to trial, he wanted to admit evidence that the victim was abused by her grandfather as well. So as with nearly all 412 issues, this comes down to the constitutional exception. Is this going to interfere with their right to present a complete defense if they don't get into this other stuff? He argued it did because the grandfather's abuse was necessary to rebut the sexual innocence inference, or the idea that basically no kid this young would have this detailed sexual knowledge without something having happened to them, something inappropriate. So the victim was 11 and 12 when all this happened, and I think she was 14 by the time she testified. There's one somewhat similar case in this area, State v. Marks, back from 2011. In that case, a step-grandfather was charged with abusing his step-grandson, and Marks wanted to admit evidence that the victim looked at some pornography and had simulated intercourse with his sister, even though the victim in that case was male, as was the defendant. So the court in Marks said, well, that's not close enough because he wouldn't have gained kind of sexual knowledge from that pornography and from that experience, the alleged experience with his sister, that he accused Marks of doing. So Stephan abused the victim in various ways that gave her some very detailed sexual knowledge about the male anatomy and sexual responses, let's say. The grandfather's abuse, though, was comparatively very mild. I think he watched her shower and he shaved her legs, oddly enough, and he touched her breasts. But the trial court said, that's just not similar enough. That's not just apples and oranges. That's like apples and watermelons or something like that. Way too dissimilar to come in. The Court of Appeals agreed with the trial court, said, no dice, no soup for you. So that one's pretty straightforward. But if you do get a 412 motion, just recognize that the more dissimilar they are, the tougher the row that defense counsel is going to have to hoe on that issue. Next, we're going to talk about unintentionally violating a stipulation. So in this case, like sadly many cases, the victim started cutting herself after the abuse. And defense counsel said, well, we want to admit grandfather's abuse because that provides another reason why she would be cutting herself, and not just because she cut herself because of Stefan's abuse. And the prosecutors eventually settled on, okay, we're not even going to talk about the cutting then. We don't want to go down this road. If it's potentially admissible, we'll just leave it out. And the issue dropped off, and nothing happened until the prosecutors played a version of the victim's CJC interview in which she said the words right at the end. She said, "I cut." And then defense counsel moved for a mistrial, saying, oh no, the prosecutors violated the stipulation. This is terrible. This is everything else. And the trial court said, well, I'm not going to grant a mistrial because now if you want to, you certainly can explore the cutting. If you want to bring in the grandfather evidence, then you can say, here's an alternative explanation for that. Defense counsel decided not to do it. Now, and I don't fault the prosecutors for this. As I understand it, they actually had 3 or 4 different versions of the CJC interview queued up and ready to go. Depending on how other testimony came out, it would render some portions admissible and other portions not. And it appeared, and they had even tested it before trial to make sure that all this cutting stuff was taken out. But for whatever reason, it kind of slipped through the cracks. So I don't fault them for it. This kind of stuff happens. But it was still unfortunate. Got to be careful. So trial courts have discretion to grant or deny mistrials, right? Because they're there to see what damage comes from it. But it's pretty clear from the cases that a court doesn't abuse its discretion in denying a mistrial if the remark isn't intentionally elicited, which was the case here. It's made in passing and it's relatively innocuous. So how big of a deal is this anyway, is basically what the court looks at. And yeah, I've seen worse. And there, the court basically just said, nah, this wasn't a big enough deal. It really was on the tail end of a whole lot of testimony. The prosecutors never drew any attention to it. They apologized for it. They said this was a complete mistake. Trial court believed them when they said that, and understandably so. So that just wasn't mistrial worthy. All right. A lot of this next part on the work product doctrine comes down to what happened with the victim's mother. So like all good prosecutors, the two here interviewed their witnesses before trial. Also, like good prosecutors, to avoid making themselves witnesses, they had somebody else there, right? I believe they had their paralegal present. So you want to have a paralegal, a cop, somebody who can talk about the conversation that isn't you, unless you want to be kicked off the case, but presumably you don't want to do that. So far, so good. You can interview victims and your witnesses and have somebody else there in case things go south or they change their story. Then the mother says something during that interview that really gets their attention. So she admitted that while driving the victim to the CJC, she urged the victim to lie and say that nothing happened. So this is a sadly common occurrence in especially familial sexual abuse cases. But it's also really good evidence if you're looking for a conviction. So the prosecutors, this understandably got their attention, but they were so excited about it, they forgot to tell defense counsel about it. So maybe they were just too excited, maybe they got caught up in other trial preparations, but this, for whatever reason, slipped through the cracks. And defense counsel heard about it for the first time during opening statement. And that eventually caused a mistrial. After the prosecutor one of the prosecutors gives the opening statement, defense counsel says, excuse me, I never got wind that the mother admitted telling the victim to lie. Can we talk about this? Ultimately, that ended in a mistrial. And between this trial and the next trial, the defense investigator also interviewed the mother. So now we've got all this controversy swirling around. What has mom said? When did she say it? And who knows what she said and how can we look at it? So defense counsel was pretty livid here. They're still upset about the late disclosure, and they demand the prosecutor's notes from the interview that they did with mother. And then the prosecutor says, fine, we demand your defense investigator notes from the interview with mother. So everybody wants each other's what's potentially work product, right? So how does this all shake out? Here's CrimPro Rule 16A. The state has to disclose a whole bunch of things, as well as any other item of evidence which the court determines on good cause shown should be made available. And then, of course, we have State v. Knight governing a lot of Rule 16 discovery that says if a prosecutor responds without requiring the defendant to get a court order, and that's the case almost always, right? I mean, I can't think of a single case where other than when you needed a witness's criminal history and you couldn't go to BCI and get it without a court order, and you just tell the court, look, we're willing to hand it over, we just need you to say, hand it over, so BCI will give it to us and allow us to share it with defense counsel. Absent that kind of thing, it's almost never the case that you force the defendant to get a court order to get discovery, right? Because of both our ethical and our constitutional obligations to turn things over. So fortunately, we avoid most discovery fights. But this is the kind of case where each side had something to fight about because they arguably had a reason to not disclose this stuff. So each party invoked the work product doctrine. And again, this is the context Rule 16, and State v. Knight says you either need to hand everything over as requested or explicitly identify what you're not going to turn over. And most of this is taken care of in your standard discovery letters, right? You've got your civil attorneys who have put together, or some criminal attorney who has put together, you now have discovery, you have everything that we have, and we'll keep you posted, essentially, whatever that particular notice says. And prosecutors have a continuing duty to disclose responsive discovery as things keep rolling in, which, as frustrating as it can be sometimes, I know what it's like. You think you have everything, you ask your cops 10 times, do I have everything? Yeah. Everything? You sure? Yeah. Everything? Yes. Get to trial. Here's another report. Awesome. Then you have to go give it to defense counsel and hopefully not cause a mistrial, right? You can also ask the court to limit disclosure. So in addition to the good cause to disclose, you can also ask the court to limit disclosure based on a, quote, sufficient showing to justify it. So the work product doctrine goes back to this old 1940s US Supreme Court case about a tugboat disaster. This boat went down and some people died, and the attorneys for one of the sides, I believe the attorney for Taylor, went around and interviewed a bunch of people about this tugboat disaster and had all of these witness interviews lined up to go. And then when they were getting ready for trial, Hickman said, well, Hickman, I believe, was a personal representative for some people who had perished in the tugboat accident, said, well, hey, we want all those interviews you did, because that's a huge pain to go around and interview a bunch of people, right? So Hickman v. Taylor recognized for the first time in US Supreme Court cases anyway, the idea that there's this thing called work product, that you cannot be required to disclose your thoughts about a case, your legal reasoning, your guesses about the odds of success, all that kind of thing that we get paid to do as attorneys, right? To put together a case, to get a theory, and all of the things that we do getting ready for trial, putting together questions and all that stuff. So anything, materials prepared in anticipation of litigation, and that contain an attorney's mental impressions and opinions and so forth. And the court said 3 decades later, in United States v. Nobles, that the reason we have this rule is we want to encourage attorneys to keep track of things and to interview witnesses, because if it were the case that you had to turn over everything you ever wrote down, how many things would you write down? Right? Nothing. And that would not serve the ends of justice, because then attorneys would be worse at their jobs unless they're like Dave and they had photographic memories and never forgot anything under any circumstances. You just can't do your job as an attorney unless you can expect that these things will not be discoverable by the other side. So perfectly understandable, rational rule. But the problem comes when the line between fact and opinion gets a little blurry, right? So let's say you're doing a witness interview and you're taking notes. Are you acting like a stenographer? Are you writing down every single thing this person is saying? I'm presuming, unless you're a stenographer, the answer is no. I'm seeing some shaking heads. What are you writing down? Yeah, you're writing down what strikes you as significant. In determining whether something is significant, are you exercising your legal judgment? Of course you are, right? You're like, especially if you've been around the block a few times, this isn't your first rodeo. You know what's relevant and what's not, what's useful and what's not. And presumably you're only writing down things that are useful. So even though you're just writing down facts, arguably you're exercising your legal judgment by selecting which facts to write down. Do you see how this can get a little bit blurry here? So this is where it gets a little blurry, but the general rule is facts deserve less protection than do opinions and mental impressions. I think that line can be a little bit hard to draw, but that's how the cases distinguish them. And though it's not explicitly in the criminal rules, we do have a rule of civil procedure, Rule 26, that probably applies, or at least before this case applied under Rule 81, because it wasn't specifically covered in the criminal rules, and the civil rules step in to fill the gap. You have to make a showing that the party seeking discovery has substantial need of the materials and that the party is unable without undue hardship to obtain substantially equivalent materials. So let's say mom had died in between the time that the prosecutors interviewed her and defense counsel was able to have their investigator go meet with the mother. The defense would have a stronger case if the mother was no longer around in order to get that kind of thing. That makes sense. You've got to look at all the circumstances. But if you just walk away with this remembering that facts deserve less protection than do mental impressions, and exactly separating those out, it can be hard in a given case. But I think for the most part, it's probably not going to communicate too much of your mental impressions. It's going to be pretty straightforward in most cases, so you're just going to have to figure that out. But fortunately, they did have a paralegal there. So what the prosecutors did here is say, okay, you can have our paralegal notes. The court said, you need to turn something over, and they said, okay, here's the paralegal notes. That way you're avoiding, here's what the prosecutor wrote down, right? Because it's just, you have a third party there. And presumably, even though a paralegal is kind of covered by a lot of the same rules that cover attorneys, especially now that we have licensed paralegal practitioners and they're getting to be more like quasi-lawyers in some respects. They were basically just able to say, here are the facts. Here's what mom said during her interview. It's in kind of an unfiltered way, not going through the attorney's reasoning. So what happened here? The state fought discovery for a while, but eventually turned this over. And Stephan had argued that by turning this stuff over, all of a sudden the state's waived their protections now, and he even sent subpoenas to the prosecutors to testify. This got really nasty. The defense counsel was very upset about this. The trial court said, hey, you got the facts from the interview. You haven't shown me that you need the opinion stuff. You're not entitled to that. And turning over facts doesn't waive opinion protections, especially where it was arguably under the court order anyway. And then with Stephan, so the prosecutor said, well, we want your investigator notes now. We had to turn over our paralegal notes, so do tell us what mom said to your investigator. And he said, well, that's work product. It's like, oh, you don't say. So the trial court split the difference a little bit here and said, okay, look, I will conditionally order the disclosure of those notes. Defense counsel, if you use that interview to impeach mom when she testifies, then you're going to have to turn that over to the prosecution so they know what you're impeaching her with. And I think that actually was the exact correct ruling. I think the court approached it in the right way. And then basically said you only have to turn over the things that you're going to use to kind of limit the scope of this to keep out potential mental impression stuff. So Stephan never used the interview at trial, so nothing was ever disclosed. Now to the Court of Appeals, Judge Hagan writes this one, affirming. Stephan was convicted. For the prosecution, they said, look, the court essentially ordered them to turn this over, so the prosecutor's notes are still protected work product. Them turning over their paralegal's notes did not waive protection in their own notes. And Stephan still complained on appeal. He said, well, the trial court's order was overly broad and used the wrong standard, and the Court of Appeals said, yeah, you're right, it was a little overly broad, but that really didn't matter here because there's no record of what those notes said. You never admitted them at trial, they're not here, we don't know what they said, so you can't prove prejudice anyway.
John, you don't need to sit down for this one. For all you Justice Court prosecutors out there, good news. Justice Court is constitutional. So this Taylorsville City versus Mitchell, there were a couple of constitutional challenges raised to the de novo appeals from Justice Court to the District Court. The Utah Supreme Court held that the appeals do not violate the state constitutional right to appeal, and also that they don't violate the uniform operation of laws. The The rationale being that there is a rational basis for distinguishing between justice court and non-justice court counties based on the size of the county and the needs to conserve resources. So that's it. That's all I have for that one.
Mic drop. Oh, State v. Nunez Vasquez, this is a case about Rule 412 and homosexual activity. Question number 1, does Rule 412 apply to same-sex acts? The answer is yes. Question 2, is a defendant entitled to a mistake of fact instruction, or under what circumstances? The answer to number 2 is sort of. If the facts support a mistake of fact defense, the instructions have to leave that argument open, but the trial court has discretion on exactly how the instructions do that. So we'll talk about both of these. This is Mr. Jaime Nunez Vasquez. He was heavily involved in the gay party scene, both personally and professionally. His stage name was DJ Poncho, I learned. He was apparently quite a popular DJ. And he met the victim at a house party. And then he, the victim, and a few others went party hopping at gay bars around town. And according to Nunez Vasquez, he understood that the victim was straight. Now, Nunez Vasquez had what he called, quote, a thing for straight guys. He said he found them, quote, attractive and considered it a, quote, challenge to get them to sleep with him. I don't know if he was trying to get them to switch teams or not, but he claimed to do this sort of thing fairly regularly. Like, this was his practice. He finds somebody who's straight and he targets them for fun. So through all the partying and drinking, everyone agreed, and this included Nunez Vasquez, that the victim did not flirt with or encourage Mr. Nunez Vasquez. So his charms apparently weren't working that evening. At the end of the night, the victim was pass-out, blackout drunk. He was just toasted. And he asked for a ride home, but instead of taking him home, Nunez Vasquez took him to his own apartment. And the victim said that he sat down on the couch and then he just blacked out, didn't remember a thing until he woke up the next morning. He was just so far gone. Here, of course, the stories diverge. The victim said he didn't remember anything until the next morning when he woke up in the embrace of Mr. Nunez Vasquez, who was also doing things to him. There were other details which I will spare you, but it made it very clear to the victim that Mr. Nunez Vasquez had had sex with him. So he immediately called the police and reported a rape. Nunez Vasquez said that the victim, through, again, details that I will spare you, initiated cuddling and sex with him. So what do we do here? At preliminary hearing, the victim said he was straight and he had a girlfriend, but that he liked to party with his gay friends, so that's why he was out that night. Leading up to trial, defense counsel discovered also other evidence that the victim allegedly had had sexual encounters of one stripe or another with other men, and he had moved to admit those instances for 2 reasons. 1, to support his defense under Rule 412, and 2, to impeach the victim under Rule 608C. So here's Rule 412. We'll do this one first. Of course, it's the constitutional exception, evidence whose exclusion would violate the defendant's constitutional rights. So the implicit premise of the defense motion was that most people aren't gay, and thus they are not likely to consent to gay sex. By being willing to have sex with men on another occasion, the reasoning goes, he was more likely to consent or initiate sex with Mr. Nunez Vasquez. The problem with that reasoning is that it runs headlong into Rule 412, right? Like, consent to sex with other people at other occasions is simply not relevant to consent with this person on this occasion. Now, consent with this person on other occasions might be relevant under 412, right? Or if you're trying to prove that somebody else was the source of physical evidence or whatever. But if you're going under the constitutional exception, that's just not a viable theory. You can't use this kind of reasoning to get this kind of evidence in. So the constitutional exception usually invoked is this one. It's called the constitutional right to present a defense. It's mostly a conglomerate of the 5th, 6th, and 14th Amendments to due process, confrontation, and compulsory process. And the basic idea is you need to be able to bring in witnesses. If you have a viable defense, something that the law recognizes as a defense, then you should be able to, by hook or crook, get the people into court to let you assert that defense. And defense counsel often interpret the right to present a defense as anything that I want to do to defend my client. But of course, it's not that limitless, right? Michigan v. Lewis recognized this particularly in the context of rape shield laws. You need to show more than just that it excluded defense favorable evidence. The exclusion has to infringe on a defendant's, quote, weighty interest and be arbitrary or disproportionate to the purposes the rule is designed to serve. For 412, the reason we have 412 is that 403 wasn't working in the old days. We needed a specific rule in order to encourage victims that if they came and reported a sexual assault, their sexual history, they themselves would not be dragged through the mud and put on trial for things that they did with other people at other times. And this increased reporting and increased accountability. All right, so that's Rule 412. He also argued Rule 608C. Here's the money language. He said that this was evidence of bias, a motive to misrepresent. He had an interest in his sexual identity, purportedly, as being straight, and therefore he had a motive to lie and say that he had no homosexual sexual experiences in order to protect, say, his relationship with his girlfriend or his identity as being straight. So we had a 23B hearing on this. We went down and took more evidence. We called a timeout on the appeal, went down and took more evidence in the trial court to get evidence in the record for an ineffective assistance claim, then came back up. Tellingly, though the two men that he said were witnesses to other sexual activity came in, they never testified that they actually did anything sexual with the victim at all. One of them said, I think, that he kissed them, and another that he kind of came onto him or something. But there wasn't nearly as much there as defense counsel initially proffered. And perhaps because people change their stories. For my first trial was the day after I was sworn into the bar. And I was talking to a witness in the hall. It was a little DUI case in justice court. And I was talking to a witness in the hall, and I said, okay, so what did his driving pattern look like? Oh, he was all over the road, looked like he was drunk. I'm like, thank you, awesome. So I call her, get her on the stand 20 minutes later after we pick our little 4-person jury. I say, who are you? How do you know? Did you see this person that day? Yeah. Did you notice anything about his driving pattern? No. Was he weaving all over? No, just driving normally. She just totally turned 180 degrees on me. And I was a young prosecutor. Like I said, it was literally like my second day on the job. And I didn't have somebody with me while I was chatting with her idly in the hall and had no idea she would change her story. So I get that people change their stories. I'm not trying to bag on defense counsel too much here. But interestingly, there was not a whole lot of there. And we said, this doesn't show a motive to misrepresent anyway. If he says nothing about his sexual identity, then he has no motive to protect the identity he didn't bring up. So the Court of Appeals affirmed and said, look, because the victim did not discuss his sexuality at trial, there was nothing to rebut and no sexual identity to protect. And tellingly, by the way, if this did come in, it would just have shown the jury that he didn't cry rape. I think the prosecution would have had a fantastic argument to say, yeah, it's true that he came on to other men, but he never came on to Nunez Vasquez. So, and he didn't accuse those other men of rape when this other stuff happened. So I think it actually would have made conviction possibly more likely. And it certainly wouldn't have helped him. And what's more, by the time of trial, the victim had a TBI from a motorcycle accident, traumatic brain injury, and he blacked out. So defense counsel was able to make some hay out of that and just say, well, gosh, you don't remember so many things about your life. How can we trust your account of what happened that night? So he had other ways to assert his defense, essentially. And they also said, well, no, this isn't bias because it doesn't show that he had something to protect. And he had a traumatic brain injury, so defense counsel had a means of impeaching this guy anyway. A quick jury instruction issue. The defense theory here was that even if the victim didn't consent, defendant was reasonably mistaken as to his consent because of the many alleged physical cues that the victim gave him, which I will continue to spare you. And to support this, he asked for 3 very extensive mistake of fact jury instructions that basically spell out from case law exactly what a mistake of fact defense constitutes. I've paraphrased them here. You can look at the materials online if you like. But the trial court basically said, I'm not going to give your proposed instructions. I think it's kind of confusing. I think the elements instructions cover this just fine because the state has to prove that he at least recklessly disregarded a risk that the victim was not consenting. That includes the argument that you want to make. You can say, I had good reason to believe that he actually was consenting. So the instructions allowed him to argue mistake of fact, just not as explicitly as he would like. Here are the rules on this. A party has a right to instruct the jury on its legally valid, I should say, theory of the case, if evidence in the law support it, but no party has a right to dictate the form that those instructions take. That's actually up to the trial court, if you look at Rule 17 of Criminal Procedure and associated rules and associated cases to that. And the court said, yeah, there was plenty here for defense counsel to make that argument.
Just one additional thought on the interaction between sexual orientation and Rule 412. This also came up again in an opinion that was issued just a couple of weeks ago, State versus Steele. There's sort of a weird ineffective assistance of counsel gloss on that case, so the court doesn't address some of the 412 issues directly. If you have a 412 issue involving sexual orientation, please reach out to us. I think both of us have done extensive briefing on the issue. Good rule of thumb, though, is that a defendant cannot use a victim's sexual orientation as a sword unless the state first uses it as a shield. So if the state opens a door by saying, well, he never would have consented with this defendant because of their sexual orientation, then a defendant can rebut that, but otherwise it's off the table. Okay, I said there weren't very many U.S. Supreme Court cases, but here's one important for you all to know, that you can subpoena the president if you want to. So the questions presented in Trump versus Vance, which are really interesting for sort of separation of powers purposes, but maybe less interesting for your day-to-day work, are: can a state court issue a criminal subpoena against a sitting president? And if so, does the Constitution require a heightened standard of need? And the answer to both of those questions is no. The answer to the second question is no. Wow, I should correct that. Because a state court can issue a criminal subpoena, but they don't need to show a heightened showing of need. So here's Aaron Burr, sir. As I understand it, this is a historical drawing that I was able to find. So Justice Roberts, writing for the majority here, says, since the earliest days of the Republic, presidents have uniformly testified or produced documents in criminal proceedings when called upon by federal courts. So if a federal court asks you to testify or provide documents, that's totally fine. For instance, Chief Justice John Marshall, enforced a subpoena against Thomas Jefferson during the treason trial of Aaron Burr. And I know you've spoken about that case in other circumstances before. At common law, the king did not have to comply with the subpoena because the king could do no wrong, but it turns out we don't have a king. We have a president, and the president is of the people and thus subject to the law. So, according to the majority, it also doesn't matter that this was a state subpoena rather than a federal subpoena. States aren't allowed to interfere with the functioning of the presidency, but merely issuing a subpoena standing alone is not an imposition upon the presidency of a constitutional magnitude. So the court leaves open the door for presidents to argue that a subpoena is unduly burdensome as applied in a particular case. So if the president wants to argue that some rogue state prosecutor is trying to harass them or impede the functioning of the federal government by bombarding them with constant invasive subpoenas, they can make that argument on a case-by-case basis, and the president has a right to raise that argument in a federal forum in front of federal courts. They don't have to just do it in front of state courts. Those are the protections a president has, but there are no other additional protections. They reject the suggestion from the U.S. Solicitor General that the evidence must be critical for specific charging decisions and that the subpoena must be a last resort. The court also discusses some additional protections for official government documents having to do with secrecy and things like that. Those don't apply to the president's private papers, and the existing protections that I've already discussed, according to the majority, are sufficient to protect the presidency, the executive branch, and the federal government against abusive subpoenas by state courts. So if your case calls for it, you are free to subpoena the president if you want.
All right, we have just a couple of minutes left, and I don't want to intrude on Sandy's presentation since we took a little bit longer lunch break than we counted on, so I guess we'll end there. Thank you. Take a break before Sandy's presentation.
Thanks, guys. Let's take time. Let's come back to 1:30 and we'll finish up with Sandy at Rule 16. To announce the new SWAT board member, everyone got a respectable number of votes, but Angela Adams from Washington County prevailed. So Angela, if you're listening, congratulations, and Jeff Buman and Ryan Robinson will reach out to you here pretty quickly. We are wrapping up to the spring conference with Sandy Johnson talking to us about Rule 16. It'll be awesome. Sandy.
Thanks, Bob. I'm a little disappointed I didn't get you to read a paragraph about how amazing I am.
Sandy Johnson graduated from the University of Utah Law School.
Keep going, keep going.
Well, I don't know anymore. Let's see.
Other than this is going to be an excellent presentation.
That's right.
All right.
That's right.
So my name is Sandy Johnson. I am a deputy county attorney for the Utah County Attorney's Office. Talking about Rule 16. So to start off with, we're going to go on a walk down history lane. This gentleman, and if Lance Sebastian is out there, anybody who knows Lance Sebastian, I could have put up a different picture and done a who does this person look like, but that's a skill he has that I do not. So this is Senator Todd Weiler, and in 2017, Senator Todd Weiler introduced Senate Joint Resolution number 7, which would amend the rules of criminal procedure to punish prosecutors for discovery violations. Now, like most legislation, you're probably wondering what many, many things had happened that would have caused this legislation to be necessary. Well, what he said is there is a need in the state to focus on this duty of prosecutors to disclose evidence favorable to the defendant in a timely manner. I see a raise of hands here of everybody objecting to this proposition from prosecutors, right? Like, what? We have a duty to disclose things in a timely manner? And Senator Todd Weiler cited exactly 0 evidence as to why we needed this rule of criminal procedure changed. So what happened is he then went on and talked about how, because of this rampant problem that didn't exist, for anyone to argue that we should give bad prosecutors the opportunity to go an entire year and potentially get away with knowing and willfully withholding evidence favorable to a defendant, that's a problem, he said, without any evidence. So, because we had this Senate Joint Resolution, in comes SWAP, who said, whoa, can we just slow down here a little bit? Look, I think a better idea would be to let's go to the rules of criminal procedure and let's get this changed there instead of with joint resolution. So with that agreement, they circled Senate Joint Resolution 7. And everybody in here is thinking, whew, thank goodness, right? So there is, in fact, a committee on the rules of criminal procedure. And in fact, prosecutors are on it. This is a list of the people who are currently on the rules of criminal procedure. Now, when any of you read changes in rules of evidence and rules of criminal procedure and think, what are those people thinking? By all means, please come join these committees, okay? Because this is where you make the difference. Instead of just reading about it afterwards, get on the forefront. So in this case, 2 prosecutors specifically, Jeff Gray and Ryan Stack, the rest of the attorneys, or Blake Hills as well, was prosecutors. So they went through, and in July 22nd of 2020, they published a proposed rule. And it goes out, for those of you who don't have your email updated on the Utah State Bar website, get that updated so you can get the emails. It goes out for public comment. And in this case, I have to say, well, generally, I'm very proud to be a prosecutor. But when this came out, we were amazing, all right? We got 31 comments. Now, most of the time when the rules get put out for comment, you'll get 4, 5 maybe. 31 different comments came in specifically from prosecutors about why what the committee was proposing was not such a good idea. And I've just listed the people who put in those comments from all over the state. Washington County, Uintah County, everywhere these comments came in. And I'm going to quote what Davis County submitted. They said, "We believe that we are at the forefront in the state of Utah for providing discovery in the most ethical, fair, and complete manner possible. It is in this light that we provide the following feedback on the proposed changes to Rule 16. not as an attempt to avoid complying with our obligation to provide full and meaningful discovery, but instead to demonstrate the difficulty and in some cases impossibility of complying with the proposed rule changes. In our view, many of the proposed changes make it impossible for even the best intentioned prosecutors to fully comply with the proposed rule as currently written. That was an awesome introductory paragraph, right? We didn't come out and say, you guys are dumb. We didn't come out and say, this is a terrible, terrible idea. We said, look, your idea is good, and one that we as prosecutors all agree on. We want to be ethical. We want to provide everything in compliance with Rule 16, but what you're proposing is impossible in many instances. And then as prosecutors, we cited actual things like rules and case law, instead of just our feelings or pounding the pulpit, right? It was fantastic. So after getting all these comments, the Rules Committee said, well, that didn't work so well. Let's take all these comments and let's go back and let's see if we can tweak everything a little bit. So they went back, and just as a premise as to what the proposed rule of Rule 16, what the goal is, this is a quote from the committee chair. Because a lot of the comments came back and said, hey, that's not what the case law says that we're obligated to do. Hey, that's not what the Constitution says we're obligated to do. But what the committee chair noted is, he said, look, we're not trying to limit Rule 16 based on interpreting constitutional provisions. The court rules can and often do impose burdens or limitations on the government, and I would add, and defense attorneys, above and beyond those required by the Constitution. The proposed changes are an attempt to secure simplicity in procedure, fairness in administration, and the elimination of unnecessary expense and delay. Now, these new rules that we went back and put together were posted on January 20th. There was very few comments. I think there was 2 or 3 that came. They weren't anything of substance. And in fact, there were a few comments thanking the committee, which is always a good idea to make sure you thank people for doing what you asked them to do. The comment period closed on March 6th, and they had a meeting on March 16th to discuss the proposed changes. So the new Rule 16 that I'm going to tell you about has not been passed yet. The old Rule 16 is still in effect. We're in this limbo period where it got sent out for comment, everything came back, the Utah Supreme Court looked at the changes that were made after all of the prosecutors' comments and said those all seem like a pretty good idea. And so now we're just waiting for the Supreme Court to approve them. So still under old Rule 16, but going to talk about what the new Rule 16 is going to do once the Supreme Court approves them. All right, so under the current rule, the focus was on discovery had to be requested by defense counsel. And it basically set a minimum that was based on the Constitution. Under the new proposed rule, there are going to be 4 categories of discovery. There's going to be mandatory disclosures, disclosures upon request, good cause disclosures, and trial disclosures. And remember, going back to the committee chairperson's focus of, we're not trying to set the bare minimum, we're trying to go above and beyond that. All right, so let's talk about mandatory disclosures. Mandatory disclosures are the very first category. And I've put up here in red where the language is going to be changing. So everything in black is what the old rule said. So under the old rule, it was material or information of which the prosecutor had knowledge. So they decided, as lawyers, we didn't have enough words there. So we added more words. Now the words say material or information directly related to the case, right? We wanted to narrow. When we're asking for these mandatory disclosures, it can't be just, did you know something? It has to be directly related to the case, of which the prosecutor team has knowledge and control. Now, these are important additions, I believe, in order to narrow down what we are going to be required to disclose as prosecutors. Because again, these are mandatory. Defense counsel does not have to file a discovery request. Once this proposed rule goes into place, we are obligated as prosecutors to just turn this over without a request from defense counsel. So these are the things that we have to turn over that are mandatory disclosures. And again, whatever's in red is something new. So written or recorded statements of the defendant and any co-defendants and any substance of unrecorded oral statements. reports and results of any physical or mental examination, any identification procedure, and any scientific tests or experiments. Physical and electronic evidence, right? Going back to John's earlier thing about electronic age, everything is electronic, it's no longer just physical. You know, it's now we're talking about electronic evidence, including warrants, warrant affidavits, and then also books. I've been fascinated. In 20 years being a prosecutor, I've never actually turned over a book in discovery, but turned over journals, but never a book. Right? Papers, photographs, digital media recordings, written or recorded statements of witnesses, reports prepared by law enforcement officials, and any notes that are not incorporated into that report, right? That comes directly from case law. And evidence that must be disclosed under the United States and Utah Constitution. So I'm going to talk about a couple of these things in the mandatory disclosures. First of all, the prosecutor team, right? What is the prosecutor team? The prosecutor team is any member or group involved in the prosecution or the same investigation of the case or the defendant. And specifically, it is the prosecutor, the prosecutor's staff, or police officers or investigators. Now this, we all know, has never changed. I mean, I've only been doing this for 20 years. I would imagine those who've been doing it longer than I have will say, this is an ongoing battle that has never ended and will never end, which is, how do you get all the stuff that law enforcement has to your files, right? And we are always surprised, and you're getting ready for trial, and you go and you meet with the detective, and you sit down, and suddenly they pull out a CD you've never seen before, or a witness statement you've never seen before. And a lot of times, I believe this comes from just not understanding technology. Right? Law enforcement, I think they believe there's this magical thing that happens that as soon as they upload their report after their sergeants reviewed it, that it just flies over into our files and arrives there and announces itself to the prosecutors, and then the prosecutors know to then send it over to defense counsel. But unfortunately, none of that happens, right? They approve it, it gets uploaded into Spillman or whatever, Versadex, whatever program that your officers use. And then it doesn't get sent over until a records person in the records department actually makes the effort to send it over. And then depending on how your agency is set up, who gets that or who doesn't get that, right? It's an ongoing problem. But it's one that we have the obligation to try to fix, that we have the obligation to know. Because you don't get to say, oh, wait a minute, I didn't know that you knew that. Because law enforcement isn't obligated. We, as the prosecutors, have this obligation. We, as the prosecutors, are in charge of this prosecution team. So the courts have specifically said the prosecutor's good faith should not have any impact on the trial court's determination of whether the prosecutor had violated his discovery duties. Right? Same, this hasn't changed, right? None of this has changed. Information known to any part of the prosecution team is charged to the prosecutor, and the prosecutor's good faith ignorance does not excuse non-disclosure. So, again, whatever you can do as prosecutors to put into place, to go out and train your officers, to get procedures and processes in place to get whatever they have and provide it to us. I mean, witness statements, I think, are one of the biggest issues of witness statements. Because for whatever reason, they get uploaded differently into the Spillman program or into Versadex, and then when the records person is sending them over, they don't get sent over, and so you don't know. We need to be reviewing our files. We need to be talking with our law enforcement officers, because we are now obligated to send that over. As soon as a police officer gets that witness statement, it is now a mandatory disclosure on our part, or will be once the Utah Supreme Court passes this rule. All right, knowledge and control. That's another thing that was limited, right? It has to be within the prosecutor's team has knowledge and control. So first of all, we go back to what has always been in existence, which is Pliego, right? State v. Pliego, State v. Knight. Those are going to be some pretty big cases for you as prosecutors. We cannot be expected to disclose materials that we, as the prosecutor team, not just the prosecutor team does not know exist. And we are still not required to turn over every stone or exhaustively pursue every angle, searching for exculpatory evidence or other evidence that may be helpful to the defendant's preparation of his case. It's the same obligation as before. And the control part, though, is also the part, because defense attorneys like to throw around the word government, right? Because they don't like to acknowledge that, like, we're cities, and we're counties, like if they say the word government, then somehow we have the NSA available to us to just go find all the things in all the places everywhere. Okay? But we are not. So this control part becomes important. So in State v. Pliego, that was where the defendant was trying to get the prosecution to turn over DCFS records and records from RTEC. Well, as the prosecutor, you don't have any more control over those records than the defense attorney does. Those are protected records. Those are privileged records. Those are records of the victim. There's many other things. And so if you don't have control over those records, you are not obligated to turn those over under the mandatory disclosures. You are only required to turn over what you have knowledge of and control over. And again, the quote that I think as prosecutors we have all quoted multiple times when defense counsel send us their 5-page template of all the things that they want, right? Which is, we do not have to take on that Herculean effort that you want us to do to go find all the things that you're hoping might turn up something that might possibly make your client not look like the guilty person that he is, right? All right, so mandatory disclosures. Under those, everything is pretty self-explanatory. The last thing, though, is where there's the catch-all, right? It's the Brady, and I've heard it now pronounced Giglio, I being from not where other people are from, pronounce it Giglio. But whether it's Giglio or Giglio, voir dire, voir dire, we could all have our differences here, but the Brady Giglio provision is our last provision here. So it's talking about material evidence. I want to caution you. Material evidence and whether or not evidence is material has a different definition depending on the context that the Court of Appeals is looking at it. So when you're looking at case law and defense counsel is citing case law, find out what case that look at the facts of that case, because if it's material in the context of discovery, there's a different definition for material evidence if it's a motion for a new trial. There's a different definition if it's for ineffective assistance of counsel. There's a different definition in when something's material for post-conviction relief filings. It's a different standard if it's a due process violation versus a Rule 16 violation. So whenever you get anything and they talk about evidence being material, it has a different meaning in different contexts. So what we're going to talk about is in the discovery context, what Rule 16 actually means. So material evidence in the context of Rule 16, I put this quote up. I don't like to put up long quotes, but Justice Marshall and Brennan, they wrote a dissent in United States v. Bagley, and I think it really sums up what we face on a daily basis. So the justices said, the dual role that a prosecutor must play and the very real pressures that role create have not changed. The prosecutor surely greets the moment at which he must turn over Brady material with little enthusiasm. In perusing his files, he must take the often difficult decision as to whether evidence is favorable and must decide on which side to err when faced with doubt. In his role as an advocate, the answers are clear. In his role as representative of the state, the answer should be equally clear and often to the contrary. Evidence that is of doubtful worth in the eyes of the prosecutor could be of inestimable value to the defense and might make the difference to the trier of fact, right? Ultimately, our job is interest of justice. Our job is truth. But it really does become that difficult. And I would say it's not necessarily difficult about turning over the evidence. It's that we know we're going to turn it over, and we have no problem turning it over. It's just that we know the second we turn it over, defense counsel is going to accuse us of being unethical. They're going to accuse us of giving them something at the very last minute. They can't possibly prepare a 3-sentence witness statement for trial in a week, that they're going to need a continuance. Like that, I think, really becomes where our hesitation is. It's not, should we turn it over? It is, crap, this is going to get me a continuance now. This is going to get me a motion now. Because I think Justice Brennan and Marshall are correct, is that it's equally clear to us as prosecutors we should be turning this over. And at the end, Justices Marshall and Brennan said, it's easy and it's straightforward, a prosecutor's duty. You must divulge all evidence that reasonably appears favorable to the defendant, erring on the side of disclosure. So what is the definition of material evidence? It's anything that's exculpatory, it's anything that's impeaching, and it's anything that has it's reasonably probable that disclosure would affect the outcome of the criminal proceeding. That last definition is really, really tight, right? We can all interpret that. There's only one meaning for that. Okay. So when you're talking about what will affect the trial, not necessarily impeachment. Impeachment, I think, is easy, right? Inconsistent statements, things like that. That's pretty easy impeachment, convictions. When the reliability of a given witness may well be determinative of guilt or innocence, non-disclosure of evidence affecting credibility falls within the general rule of Brady. So when it comes down to credibility, if there's anything that affects credibility, it falls under that catch-all provision. And again, you don't have to go out and search for exculpatory evidence. So those are the mandatory disclosures, right? Brady and Giglio materials, the list that's pretty self-explanatory on the list, but those mandatory disclosures are limited to the prosecutor team that's related specifically to that case over which you have knowledge and control. So now we're going to move to the hard parts. Disclosures upon request. Now, this part, I apologize to everybody out there who is a city prosecutor, who represents an agency, or who knows anything about the dreaded word grandma. Because what I'm about to say is probably going to butcher everything involving grandma and is going to make you cringe. Because I'm a prosecutor and I hate that stuff. That's why I call you. But I'm going to try to do my best to give a summary to all the prosecutors out there that disclosures upon request, this category is specifically grandma. So, for the disclosures upon request, the record must be in a mandatory disclosure list, right? So the defense counsel doesn't get up and say, I request this, and I want you to go out and get something from 7-Eleven. All right, not going to, because it's not in the mandatory disclosure list. The mandatory disclosure list is, all of the stuff. The record must be possessed by another governmental agency. Again, 7-Eleven, not a governmental agency. The record must be one that can be shared with the prosecutor under grandma. The defendant's request must identify with particularity the record they are seeking. The defendant's request must identify with particularity the agency that has the record. And the defendant must demonstrate that the information in the record is directly related to the case. Now, I underlined with particularity because that's a word I like to throw around, right? It's found in Rule 12 when it comes down to motions. It's one of my pet peeves, right? Identifying the Constitution is not identifying anything with particularity. Identifying the Fourth Amendment is not anything with particularity. If it took me an entire semester of law school to learn that I don't know anything about the Fourth Amendment, then that is not identifying anything with particularity. And in fact, I looked it up online to find out what the definition of particularity is. I did not use Urban Dictionary because in my line of work, you don't Google anything on Urban Dictionary from your work. Apparently, John has a much more liberal firewall than anywhere else, right? And yes, to all prosecutors, be cautious when Googling anything on Urban Dictionary. All right, so particularity means small details, minuteness of detail in the treatment of something. So what this really comes down to is you don't get to go fishing with this request. You don't get to come in and say, I request anything in any governmental agency's files that might help my client. Nope. Okay, with particularity. Now, what a judge will define as what particularity means is always the hurdle that you have to get to, but as prosecutors, you can always respond, that's not with particularity. All right, so I want to talk about, again, record must be in the mandatory disclosure list. Going back, what the disclosure list is, it's got to be, statements of the defendant or co-defendants, records of results of physical examinations and testing, reports prepared by law enforcement officers. So these are the most common records that, in my experience, we've been requested to get, right? Utah Office for Victims of Crime, UOVC, restitution, okay, DCFS, other law enforcement agency reports. I know I want West Valley's police report, even though this case was investigated by the sheriff. Okay, the Bureau of Forensic Services, right? Your tool marks, drug testing, DNA testing, all of those. Utah Public Health Laboratory, your toxicology, the medical examiner reports. Now, if you look at those lists, in DCFS, is it going to have written or recorded statements of the defendant, right? So before you go anywhere, when defense counsel's asking you for a record under this disclosure, you have to ask yourself, is what they're asking for, does it contain what's in that list? If it's, I want a statement of the victim, okay, well, that would be a written or recorded statement of a witness. Okay, so they've met the first hurdle. If it's, I want the victim's mental health records, all right, is that a result of any physical or mental examination? Arguable, right? But they've got to tie it back. It has to be on this list. My favorite, and the one I kept fighting with the committee about, was search warrants and affidavits, right? As a prosecutor, I don't have any more access to search warrants and affidavits than the defense attorney does, because those are maintained by the courts, right? It's filed with UCGIS. It's uploaded to UCGIS. If I want to get a copy, I have to go to the court and ask for it. But what Rule 16 will be saying now is, hey, prosecutor, mandatory disclosure, you go get it from the courts if you didn't already get it from your law enforcement. Okay, so there are 4 categories of records. This is, again, I apologize to all the grandma experts out there. Public records, which are search warrants, arrest warrants. Private records is a category. This includes body-worn cameras, recordings, prosecutor and law enforcement personal information, sex offender registry documents. Protected records is the most often requested category, most likely. It includes, again, DOPL records, UOVC records, records maintained and created for criminal purposes. And then you've got controlled records, which are medical, psychiatric, psychological data. So what happens is defense counsel would always come in and say, hey, prosecutor, you're government, you go get these records. They're in another government's possession. You go get these. All right, so let's talk about what's called the sharing provision. The sharing provision is under 63G2, 206. A governmental entity may, notice I underlined the word may. Okay? As prosecutors, we don't get to tell anybody what to do. If you are representing an agency as the civil attorney who does your grammar requests, you in fact may get to tell your agency what to do. But as prosecutors, in that capacity, we don't get to tell an agency that we do not control what to do. So they may provide a record that is private, controlled, or protected to another governmental entity that enforces, litigates, or investigates criminal law proceedings, or one that collects information for pre-sentence reports, probationary, or parole purposes. So essentially prosecutors and APMP. So in order to get that, by rule, under the sharing provision, you have to make a written request. It can't just be calling somebody up and say, hey, can you send me over those crime lab reports? No, they have to have it as a written request. And a subpoena or a other method of discovery is not considered a written request for purposes of grandma. So you can send them a subpoena all you want, and they're going to respond back and say, send me a grandma request. Okay, so send them a grandma request. Now, as the prosecutor, defense counsel is going to file a motion under this request for disclosure. They're going to say, Sandy, I want the full file from this toxicology report, because despite the fact that it shows that my client had methamphetamine and alcohol in her blood, I think there was an error with the testing, and if you send me the whole thing, I'm going to look at it, not understand anything, but I can go tell my client that there's a possibility that somewhere in all those records there's an error, okay? And you are going to want to turn around and say, oh yeah, let me just call up the crime lab. Hey, we just sent me your full file. Oh, no, you cannot do that, okay? But your first response is, when defense counsel asks for that request, you have 3 options, okay? The first option is, you say no. You can just say, I'm not going to request it, and you list the reason why, right? Look, what you're requesting isn't related to this case. Okay, that's a blood test that was done on another case. It's a blood test that was done 3 months prior to this case that we're talking about, so I don't care about it. It's not related to this case. That you can say they didn't identify with particularity. They just said any blood test taken anywhere and tested at any place. You can say, nope, that's not sufficient. I'm not going to respond to that. You can say, look, I'm prohibited from getting it and giving it to you. So no, I'm not going to go request it on your behalf with a grandma request. Or you can actually request it. Now, if you request it, the agency can still refuse to give it to you. And let me give you an example of when they would do that. Because as prosecutors, sometimes we get a little lazy. And we don't exactly redact things that we're supposed to redact. So we request, for example, we want records from the Utah Office for Victims of Crime because our victims are requesting restitution for mental health treatment. So we request the records from the Utah Office of Victims of Crime, and then we get it. And then what do? We're like, oh, we should just turn it over. So we turn it over to defense counsel. And sometimes we miss redacting, and sometimes we don't redact the personal identifying information. Sometimes we don't redact the actual mental health records of our victim before we turn it over. And because the Utah Office for Victims of Crime, as their name would show, is dedicated to victims, they don't care about our convenience, right? They care about protecting victims' privacy. And they have been burned too many times where a prosecutor has just gotten the file and just turned it over to defense counsel. And then defense counsel just turns it over to the defendant. You could imagine why a rape victim might not want their perpetrator to have their personal identifying information or their mental health records or other things like that about how they're being treated and who's treating them. So UOVC can say, no, I will only provide this in a redacted form, or I will only provide this with an order from the judge saying that you can't give it to the defendant. They can put those restrictions on it. Or they can just flat out say, no, we're not going to provide it, right? If they have the reasons under grandma to not provide it. So what your actions as the prosecutor, right? You have to decide, what are you going to do? Are you going to not request it? You're going to say it wasn't enough? Are you going to say, look, I can't by law? You're going to say, hey, they won't give it to me. Or are you going to go get it? So the prosecutor, if you decide you're not going to request it, or if you decide that you're prohibited by law, you have to file a notice back telling the defense attorney why you're not going to. And at that point, the defense themselves can seek a subpoena, or they can go to the court and file a motion. Or if you receive the record, you can then disseminate it in accordance with grandma. So again, going back to the sharing provision, right? Any governmental agency can share it with another governmental agency if they so choose. But under that sharing provision, any document, any record that we get, we are subject to the same restrictions as the person who originally had it. So if UOVC can't give it to defense counsel unredacted, neither can you if you got it under the sharing provision. Same goes for crime lab reports, same go for SANE exams. Okay, anything that you got under the sharing provision, if they couldn't give it to the defense, neither can you. That's a grandma violation. Okay? And you have to be careful about this. So for example, crime lab reports, the first 3 pages, and I say 3 because that's usually what I get them in, where it just lists, say, the person's either DNA results or it'll list the blood alcohol level, right? So just the basic, this is what the person's blood tested at. Those are considered the police agency's record, so the police agency can, that's why they can share it with you and you can share it with defense counsel. But anything else that might be in there, again, it might contain protected records. It might also contain private records. So again, I want you to think about, for those who do sexual assault cases, victim goes and gets a Code R exam done. There's a medical health professional there who takes a record and makes a record and a report. And then they include that in the same kit, in the Code R kit that goes up to the crime lab. The crime lab then takes that report. It guides them on which samples they're in fact going to test. They then test those samples. So contained within the records of the crime lab who was doing the DNA testing, you actually have The protected records, which is just the outcome, which can be shared with law enforcement. You also have a protected medical record that is the victim's medical record. So they can't disclose a private protected medical record. They can't provide that to you, and you can't provide that to defense. So you have to be careful about what you're asking for, right? So I bet you any of you have tried this, have been met with success, right? Hey, judge, look, the agency said that they didn't want to turn it over. And you got the response where the judge said, but I ordered this turned over. And you're like, I know, but there be rules, right? And so what you say, hey, judge, look, under grandma, including with the sharing provision, the records are privileged from discovery. So no matter how many times you sign that discovery order, it doesn't trump grandma. Because grandma specifically says these records are privileged from discovery. It also says that you can't disclose it until you, judge, make some findings. And again, sometimes it's a little hard to get a judge to make a finding, right? They wish that they could make those findings, but they just don't want to. So before a judge can order this to be released, so even if you have it, right? I went to the crime lab. They were great. They turned everything over to me, judge. So now I have it. But guess what? I still can't give it to defense counsel until you make some findings of what I can turn over. So the court has to sign an order. And the court has to have reviewed, first of all, the court has to make a determination they have jurisdiction. The court has to have considered the merits of the request to access that record. The court has to consider and, where appropriate, limit their use of the further disclosure of that record. And the court has to find that the interests favoring access are greater than or equal to the interests favoring restriction. So again, this comes down to the judge is going to have to make some findings. So even if you go out and get it under your grandma request, and even if the agency shares it with you under the sharing provision, you can't then just go around and turn it over to defense counsel. You have to go back to the court. You have to get the court to make an order. You have to have the court consider that disclosing this unredacted, right? If you want anything other than what the agency provided to you, you have to go get additional findings from the judge before you can disclose it further. So what this means is, if you're going to go ask for something from an agency and you know you're going to be turning it over to defense under grandma, I would be asking them and telling them specifically, I'm requesting this on behalf of defense counsel. Please only provide to me what you would disclose to them if they provided you a grandma request. Because I don't want to go through all this. This is a pain in the butt. This requires me to do another hearing. This requires me to get a judge to make findings. This requires me to listen to defense counsel talk about how I'm trying to hide stuff. Okay, and I don't want to do that because it exhausts me. So I'm going to ask the agency and say, just turn over what you would give defense. Right? But a few additional thoughts. We've already talked about that. If a lot of times these records are coming from an agency that is represented by an attorney. Okay, UOVC has an attorney. The crime lab, they have an attorney general who represents the crime lab. DCFS, they have attorney generals that represent DCFS. If you're going to have the judge order DCFS to do something, you need to make sure that their attorney is notified about that hearing, because you don't represent DCFS, you don't represent the crime lab, you don't get to speak on behalf of them, so make sure that their attorney's been notified. And there may be additional rules to grandma, right? Just because I get medical records, for example, doesn't mean I get to turn them over, because I also have Rule 14, which says if it governs anything involving a subpoena or a court order, which would be a discovery order, right? A court order for medical, mental health, school, or other privileged records of a victim. So just because I can go get those doesn't mean Rule 14 doesn't apply. It means, okay, I have them, but now we still have to go through a Rule 14 in-camera review and have the judge make all those findings. Okay, so that is the disclosures upon request. Again, it all has to do with grandma. Okay, we'll talk about good cause disclosures. Good cause disclosures it's the same language as before. This hasn't changed. So just a couple of highlights for this. We believe that Rule 16 should be liberally interpreted within the confines of the requirement's purpose. In other words, good cause should be liberally interpreted. It does require a preliminary showing that the evidence is necessary to properly present things at trial. And this right here is just my baseline. I always file a motion for state's discovery, and I list this because this was out of State v. Spry. This is exactly what the prosecution sought in that. And the court in State v. Spry specifically said all of the state's requested disclosures were material as they involved information on witnesses and documents which the defendant intended to use at trial. So if you stick with this on your state's disclosure, great. If you want anything more than this, then you need to make sure you make a preliminary showing about why you need it. And I find that using and listening to defense counsel is always good practice. Because whatever they say about why they need something from me, I'm going to write that down. So later when I ask for it from them, I'm like, Judge, remember how they said it's necessary? Yeah, it is. I agree. Okay? But if you're going to object to defense counsel, you better make sure you're not going to then turn around and ask for it either. Okay? So just think about what it is for a good cause. All right, trial disclosures. Trial disclosures now are what's required. This is our fourth category, trial disclosures. A written list of the names and current contact information of all persons that you intend to call at trial. Any exhibits that you intend to introduce at trial. Upon order of the court. Now this was a big one that we also fought about because the committee originally wanted us to turn over criminal histories. Well, under the statute, we can't, right? It has to be by a court order. So upon order of the court, we turn over criminal records of any persons that we intend to call at trial. These are just the rules that talk about why we can't just turn them over just because we have access to them. We have to have a court order. The only sort of exception to that is the defendant's criminal history, but even the defendant's criminal history under the statute has to be done only upon request. So this will get a little bit tricky if defense counsel stops just filing their boilerplate request for discovery. Before you send over the defendant's criminal history, you might just need to send a quick email that says, hey, do you want this? And they'll say, yes, I request it. And you say, okay, great, thanks. Now I can send it. All right, information not subject to disclosure. This is attorney work products, essentially. This hasn't changed. The only thing that they just noted was that the exception under Rule 25b-5 of the Rules of Civil Procedure does not apply in criminal cases. So they clarified you don't get to take Rule 26 from the civil procedure. All right, timing. When are we required to make these? As the prosecutor on the mandatory, as soon as we know about it. As soon as we can after we file charges. And as long as we've got it before the preliminary hearing, before the defendant enters a guilty plea, or before trial, unless they waive that. And this was a big thing, especially in justice courts, right, where a lot of times defendants come in and they're entering pleas without even getting copies of the police report. That's where you just need to make sure that they waive. Hey, I've got the police report. Do you want it? If you don't want it, I just need you to waive the fact that I'm not providing it to you before you enter your plea. All right, upon request, the whole grandma stuff, there's no timing. For good cause, again, no timing specified. And the trial disclosures have to be made no later than 14 days prior to trial or as soon as practicable. And just as a practice pointer, again, as prosecutors, I encourage you to ask for deadlines, right? Deadlines are always prosecutors' friends a lot more than they are our enemy. Because again, hey judge, I want trial disclosures. I'm asking that all trial disclosures be ordered 30 days prior to trial. This 14 days stuff is scrapped, right? Like, I'd like it more than two weeks. And I am willing to take that on, and I want you to order defense counsel to do the same thing. Because I want their witness list 30 days ahead of time, not 14 days. And in terms of prosecutors' disclosures of timing, anything that deals with factual innocence, you always have the constitutional obligation to disclose that before plea bargaining. That's just easy. When in doubt, disclose that you're not going to disclose. So for example, if unfortunately, like if victim's mom came in and brings me all of her daughter's mental health records, and she's like, here, Sandy, I want you to have all my daughter's mental health records. And I'm like, oh crap, right? Usually they give them to the officer, and the officer's like, here, Sandy. I'm like, okay, now it's in the possession of the prosecution team. I just file a discovery response, and I say, look, I got them, and I ain't gonna give them. And if you want them, file a motion, right? Because then it's just clear. I'm not trying to hide anything. I've disclosed I have them. I've disclosed that by law I don't have to turn them over. And if you want to argue about it, let's do it in front of a judge. All right, defense disclosures. There actually is a specific section in the upcoming proposed rule about defense disclosures. Mandatory. They're mandatory disclosures. Alibi, right? Alibi is in statute, and it's 10 days before trial, which, again, whoever wrote this statute just drives me crazy. Really? 10 days before trial, suddenly you're providing me an alibi? Unless otherwise ordered. So again, going back to his prosecutors, ask the judge for deadlines. The judge can literally tell the defendant, you have to disclose any alibi witnesses 30 days ahead of trial. Okay? Again, the statute is the baseline. It is the bare minimum that they have to provide, which is 14 days before trial, or 10 days before trial. So ask for that sooner. Failure for them to comply with that means you can exclude their witnesses, but you can never exclude the defendant from taking the stand and providing his own alibi. The timing just won't apply to him. Insanity disclosures, again, this is a ridiculous timing period, but it's following the statute, which is no less than 30 days before trial. Because insanity, as we all know, you can get the defendant examined for insanity and an expert ready to come testify, and all of that done in less than 30 days. All right, good cause. Same exact language. Defense counsel, for their disclosures, they have mandatory disclosures. They don't have discovery upon requests, but they do have good cause disclosures. Any item of evidence which the court determines on good cause should be made available to the prosecutor in order for the prosecutor to adequately prepare the prosecutor's case for trial. It is the same as the prosecutor's good cause standard. That's right, I said it. It's the exact same good cause standard for the prosecution as it is for the defense. Right? And the Utah court has specifically said the good standard of good cause required of one is the standard of good cause required of the other. So when defense counsel gets up and says, Judge, I need to know all of their witnesses and what they're going to say, because that's the only way I can adequately prepare for trial. All right, Judge, I want a list of all of their witnesses and what all their witnesses are going to say, because that's what I need to adequately prepare for trial. And when they say, work product and all that other crap, then you quote this and says, Judge, good cause is good cause. Again, we don't have separate rule books. Okay, they also have the same exact thing on their trial disclosures, right? A written list of the names and contact information, any exhibits they intend to introduce, no later than 14 days prior to trial or as soon as practicable. They also have the same what's not disclosed, what shouldn't be disclosed exception under Rule 26. So this is where I'm going to just do a little quick caveat. All right, information not subject to disclosure. We need to be very careful about what words we use, because attorney-client privilege is not the same thing as work products. They have different standards, they have different things of what we can get. You need to be really clear, because everybody comes in and talks about the work product privilege. And then they say it's the attorney-client work product privilege. I'm like, well, that's like 3 different things you just said all in one sentence. All right, let's parse this out. What is this actually? So attorney-client privilege comes, these are really small, comes from the rules of evidence, right? Privilege comes from rule of evidence. Work product comes from the rules of civil procedure. Under the attorney-client privilege, it has to be a communication, and it has to be between the client, i.e. the defendant, and the defense attorney. Those are the only 2 people that can participate in anything that is covered by the attorney-client privilege. Under the work product privilege, it can be anything. It can be documents, it can be tangible things, and it has to be prepared in anticipation of litigation. And there's 2 different types of work product. There's core work product, which is the defendant's attorney's legal theories, opinions, and things like that. That has basically absolute protection. Like, we're never going to get that. They don't ever have to turn that over. But factual work product can be waived. Now, not every communication between an attorney and a client falls within the attorney-client privilege, and this is where I want to emphasize the difference, because the attorney-client privilege, which is a privilege from the rules of evidence, does not include information that an attorney secures from a witness while acting as an attorney in anticipation of litigation. Okay, that comes from the United States Supreme Court. So when they go out and they interview all the witnesses that they're going to call, whatever they talk to that witness about is not covered by the attorney-client privilege. It's covered by the work product privilege, but not the attorney-client privilege. And there is a much lower bar for the attorney-client privilege, for the work product privilege. So when they ask you for notes and things about interviews with witnesses, keep in mind, complying with the court order disclosing factual information. So your witness said, this is what happened. That does not constitute a waiver about your thoughts. So if you're taking notes, or your law enforcement officer is taking notes, or whoever it is that's taking notes, if they are interspersing, hey, this is what happened, and boy, I think this might be a really good trial strategy. I should really focus on this. Okay, you don't have to disclose the second one, but you might have to disclose the first one, even if they're in the same piece of paper. In this case, and I love this case, especially as a prosecutor, and I know this was John's case, I believe, because he sent around a bunch of sample memos. State v. Steffen, right, from last year, John? Right, the district court found that the state had shown good cause for Steffen to disclose investigator reports, investigator notes, and investigator recordings from witness interviews with both the state and defense witnesses. So all the time, defense counsel will say, well, no, because that's work product. That's work product. I don't have to turn that over. Actually, they do, okay? Because, first of all, it's fact work product. It's not opinion core work product. And what the court held was that this would be waived if the defendant intended to use those notes to impeach the witnesses on cross-examination, or if you were going to call those witnesses and place their credibility at issue. As soon as the defense attorney decides they're going to call those witnesses, then whatever facts those witnesses have disclosed, they've essentially waived their work product privilege. What State v. Steffen did say is, with respect to notes from the interviews with defense witnesses, the district court ordered Steffen to disclose only those portions that contained prior witness statements. They didn't have to disclose their core opinions. So when defense counsel again comes in and says, but judge, then they're going to know my thoughts and my opinions. Okay, we'll redact that, but anything that's factual, you have to turn over. And you want to make sure you're narrowly construing it, right? Where Steffen, in the case of State v. Steffen, where the prosecutor and the judge ran into a little bit of problem, was the judge just ordered, well, turn over the notes, and the judge didn't make clear, okay, only turn over the notes that had factual work product as opposed to opinion work product. So just make sure the order says to turn over any factual statements made by witnesses, and that make it clear you're not going after core opinion work products. All right, methods of disclosure. It hasn't changed, right? It's all still going to be the same. You notify, you can either do it by turning it over, or you can tell them they can come inspect it, they can come copy it at specified times and places. This part is new. If the prosecutor, because they just basically wanted to make it clear to the judges. The judges have always been able to do this, but this was added to be really clear. If the prosecutor concludes that that the disclosure is prohibited by law, or that the disclosure would endanger any person or interfere with an ongoing investigation, the prosecutor can file a notice saying, I'm not going to turn it over. This is why I'm withholding it. And if the disclosure by the defense attorney, if they say, but I still want it, then the court has to hold an in-camera review. You don't have to just turn it over to defense counsel to argue about it. It becomes an in-camera review. And the court will then decide whether disclosure is required and what limitations or restrictions that the judge wants to put on it. All right, restrictions for disclosure, again, hasn't changed. You can restrict disclosure based on protecting victims from harassment, from abuse, from the undue invasion of privacy. This is a big one, victim cell phones. This is a huge issue for me. Law enforcement and everybody, they just come in and they just, Cellbrite is only designed that you plug the phone in and you push a button and it just dumps the whole victim's phone. Okay, all we're looking for were the text messages sent between the suspect and the victim for like the 3 days that they met between when they liked each other on Tinder and they met up, right? Like, it's a 3-day window. Why are we downloading the victim's entire cell phone and turning that over to defense counsel? Okay, none of that is relevant to the case. None of that is pertinent to the case. That is an undue invasion of privacy. So in that case, limit what you're disseminating, limit what your disclosure is, because you're protecting the victim's privacy. Restrictions: the court can order that discovery be denied, restricted, deferred. Limitations can be modified, or any other order is appropriate, including you can't give it to your client. Okay, that is actually something that you can order. You can make this showing ex parte. So again, you can go make this showing to the judge and not have the defense attorney there or the defendant there in order for that in-camera review. All right, if you fail to disclose, again, we can't do anything that's unconstitutional, but the court can order or permit discovery. The court can grant a continuance. The court can prohibit you from introducing anything you didn't turn over, or any other order it deems just. And then this is the new one, which goes back to the very beginning of Senator Weiler, which is if after a hearing, the court finds that a party has knowingly and willfully failed to comply with an order of the court compelling disclosure, the non-disclosing party or attorney may be held in contempt of court. Now, I actually had this in one of my cases where the defense attorney stood up and said, "Yeah, Judge, I know you ordered me to turn it over, but I chose not to." Okay, well, that's willingly and knowingly. Now, of course, the judge just excluded the evidence. It didn't hold the attorney in contempt, but. All right, the additional requirements, again, nothing about this has changed. The only thing they did was they added the language upon good cause. So you can't just ask the defendant to go speak for identification unless you got a good reason for it. My favor is I just barely filed a motion a couple of months ago asking the defendant to come get inspected to see if he was circumcised. Judge granted the motion, except for the defendant decided he didn't really want to do that, so he just stipulated. All right, additional requirements. Again, there hasn't been anything really changed. You have to give reasonable notice to the defense attorney. You have to give reasonable notice to the defendant. And if they fail to comply, just like before, you can revoke their pretrial. You can revoke their pretrial release. You could offer that as evidence of, hey, we tried to get this and he refused to do it, or any further sanctions. All right, that's it. Thanks.
Okay, thanks everybody for coming. Thanks to all those that stuck around online. We look forward to next spring when we can fill the room. So go forth and conquer. Thanks. Oh, sorry. One thing I forgot to mention is we'll post Sandy's slides to the webpage probably Monday.